Thank you. Thank you.
Honorable Shri Justice Vipul M. Pancholi.
Thank you.
I'm sorry.
Honorable Shri Justice M. M. Srivastava, Chief Justice, Madras High Court.
Thank you, Aji sir. I'll just stretch forward. Thank you.
Honorable Shri Justice M. Sundar, Chief Justice, High Court of Manipur. Honorable Shri Justice R. Suresh Kumar, High Court of Madras. Honorable Shri Justice A. Mohammad Mustaq, High Court of Kerala. Honorable Shri Justice Sachin Datta, High Court of Delhi. Honorable Shri Justice Harinath Nunnepalli, High Court of Andhra Pradesh. Ms. Nandini Gore, Senior Mediator and Trainer.
Good morning, judges, ladies and gentlemen. As we follow from yesterday's grand inaugural, let's begin the technical session today. For the first session, we'll start with the basics of challenges and the way forward. This session would focus on areas of mediation as a profession, government and mediation, and how to build public trust in mediation. We have a very distinguished panel who need no introduction, but I would be failing in my duty if I do not just briefly introduce them to you. To chair the panel, we have Honorable Justice Suryakant, Judge, Supreme Court of India. Justice Suryakant had chaired the technical session even at the first mediation conference where the whole journey began, and having him chair this first session where we would lay the foundation for the discussions to the rest of the day marks a continuity. He is very passionate about mediation, and we heard him yesterday, and those of us with an interest in mediation, I'm sure, have been following what he has been saying on this subject. He, as the chairman of NALSA, was the brain and backbone of the National Mediation Campaign, and having also served as an Advocate General, being appointed as one of the youngest Advocate Generals in the country, through his vast and varied experience, he brings in ideas which are practical and innovative, and I'm sure the audience and panelists would only be benefited from his wisdom. Co-chairing the panel with him is Honorable Justice Vipin Pancholi, Judge of the Supreme Court, in fact the youngest Judge of the Supreme Court today, a judge with a vast experience across jurisdictions, having served as a judge of the Gujarat High Court and a judge and Chief Justice of the Patna High Court, and now a judge of the Supreme Court. Having a long distinguished career as a lawyer and then a judge at the western state and later towards the opposite side of the country, he brings with him the practical knowledge of the challenges and opportunities of the diversity of India. Having had a brief interaction with him, his passion and vision in this field, coupled with the practical insights, are truly what one needs to hear and be educated about. The other co-chair for today is Honorable Justice M.M. Srivastava, the Chief Justice of the Madras High Court. Currently, though he is the Chief Justice of the Madras High Court, he has previously served as a judge of the Chhattisgarh High Court and later as the Chief Justice of the Rajasthan High Court. He brings with him the knowledge and wisdom of cross-cultural challenges and insights on and having served in multiple jurisdictions and also on the administrative side in at least two high courts. The other panelists here include, in fact, this is a panel which has 3 judges, if I can say, from Tamil Nadu. Apart from the current Chief Justice of the Madras High Court, we have Justice M. Sundar, who presently Chief Justice of the Manipur High Court, who actually hails from Tamil Nadu, and his parent High Court was the Madras High Court. We also have Justice R. Suresh Kumar, a judge of the Madras High Court. And from the neighboring state, we have Justice Mohammad Mustaq, a senior judge of the High Court of Kerala. Along the rest, we have from our very own capital, Justice Sachin Datta, a judge of the High Court of Delhi. And we also have Justice Harinath Nunapalli, a judge of the Andhra Pradesh High Court. Among the judges, we also have a very senior mediator, practitioner, and a trainer in Ms. Nandini Gore. Over to you, Justice Suryakant.
Thank you, George. A very good morning to all the ladies and gentlemen. The formal address I am dispensing with because of the time constraints. Well, I take it that the second National Mediation Conference as a step forward towards the call which we have given for mediation for the nation. As all of you are aware, that campaign has started from 1st of July, and the initial period is for 90 days, and we are every day the kind of response which we are getting, we keep on evaluating it, and then we'll ultimately take a final call. But what has happened so far is quite very encouraging. The perspective of mediation, I will just in 2-3 figures I will highlight, and then we'll go to the question answer issues. 168 crore cases have been identified as mediation friendly so far by all the high courts, of course by their district courts and the trial courts level. 1 crore 68 lakh cases. Out of that, then there is a second process to identify that which case really should go immediately to the mediation. And so far, almost 5,25,000 cases have been referred to mediation out of those cases. Rest are every day in the pipeline, identify, take the consent of the party, then it goes to mediation. Now, in this scenario, we have so far, despite the online training every day going on by the Supreme Court MCPC, which I am looking after, we don't have more than 13,000 trained mediators so far available throughout the country, and see the challenge of the matters to be dealt with. Going by our population of 1.4 billion, and proportionately we require not less than 2,50,000 very well trained mediators in the country. So please see the gap. 13,000 we have, online trainings are going on, but how are we going to achieve this figure of 2.5 lakh? Then, most interesting and very, very encouraging aspect is that in terms of the success rate, 30% is the national success rate in mediation proceedings. 30%, which may be, barring one or two jurisdictions throughout the world, we have the most successful rate so far, and it's quite encouraging. Of course, when we are talking about the structured mediation that we have introduced in the country, we may be that we are the newer in terms of introducing it, though mediation is basically part of our culture, as last we have in every conference we have been telling, and all of us know that. So I need not to highlight that part. So with this 30% encouraging success rate in mediation, 160 crores out of, assuming that even 50% cases eventually land up for mediation, only 13,000 trained hands with available requirement of 2.5 lakh trained mediators, the challenges are definitely there. And when there are challenges, we must meet them. So the first question will be that what are the real, beside this, what are the real challenges that mediation is facing? And I will request my youngest brother, baby of the Supreme Court, my brother Justice Vipul, to very briefly point out something about it.
Good morning, sir, and good morning to all respected dignitaries. Sir, I've hurriedly gone through the provisions of the Mediation Act of 2023. Sir, according to me, the major challenges are with regard to the perception. Sir, ordinary people, the layman, the ordinary citizen, thinks that mediation is a mere compromise or settlement. But in reality, it represents justice in its most human form: collaborative, participatory, and reconciliatory. Sir, second challenge is institutional readiness. While framework has been created, mediation centers must be expanded and strengthened across all levels of the judiciary. Sir, according to me, the third challenge lies in judicial integration. Sir, courts must develop the confidence to refer the matters to mediation at the right stage, ensuring it is not used as a delaying tactic, but as a genuine opportunity for resolution. Sir, at this stage, I would like to refer Section 7 of the Act, which provides for power of the courts or tribunal to refer parties to mediation. Subsection 1 provides that notwithstanding the non-settlement of dispute under subsection 1 of Section 5, the court or tribunal may at any stage of proceedings refer the parties to undertake mediation. So the word used in the provision is at any stage. But according to me, the dispute is to be referred at a right stage. Sir, the fourth challenge is awareness and outreach. Mediation must not remain confined to commercial or corporate disputes. It must reach to the families, labor disputes, consumer grievances, land issues, and even the dispute between with the government. Only when citizens experience the effectiveness of mediation in their everyday conflicts, public trust in the process will deepen. Sir, Section 6 of the Act provides which are the disputes or matters not fit for mediation. The list is given in Schedule 1, first schedule of the Act. So according to me, sir, these are the four main challenges so far as mediation is concerned, sir.
Thank you, brother. Thank you, brother Vipul. for highlighting the main things. The institutional mediation need to be supported, and let mediation go beyond the commercial disputes also, and there are varied fields that can be also occupied by the mediation. And of course mediation, that I think someday we will have a long discussion on it, that is it the mediation and compromise are the same thing. That my personal view is that these may not be the same thing, but that's separately we will discuss someday. But that's a very interesting issue that someday the mediators need to resolve. But when we are talking of expanding the scope of the mediation, as my brother has rightly pointed out, that it can't be confined only to the commercial disputes. The question that would arise, that as I indicated to you, that only 13,000 hands available and need of over 2 lakhs. 2 lakh not required today, but in due course of time we need to have an appropriate mediation bar comprising those trained and dedicated mediators. But the question will arise, and yesterday after the inaugural session, one of our friend, a very senior mediator from Delhi, she pointed out to me in particular, and I appreciate that concern, that about the quality and commitment of the trained mediators. So I will request Justice Srivastava, one of the very learned judges who have vast experience of working as Chief Justice of 2 High Courts, besides as a very senior judge and served a long tenure in the Chhattisgarh High Court. My question will be that how to prepare the mediators, how to ensure that quality and quantity both can gel with and both can match each other.
Thank you, sir, for giving me this opportunity. From ignorance to indifference, rolling into choice, necessity, and now as a preferred mode of mediation, is the story of a mediation system in the first quarter of 21st century. Way back in July 2022, there was a national conference at Jaipur, and one of the main thirst and the concern raised by all speakers was that if you want to have a robust mediation system, ecosystem, we need to have a large pool of mediators. When it was being discussed at that time, Mediation Act was not enacted. If we look into the provisions of the Act and the legislative mandate, what we find is that the Act aims to have a very large pool of mediators, 1. 2, mediators who are skilled and specialized. And then from where from to get it? Is it necessary that only those who have grey hair only should come forward? No. The provision of the Mediation Act, if we look into, aims at having a large pool with youth also participating in the mediation process and having an option to prefer mediation as their career. It cannot be only a part of their career as a lawyer. Can we not think of having mediation as part of alternative dispute resolution mechanism included as part of curricula in all the educational institutions, since the academia is also here before us in this conference? And from that stage itself, because people may have, those who have joined the legal education may have this in mind to have a career option as a mediator. So from that stage they may be prepared, that kind of courses may be offered to them, and once they complete their legal education, soon thereafter, maybe that in every matter involving big stake they may not be involved, but then at least they may be involved as a co-mediator right from the time they are enrolled or otherwise also. So with the main mediator there can be a system of having co-mediators. Now that will help in bringing about at a faster speed a large pool of mediators, and they will be comparatively young. 5 years of law course followed by 3-4 years of the experience as being associated with the mediators or as a co-mediator will bring about 7 to 8 years of experience, and soon thereafter, maybe after 5, 6 years, we may have a very large pool of mediators. That is one. The other thing is that we will have to think about if you want to have the quality mediation, there are two things which are very important. One is that mediation also has to be developed as a specialized subject. I don't think a person who is expert in corporate mediation may be a successful mediator in a family dispute, or one who has the experience of working on the family dispute, property dispute, commercial disputes may necessarily be a good mediator in other jurisdictions. So the need of the hour, if we want to have a quality mediators, we need to have a specialized mediators, and that will therefore require from the very beginning and inception preparation of training and skill building, capacity building in specialized subjects. Then the third part is having a good remuneration system. What mediators are getting these days, perhaps to expect the best of the quality, is unrealistic optimism. In cases of successful mediation, that a successful mediation invariably happens in those cases where the parties have not only reposed full confidence and trust on the mediator, but they, with the help of the mediator, they have arrived at successful mediation. Why can't we have a system where, at least in cases involving specified value being on higher side, to provide something as a remuneration to the mediator in case of successful mediation? It will have two-way impact. One, it will encourage taking mediation practice as one of the career option. Two, it will also have a kind of incentive for the mediators to try their level best to bring about a successful mediation. These are two important aspects which I wanted to share with the House. Thank you.
Thank you, Justice Srivastava. I think it makes a lot of this quite important that we have a community of mediators who are duly accredited, and they adopt the mediation as a career opportunity. And then we have a sustainable ecosystem where the mediators are adequately provided the fee structure, and they can largely then depend upon as a career pursuit, only completely devoting to the mediation part. Now, when we question of this fee structure or adequacy of the fee payable to the mediators comes, sometimes we unnecessarily start comparing with arbitration also. That also creates a lot of confusion about arbitration and mediation. Justice Srivastava, in one line, would like to speak on that also.
All of us, through our experience, know that the arbitration is under severe criticism as having virtually reduced to a pre-litigation. Once he enters into the formal litigation system, then commercial courts and higher courts, and then it takes a lot of time. Mediation has many reasons has to be preferred as arbitration for many reasons. Firstly, it is cost effective, it is less time consuming, and it does not result in further litigation. There is a settlement of dispute. Under section 12A of the Commercial Courts Act, it talks about compulsory pre-litigation mechanism unless the case involves an matter of an urgent nature. But then the word suit has not been defined in the Act, and therefore it has to take its meaning color as has been defined in the provisions of law, General Clause Act, CPC. I think that should include arbitration as well. Why to have arbitration for commencing without having a pre-litigation mediation mechanism? So I think every arbitration proceedings must precede, unless of course it's a case of urgent nature, parties can go under section 9 or even before the arbitrator. But in all other cases, they need to have mediation preferred to arbitration proceedings. It is only upon failure of mediation that the arbitration should be taken recourse to.
Thank you, Justice Srivastava, drawing the clear distinction between the scope of arbitration on one hand and that of the mediation on the other. Now, in very recent times, with the enactment of this Mediation Act of 2023, there is too much a talk, a positiveness and a lot of expectations from this new Act of 2023. Even yesterday, I also in my 5-minute very brief inaugural address, I also referred to this Act as a ray of hope for the strengthening of the mediation as an institution and for particularly for a structured mediation. I have also tried to go through the provisions, and maybe that the question that would always arise is that, of course, enacted very recently, does this Act really meet with all the expectations which the mediation community is looking for from the legislature? Or is there something which is which we think as a legislative deficiency or a lacuna that has been left behind and that need to be really addressed? For that we have Chief Justice M. Sundar with us. Justice Sundar is right now Chief Justice Manipur High Court, and my brother as a judge of the Madras High Court has been actively participating. You must have seen him, very familiar face in all the arbitration and mediation conferences. He is with us. I would request Justice Sundar just to very briefly point out the lacunas or the deficiencies which according to him are there in the Mediation Act and which ought to have been addressed by the legislature.
Thank you, Honorable Chair. The point is, as regards this Mediation Act 2023, it is a conditional legislation. It was passed in both houses of parliament in August of 2023, received presidential assent on 14/9/2023, published in the Gazette on 15/9/2023. It consists of 65 sections, nicely slotted in 11 chapters. But the point is, 3 weeks later on 9/10/2023, only 21 sections have been notified. The remaining 44 sections have not been notified. So now we are operating only with 21 out of the 65 sections, this being a conditional legislation. Now, of the 44 sections which are yet to be notified, in my considered opinion, I place it for the consideration of this august House with all humility at my command. I feel 11 sections are very, very important. These 11 sections can be put in 3 baskets. Considering the exigency of time, I'll just address these 3 baskets alone. Basket number 1, that is sections 49 and 50. 49 and 50 deal with mediations in cases where state is a party. Now 50 has been notified, 50 has come into force, but 49 has not come into force. In my considered opinion, 49 and 50 are statutory twins. They are at least statutory cousins. Now 50 gives immunity and protection for officers who take decisions in mediation. But 49 is the one which talks about prior consent of a competent authority. Now if 49 is notified, the government may put in place SOP, standard operating procedures, and competent authority may be notified. Then it becomes so much easier for the officers to take a call. In very simple terms, all of us are aware, assuming the state says it is entitled to 100 crores, considering the length of litigation, considering the uncertainties, considering the cost of litigation, it may take a call saying, all right, we'll settle for 75 crores. But who takes the call? Who is the competent authority? That is one lacuna which I may point out. 49 should be notified as early as possible. Of course, the parameters which the executive may be considering are different. As adjudicators, it is not for us to get into it. But the point is, it needs to be notified as expeditiously as possible. The second basket is sections 27 and 28. In my humble opinion, 27 and 28 constitute the soul of the statute, for the simple reason that 27 gives the status of a decree, a civil court decree, like under the Arbitration Act, for a mediated settlement. A mediated settlement can be put into execution under 27. 27 is controlled by 28. I respectfully say it is controlled by 28 because this 27 finality can be challenged only under the 4 grounds under 28. Fraud, misrepresentation, corruption, excluded under section 6. So 27 and 28 may have to be notified and may have to kick in is the respectful point which I am placing for the consideration of this August. The third basket, I would put it very quickly, sections 58 to 65, 8 sections. That is legislation by incorporation. Several statutes would stand amended when these 8 sections, 58 to 65, kick in. For illustration, 12 capital A of the Commercial Codes Act. Now, as of today, a pre-institution settlement arrived at under 12 capital A has the status of an arbitral award. That is causing considerable difficulty, and we are aware of the dichotomy of opinions, and ultimately in partial automation it was settled saying it is mandatory. All that we are aware of. But now when these sections kick in, a mediated settlement in a pre-institution mediation under 12 capital A would now become a settlement within the meaning of Mediation Act, which means the scope for challenge is taken away from 34 of the Arbitration Act and limited to these 4. This is an illustration I am giving. There are several other statutes by incorporation which will stand amended when the sections 58 to 65 are notified. So this is being a conditional legislation, this has to be considered as my respectful point I am placing for the consideration.
Thank you, Justice Sundar. You have very well highlighted that how Section 49 is still awaiting the enforcement, and unless by virtue of that section, the central and state governments also start participating in the mediation, the question of granting exemption on good faith under 50 or protecting the officer under 50 may not arise. As such, therefore, 49 and 50 are mutually dependent on each other. And 27, he rightly says, the soul of the act, because that is the only provision under which a mediation settlement has been given a status of a court decree, and that is enforceable. In 28, but Brother Sundar, one, of course, that's very legislative, has really thought of it, because particularly in the rural background, one of the ground taken which normally not usually you find in the legislation is ground of impersonation. That's also a ground, because that sometimes mediation, fraudulently that other person comes and but my worry is about clause 4 of subsection 2, where it says a mediation settlement can be challenged where the mediation was conducted in disputes or matters not fit for mediation under section 6. That is too wide and sometimes too open. It may invite a full-fledged court trial before the civil court and a parallel proceeding despite a mediation settlement. So that is also one issue that we can, of course, separately debate. We have with George to conduct this session along with me. I would ask George to now proceed further with certain questions and associate my other panelists.
Thank you, sir. Just following up from the legislative bit, if I can follow up the next question to Justice Mohammed Mustaq, a senior judge of the Kerala High Court, who's been very actively pursuing mediation even before his elevation, and now as a judge of the Kerala High Court who is pursuing it from a judicial perspective. So, what legislative measures are needed to ensure that mediation reflects India's dual tradition, the truth-based resolution and the harmony-oriented resolution, while still aligning with modern legal frameworks?
Honorable Chair, and thank you, Mr. George, for asking this question. We all speak about mediation and relate it to our tradition and culture, but at the same time, we don't look at the Mediation Act as something linked with our society. Are we treating this mediation enactment as similar to the Arbitration Act and simply seeing as one of the procedure too? Or do we want to connect with the society? That is an important question we need to answer. Whether we can find that connection in our legislation. We speak about Lord Krishna's role in mediating. Lord Krishna was mediating for a dispute resolution or prevail something else? If you look at the history, you will find the attempt of the Lord Krishna was not of a dispute resolution, but was in attempting to prevail truth, the ultimate dharma. So we were a small, close-knit society where everybody knows each other. We are bound by personal ties. In that society, the truth was very important. So in a society where we want to relate mediation to our culture, ethos, do you see that present Mediation Act connect to the society? I don't think it's connected to the society. Why? Because we try to simply imitate the Western model. That's exactly the problem with us in the legislation. In a society which is a close-knit society where the personal relationship is very important, the truth matters. Now, the society moved forward on the invention of agriculture and the industrial revolution. We have a impersonal relationship where the law becomes an artificial virtue to find justice, no doubt about it. But do we require to classify and categorize nature of disputes? The classification must be on the well-grounded principles. The relationship bound by the personal ties and relationship not bound by personal relationship, of course impersonal relationship, where we can find answers to the artificial virtues of the justice concept. This is exactly the problem because you know the history. If you look at the history, you'll find in Europe after collapse of Roman Empire, the philosophers in Europe tried to develop principles of law on natural justice principles and create an artificial virtues to bind all impersonal relationship. But in contrast, now life, the issues in the life and issues in life are not separable. It's part of a way of life. We looked every aspect of issues as a part of our life, very existence of life. So we always focus on the truth to prevail in such relationship. But in Western culture, it's not. They look, all relations are impersonal relationship and fix issues based on artificial virtues. Maybe it may be relevant in certain categories of disputes, but not all categories. We must remember 65% of population live in rural India. And we are taking mediation to rural India with kind of mindset which mediation is evolved in Western thoughts. Is it practical? Don't we require to reinvent or reimagine the mediation process in our cultural settings? So we need to classify the disputes which are amenable to the truth. I mean, it's bound by the personal relationship and which do not require such classification. I mean, it's bound by the impersonal relationship. If we are able to classify and categorize, we can relate our past. Unless we create that kind of compartmentalization, we may not be able to relate to past and cultural ethos. And you know, in India, we are all religious societies. We follow culture, practice, and tradition is all aspect of life. If mediation becomes alien to our system, there is nothing we can take forward with this kind of the premises on which the mediation enactment is made. So we need to focus on the very philosophy of the mediation and classifying and structuring it in such a way to conducive to Indian culture. That's most important, I think, and that's part of is missing in a mediation enactment. In Western culture, all issues are extended to their life, but for us, it's all part of our life. We can't separate issues from our life as far as in personal relationships is concerned. So in that process, mediator as a role is not an impartial or neutral umpire. He has a role to find truth and prevail truth over such relationships. And that will create a new society in our country. Of course, in all other kind of impersonal relationship disputes, a mediator can have a different role. He can be a facilitator, but not in a disputes which is bound by a personal relationship, where he has a different role. So we need to define roles based on the categorization of disputes. This is what my views on this legislation. Thank you.
Thank you. Thank you, sir. So far, we've had a general flavor on the mediation, the legislation we have in place, what needs to be done. But what is mediation without mediators? So if I could go on to Justice Suresh Kumar, a judge of the Madras High Court who's had a vast experience in this field. Sir, to you, how do you see mediation as a profession? Do you think it should be limited to legal practitioners?
Thank you for the chair and co-chair. Good morning all. Sir, before the 2023 Act, that informally this mediation process went on throughout the country. We judges at various hierarchy used to refer the cases to the mediators. In mediation centers, we have already a panel that before whom that it is referred. They will try their level best. That 60 days time, that as per the Madras rule, that 2010 we have brought the rule. Within 60 days time, if the mediator is able to settle it, he can give the settlement report, otherwise not settled. That report also would be sent to the court. The rest of the things will be taken care of by the court. But first time, after much deliberation in 2023, the government has thought it fit to bring this legislation and the parliament enacted this. As my brother Chief Justice Sundar pointed out of the 65 sections of 2023 Act, majority are yet to be notified. 44 sections are yet to be notified, only 21 have been notified. Among the sections which are not notified, Section 8, Section 11 and Section 12, which deals with appointment of mediators, termination of mediators, and also the replacement of mediators. These are all the important sections pertaining to the appointment, functioning of the mediators. This almost equal to the Bar Council rule. If the mechanism does not provide how professionally a mediator has to be appointed, and if the traditional system of mediation is taken place even still after the 2023 Act came into effect, I think the litigant public may not have the full confidence on the system that it is also equally or parallelly a court system by way of mediation. And people may not tend to come before the mediators to submit their jurisdiction before the mediator, unless the parties come before the mediators and submit to the jurisdiction, even under the 2023 Act, except in cases of commercial nature where Section 12 capital A is there, mandate them to go for a pre-litigation mediation, but not in other areas. Therefore, these three sections are important sections, are to be notified first. Assuming that these sections are notified and trained mediators are appointed, a pool has been developed because the council has already been, how to create the council has already been notified, that sections, that is Chapter 8 have already been notified, establishment of council, Section 31 to 37. That once the council has come into being, these mediation service providers can be regulated and they are also can be regulated and registered. And once the service providers come, a pool of trained mediators can be maintained by each of the service providers, so it will become a profession. Assuming that if these provisions are notified and it become a profession, equal to the regular practitioner, regular legal practitioner, even then, if for instance a mediator is well versed in a personal law, that he may not that much of expertise in a commercial litigation, commercial mediation. Like that, a person who is in commercial mediation may not that much of integrity of the area where the service dispute or employment issues or labor issues are involved. Therefore, even if mediators are appointed, among the large pool of mediators, we must concentrate that mediators are to be trained in a selective subjects. If the mediators are selected and they get trained in the selective subjects, they will become the expert of mediation in a particular subject that will create a subject-wise expertise in the mediation. That is one thing. Apart from the legal profession, so some areas, technical areas are there, where especially in commercial litigation or some other litigation area, the other professions are required. Sometimes the auditors are required, chartered accountants are required, some other professions are required. These kind of mediators, not necessarily be the legal practitioner, they can also be involved, but majority, the mediators must be only from the legal field. These mediators, what are all the role of the mediator and what are all the mediators that other proceedings, etc., that also have been dealt with under section 16 and 17, which are again have not been notified. The mediator settlement agreement is also there, that has not been notified. These are all the gray areas where if all these provisions are notified by the government as soon as possible, that a system would be created where the old system of that mediation, that is called a transitional period, where the traditional is in a mediation is in a traditional way, that can be slowly, can be shifted to a structured and robust mediation system where equal to the traditional court system, we can parallelly develop this mediation system as the yesterday dignitary spoke in the inaugural session. Already the Indian court system has crossed pendency of more than 5 crores of case. Therefore, this mediation is the sole way out how to take a maximum burden from the judicial system and to resolve the cases, and also equivalent to 34 of the Arbitration Act, we have section 28 also. Once the mediation settlement is there, it will have an enforceable enforceable court degree, and except the fourth situation as stated already, that no appeal could be filed, and therefore even the court of like a court of first instance, it is the first instance of the mediation itself. Any dispute referred to the mediation would get resolved, and that will give a long way for the litigant public to get as well as even in the first instance. This is what my insight, the view that I can present before this August House for the consideration. Thank you.
Thank you. Thank you, sir. You just touched upon how to look at mediation as a profession. So just moving on from there, if I could put my next question to Justice Sachin Datta. So we've heard on how mediation and court annex mediation, how it's been progressed. So how far has mediation been effective as a dispute resolution mechanism, particularly with your experience in Delhi?
Well, with regard to Delhi, I have some statistics which I can share with you. Now, during the period 1st January 2024 to 24th September 2025, the Delhi High Court Mediation and Conciliation Center, which is largely managed by members of the bar and only supervised by the court, the number of cases that were referred were about 6,600. The settlements achieved were about 1,800. And if one takes into account the connected cases that also stood resolved by way of the mediated settlement, the figure is about 3,400 plus number of cases that were settled by way of mediation. And that translates into a success rate of more than 50%. And at the pre-litigation stage, again, the success rate is quite high. It's more than 30%. I must add that the success rate has gone up on account of the recent special mediation drive launched by my Lord Justice Suryakant, not only in the High Court, but also if one sees the data at the level of the district courts. Now, in the calendar year 2024, there were about 45,000 references, and the number of settlements are about 18,000. And if one takes into account the connected cases that also stood settled, the success rate is about 40%. One thing that emerges from the data is that the number of referrals are only to the tune of about 3 or 4%. That is, only about 3 or 4% cases are actually being referred to mediation. The kind of success rate that is achieved perhaps indicates that that the number of references should increase, and that is one of the objectives of the undergoing special drive. So, as far as the Delhi is concerned, the record, I mean, it's very satisfactory. And I think 2 or 3 things that emerges from this is that the lawyer mediators who have facilitated this are really the unsung heroes of unsung heroes and heroines of our dispute resolution mechanism. And the success rate that is achieved through mediation is much higher than that achieved through any other dispute resolution mechanism. So two lessons. First, that mediation is no longer the poor cousin of litigation or arbitration. I mean, I think that's what the Delhi experience shows. And it has actually matured into a serious, structured, and increasingly preferred dispute resolution mechanism. And secondly, the obvious, which my lords have stated, that mediated justice is a faster, cheaper system, which is unclogging, which is key to unclogging our judicial system one case at a time.
Thank you, sir. Those statistics are truly encouraging, but we shouldn't limit mediation to select pockets, but reach each and every corner of the country. So just to follow up on that, if I could put my next question to Justice Harinath Nunapalli, Judge of the Andhra Pradesh High Court. Sir, what is the way to encourage mediation as a career option, and how can you incentivize it? And also, what are the essential components of a sustainable mediation ecosystem in India?
Thank you, Honorable Chair. Mediation as a career can be projected subject to the lucrativeness involved in it. Probably as rightly suggested by Justice Suryakant, that the remuneration thing has to be re-looked at. That's one. Now, in the colleges, we have different clubs. Probably the vice chancellors across the country should be sensitized to set up a mediation club at the college level also, university level also, so that these people can develop as future mediators of the state and the country. Apart from that, what I feel is the torchbearers of mediators should be, mediation should be the bar. We should also take along the bar with us, the bar councils and the bar associations, to sensitize the public, to create awareness amongst the public, including rural areas, that mediation is definitely an effective, alternative and cost-effective tool of settlement of disputes. So unless the bar is taken along with us, probably we'll be achieving greater targets and greater results once we involve the bar. That's my opinion. Thank you.
Thank you. Thank you, sir. Just having heard all the judges so far, if I can move on to Ms. Nandini Gore, a senior practitioner and also a trainer who trains mediator. Ma'am, what strategies can be employed to raise the public awareness about the benefits and the process of mediation? Because that's what is a message that needs to reach the larger public.
Good morning to everyone. Good morning to the chair. And thank you very much to give us opportunity, the mediator community who has come all the way from different states. Thank you very much for this. So before answering your question, I have made certain points of what honorable judges have said. So one point was there that co-mediator should be appointed. But co-mediators are being appointed, but my suggestion is this also, that if we are starting these courses from the college level, we are encouraging the college students also. So what we can do is we can ask them to join as paralegal. Like we do in paralegal in different fields, we can do, they can be working as a not legal, but as a paralegal mediator along with the co-mediator, so that they can learn the nuances of mediation, because they are not at that stage trained mediators. So we need to train the mediators first, and then we have to put them on the panel so that they can learn, and later on side by side they can also do the 40 hours training. Another thing which I want to note down is, which I have pointed out, that in the Mediation Act, though there is no specific limitation for number of years a lawyer should do, but usually what we follow is at least 10 years of practice. So there are many new college graduates who are coming out of the universities and they want to join mediation as a career. So for them also there should be some provision that after doing their law degree, they can specialize in mediation, and then they can take mediation as a career for themselves, because there are so many opportunities for public sector, private sector, government jobs even they can be teachers for specialized mediation courses, and there are other things also. For example, in company law board you need mediators, insolvency laws you need mediators, corporate law you need mediators. So then where hypersensitive fields are there at that stage these people can be specialized and they will be later on expert mediators in every field. Now your question, how we have to promote mediation. Yesterday when I landed at the airport, I saw a big board, second mediation conference happening at Bhubaneswar. So 2-3 ladies were there, they were not from our mediator community or lawyers, they were clicking pictures, and one of them asked me, what is this? Because we talk amongst ourselves, the lawyers, the mediators and the community which is aware about mediation. But what about general public? They are not aware of mediation. So what we should do is, not only at the airports we allow people to advertise about their products. Government can do certain banners on mediation so that people will be aware of it. We can make small pamphlets which we can distribute. In the picture halls, after our national anthem, there are series of advertisements are there, but there is no advertisement about mediation. We can make small skits, dramatical presentations, or even for the school children also I say that we have to inculcate in them that mediation is a process which starts with our household. So what we can do is, what our children are aware is, if there is a conflict, what we have to do is we have to go to the court. But if we inculcate this value in them, that there is another process which is called mediation, it will have an impact on their brain, and what they will do is, they will say, okay, there is something like dialogue, we can resolve it. And later on in schools also, you know, there are certain schools where they have conflict coaches, they call it conflict coaches, for the students when they fight with each other. So from that we can learn that every college can have it. So the mediators have another opportunity for a career, that they can become conflict coaches. So these are certain things, but some other things I will give in detail to Justice Suryakant definitely. Thank you so much.
Thank you, ma'am. That was a perspective on how to encourage a public into mediation. If I could just follow it up with a question to Justice Suresh Kumar. So a prominent challenge that mediation faces the lack of public trust, and this is because many consider it as not being adjudicated by a court or a judge, and there is no decree. How can we change this perception about mediation?
Well, sir, that I indicated for my answer to the first question, that when we make it as a profession, as I said, that with all the provisions of the 23 Act, that if they come into force and we make it as a full profession, the mediator professionals are appointed and they get trained, in the particular subject depending upon the individual mediator based on their wish, passion, that each mediator will have passion in one or two subjects in law. So they can be trained in such subjects. So they will have the expertise in the subject. And when we start the mediation centers, maybe the institution mediation or the individual mediators or whatever it may be, when we start the mediation centers, we can start it as if that it is not equally to the court, but at least some atmosphere can be given to the society, that atmosphere can be given to the litigant public who come to that mediation centers to see that yes, the mediator is there. The mediator may not be a judge, but at the same time, the mediator, of course, if he completes the mediation successfully, and once the mediation settled agreement has come into force, and it can have the enforceability and it can be enforced as a court degree. If that kind of confidence is instilled in the mind of the people at large in the society, certainly the people will make a tend to come and they can believe the system. That is one thing. Second thing, we cannot take it, it's only a part of this justice delivery system. Mediation is equally that can shoulder the maximum burden of the judiciary is already shouldering. As the docket swelling is there, it becomes inevitable. So we have to refer many number of matters wherever it is possible. It is not only confined to personal laws or motor accident claims tribunal cases, but we can refer any kind of issues. Even the law provides, the 2023 Act provides for a community mediation. Such kind of community mediation centers can be established with the help of the government, state government, with the help of the local bodies. That kind of centers also can be established where, if suppose in a public office, in a collector office, that kind of community mediation centers are established, even the major issues, major community issues touching the very smooth functioning of the society also are referred to the mediation. And the community mediation is become successful, then the people at large will have a faith. They will start listening. What is this movement, this mediation? That mediation is going on. They resolve not only the individual litigations, but also they resolve the major issues touching upon the society. If that kind of confidence is developed in the minds of the majority, minds of the litigant people as well as the society in general, certainly that will take into the fold of the every person in the society, maybe in the urban society or in the rural society. We can take it not as a system, but as a movement. As a movement, if we take it, certainly we can win over the minds of the people, and in the coming years, that more and more people may come towards getting the settlement through the mediation. That's what. Thank you.
Thank you, sir. This is a discussion which could prolong on and on, but we also ought to be mindful about the time at hand and the future panels to follow. So, with this, I hand it over back to the chair, Justice Suryakant.
Thank you, George, and all my eminent panelists. This session was for 1 hour, and I have promised that I will wind up within the stipulated time. So, thinking the watch, looking towards the watch and the time constraints, and after this discussion, when we are looking forward toward the way forward for the mediation, what has emerged from this panel discussion, I may just sum up in 1 minute only a few points. These are the bullet points which all of you will deliberate, consider, and then we will have on the next session, as and when the next event comes, we will have a more elaborate discussion on that. First, encourage mediation even if parties are before court. So, impediment should not be taken merely because the parties are in litigation already in court. We should encourage the mediation. Second, promote mediation culture through awareness and also training and equipping our mediators. That's very, very important component of the mediation success. The third thing is, court should promote a mediation drive and follow what we have really done in NALSA, that has been briefly pointed out, and this that's court's initiative is extremely important for the success of the mediation. Well, we also need to encourage the remuneration of mediators as it has emerged. Justice Srivastava pointed out that we need to have a good, a respectable, reasonable and fair and handsome honorarium structure. I will not say fee structure, an honorarium structure for the mediators. In fact, when I was looking toward the Act, there is a provision regarding constitution of a corpus known as mediation fund. I thought this fund is being created for payment to the mediators, but I found, I was a bit disappointed to find that it is only meant for paying the salaries, etc. Anyway, we will have our own mechanism to evolve it, but we must ensure that our mediators are allowed to develop it and build it as an independent career. Then Learned Attorney General is with us, he being the most prominent face of the Union of India with us. The government and all government entities should seriously pursue mediation as an effective modicum for resolution of their disputes, and for that the Government of India need to take an initiative to notify the implementation of section 49 of the Act, which my brother Sundar has already explained to you. I can just point out at this juncture that 2008 National Litigation Policy also expressly talks of the resolution of government disputes through mediation. So, if that policy can also be operationalized, that will also help a lot, coupled with the legislative intentment behind section 49, I think that can be a very welcome step to promote mediation from the government side. Then we need to have to implement the quality assurance and professional development skills and the systems also for our mediators. The Mediation Association of India, maybe under the leadership of learned Attorney General, should follow up this conference and the next which are stored in the near future, and let's reach out every part of the country. I would request learned attorney to announce the next conference here, so that all the mediators and participants are encouraged and they are well prepared for that one. The few other suggestions which I found that those have emerged is building trust. Let's have an evidence-based confidence building among our mediators. Let's build a systematic public trust through documented campaign. That's very important for the success of the mediation. For that purpose, we also need to strengthen our institutional credibility that may be evaluated on the performance basis, and I think that accreditation kind of the institutional assessment is also equally important. Another very extremely important aspect of mediation, which probably in the first conference I spoke when I said that let us have the mediation in the language of the consumer of the justice, for whom we really want to initiate mediation. So therefore, there I pleaded for mediation in vernacular language. I had thereafter gone beyond even that. I said we also to have the mediation even in the local dialect to make it more and more popularized. So therefore, I will really emphasize on the scale-proven community-based models for the rural and for the marginalized sections of the society. I can just give only one small example. In Arunachal Pradesh, in 3 areas of Tawang, Dirang and Bomdila, they have initiated mobile-based mediation camp, and that this is how they have overcome the geographical barriers. In Tawang, in Arunachal Pradesh, traveling, going to one place to another is so difficult. Most of you must have experienced that. So they have found out the innovative local via media to find out. So localized factors and localized solutions with vernacular language, with the local dialect, and this kind of integration with the society is another very important factor for the success of the mediation. And lastly and finally, it is for all of us, we are present here, that we make India a mediation friendly jurisdiction, and of course then we can provide an international platform, and for that purpose we need to have adopt the best of the practices across the globe, across our borders, and whatever is happening in the in and around the world, in the world of mediation, I think we need to pick up those best practices, integrate ourselves with those institutions, and we need to identify as a stakeholder at the global map for the purpose of the success and establishment of the mediation institutions. Thank you very much, all the very eminent panelists we have. I know that we couldn't give much time. They could share their experience, their ideas and their innovative thoughts on so many subjects, but it being an introductory session, we have the following session where my sister Justice Nagratna, my brother Arvind Kumar, Prashant Koteshwar, all of them will speak along with the learned Chief Justices, and I am quite sure that some of the issues which we have highlighted for way forward will also be further deliberated by all the participants. Thank you very much for joining us in this session.
Thank you, sir. You've already left a lot for the Attorney General to ponder over. He just wants to respond to that.
I just thank you so much for this wonderful session, sir. In anticipation of some of the issues which probably would be arising in this conference, I requested the Law Minister to have a quick round table to look at all these issues, proposing a round table sometime in the end of this month. Notifications and training programs, etc. will be discussed. I hope will come with a program. And secondly, I thought Northeast region requires a separate and focused approach. Probably in January we will have the conference in Northeast. And thirdly, the national mediation service providers, I've identified some of them. We are going to have again a conference before the end of this year. hopefully by January you would have probably reached a good stage of advancement of all these issues.
Thank you, sir. I take this opportunity to thank our chair, the co-chairs, and all the panelists, and last but not the least, a very attentive audience. Thank you.
As a commercial lawyer and mediator myself, I am very excited to take this discussion forward with a very distinguished panel consisting of the Chair, Honorable Mrs. Justice B.V. Nagaratna, Judge, Supreme Court, the Honorable Co-Chairs, Honorable Mr. Justice N. Koteswar Singh, Judge, Supreme Court, and Honorable Mr. Justice Gurmeet Singh Sandawala, Chief Justice, High Court of Himachal Pradesh, and the panelists, Honorable Mr. Justice Jayant Banerjee, Judge, High Court of Karnataka, Mr. Birendra Saraf, Advocate General, Maharashtra, Mr. Praful Kumar Bharat, Advocate General, Chhattisgarh, Ms. Geeta Ramasheshan, and Mr. Jawad A.J., Senior Mediators. Yes. And now, may I please request AG sir to felicitate the panelists before we commence.
Honorable Sri Justice N. Koteswar Singh, Supreme Court of India. Honorable Sri Justice Gurmeet Singh Sandawala, Chief Justice, High Court of Himachal Pradesh. Honorable Sri Justice Jayant Banerjee, Judge, High Court of Karnataka. Shri Virendra Saraf. Shri Virendra Saraf, Advocate General, Maharashtra. Shri Virendra Saraf, Advocate General, Maharashtra. Shri Praful Bharat, Shri Praful Bharat, Advocate General, Chhattisgarh. Shri A.J. Jawad, Mediator. Ms. Geeta Ramsheshan, Senior Mediator. Now I request Soni ma'am to proceed forward.
So welcome once again. We start the second session of the day on how to enhance ecosystems for sectoral mediation in India. We are glad to have the distinguished panel members. Honorable Ms. Justice B.V. Nagaratna, who is the chair of this panel, also co-chaired the technical session at the first National Mediation Conference in Delhi, and is passionate, to say the very least, about mediation as an effective, collaborative dispute resolution tool. Over to you, ma'am, for an overview of the topics that would set the tone for the rest of the session.
Namaskar and a very good afternoon to everybody. Esteemed panelists, Brother Justice Pancholi, Honorable Chief Justices and Judges of the High Courts, Learned Attorney General, Learned Advocate Generals and other esteemed delegates. Before I go on to the actual topic, I would like to ask ourselves a question and preface my talk with a few points. Why do litigants go to court? Obviously, they go to court for justice. Then what is justice? And how is justice achieved? The obligation is on the legal profession to serve as healers of human conflict, whereby we provide a mechanism and an acceptable solution in the shortest possible time, with least possible expense, and with a minimum of stress on the participants. That is what justice is all about. Is mediation not a mechanism that has been now statutorily recognized in the place of the justice system to achieve justice? Therefore, we should say that mediation is a form or a new dimension, not only to achieve justice, but to access justice. Access to justice. It embraces a philosophy of democratic decision-making. The definition of mediation is drawn primarily from the exercise of party self-determination. The magic is that it can occur when people open up honestly and empathetically about their needs and fears in uninhibited private discussion. Then what is required for mediation to be successful in our country? It undoubtedly requires a complete change in the mindset. For litigants to become aware of its benefits in comparison with the great disadvantage of waiting in the serpentine queue for the day of reckoning to arrive in a court of law. For that, the role of the bar as well as the bench is vital in taking mediation forward. We in the judiciary can no longer be in the past or remain in the past. It is important that courts also adapt to the changing times. Now that the Parliament has enacted the 2023 Act, it becomes the court's duty not to greet it with skepticism, but it becomes necessary to fulfill the intention of Parliament by realizing the true role of the judiciary. With this preface, I would like to go into the sector-specific mediation. I'll try to be as brief as possible. By sector-specific mediation, I mean the various sectors in which mediation can advance. Now we see we have usually it is in the family court matters, to some extent in partition suits, or in certain recovery of money suits. Sometimes it is there in compensation matters, or in other disputes which are not really in the sectors which we are now trying to speak about. I am aware that clause 6 of the first schedule of the Mediation Act says that those cases which are before the National Green Tribunal cannot be mediated. But I would nevertheless say that when environmental conflicts are there, which involve complicated socio-ecological challenges and a wide spectrum of stakeholders, there could be mediation in environmental matters. This is a domain which can be beyond the room of the mediator, to involve site visits, informal discussions, and direct participation of stakeholders. A mediated settlement, for example, in a pollution dispute could include not just compensation, but also commitment to habitat restoration, the establishment of joint monitoring committees, or community benefit sharing agreements. Therefore, we need to train what I would call as green mediators, who are individuals who require unique skill set, combining expertise in mediation techniques with a deep understanding of environmental law, climate science, public policy, and socio-economic impact assessment. We could draw sustenance from the United States Environmental Protection Agency, which has institutionalized the use of environmental collaboration and conflict resolution, ECCR, for over 2 decades. What should we do for that? We should have a 3-pronged process. 1, training cohorts of specialized mediators, as I said, green mediators, advocating for the viability of mediation in environmental disputes, ensuring real and meaningful participation of all stakeholders. The next sector I would speak, though I am aware Section 65 and the 10th schedule has not been notified, but even then a significant challenge is in healthcare disputes, where there is an inherent power imbalance between an individual patient and a medically and legally uninformed persons and a large, well-resourced healthcare institution. To have mediation in such kind of disputes, we need to address this asymmetry by having patient advocacy groups, PAGs, who can play a formal integrated role within the mediation process. We have listened in the earlier session of student mediators. They could be part of the what we call patient advocacy groups, like we have PLVs in the Lok Adalats and the Legal Services Authority. Moving forward, mediation in intellectual property matters. It is true that for getting an urgent relief in an IPR dispute, Section 12A is not resorted to. Mediation, according to me, is a confidential process where, in a sensitive commercial and technical matter, there could be open discussion between the parties. Mediation can generate a wide range of creative, business-oriented solutions, and the parties can agree to coexist with many agreements arrived at in the mediation. To build a world-class IPR mediation ecosystem in India, it is necessary to learn from and integrate with global best practices. In this context, I would like to refer to the World Intellectual Property Organization, WIPO, and International Center for Dispute Resolution, ICDR, where specialized rules and extensive panels of expert mediators are there. Just like green mediators, we need to have specialized mediators in line with the IPR regime. Next, we heard in the morning session about Section 442 of the Companies Act, which permits mediation in company matters, which could be done by the tribunal referring suo motu now. we need to know that mediating first should be the legal DNA of a startup from its very inception. The government has got the program called Startup India Initiative. It must popularize this by having a clause regarding mediation as a necessary component of any founders agreement, shareholders agreement, or a binding term sheet. A founder dispute resolved in a week's time or a few weeks' time to mediation can have a great impact on the company's success or its failure. I know that Section 49 of the Mediation Act 2023 is not yet notified, but when it comes to public policy and government contracts, what happens? We are all aware of the Government of India, particularly the Ministry of Finance Office Memorandum dated 3rd June 2024. There is a reference with regard to arbitration and a positive reference to Mediation Act. But in my view, what happens is if a government body goes on initiating another round of litigation to exhaust all judicial avenues where there exists no likelihood of success, our country's resources will continue to be improperly used and judicial time mislocated. I think for any radical improvement in government-led dispute resolution, and more specifically for propelling mediation, there is an impending need to transform this outlook. If a mediation decree entered into between the government and the contractor is necessarily looked at with suspect by the higher officers of the state authorities and the succeeding in charge in the department, the project of state authorities and private entities mediation will never be able to successfully gain ground. Therefore, in the national litigation policy and state litigation policies, it is necessary to have a greater impetus on mediation and as to when the government will really challenge such mediation awards or decrees. Section 27 and 28 of the Act have not been notified. Therefore, it is necessary to notify the same. I am aware of Clause 3 of the first schedule, that is in criminal offences there cannot be any mediation. But I would refer to one area, that is juvenile justice. Being also the chairperson of the Juvenile Justice Committee of the Supreme Court, where to give effect to restorative justice with regard to the child in conflict with law, we need to have what is called a tool, that is the victim offender mediation, VOM or WOM, which must be employed within the criminal justice system. There must be training of mediators for dealing with children in conflict with law, so that who are trauma informed and incorporate principles of child psychology and restorative justice facilities. Sections 58 to 65 of the Act have to be notified. I endorse what Chief Justice Sundar has said, and Section 55 has also not been brought into force. Section 55 has, with regard to second schedule, clauses 4, 5, 6 and 7, if you see, they are very, very important with regard to bringing about a dispute resolution in certain sectors which are under the Family Courts Act 1984, Legal Services Authorities Act 1987, Maintenance and Welfare of Parents and Senior Citizens Act 2007, Sexual Harassment of Women at Workplace Act of 2013. Therefore, unless Section 55 is enforced, clauses 4, 5, 6 and 7 of the second schedule will not be enforced. My suggestion to Learned Attorney General and to Learned Solicitor General, who is also present now here, is to ensure that the specialists abroad in these sectors are invited to India to train our mediators so that they get the impetus in the various sectors. Now, I have spoken for some time on this aspect. As far as the skill and process oriented sessions are concerned, I will request my esteemed panelists to speak, and probably I will conclude on that aspect a little later on. I thank the organizers of this conference for giving me this opportunity to chair this session. So over to my esteemed panelists.
Thank you very much, ma'am.
Brother Justice Kotishwar will speak.
Yes. Thank you very much, ma'am, for introducing the topic very exhaustively. Justice Kotishwar Singh, in the past you have stressed on the dire need for effective alternative mechanisms to resolve disputes other than the overburdened formal judicial mechanism. How do you feel mediation fills the ever-widening gap, and how can the mediation ecosystem be enhanced in India, in your view? Over to you, sir.
Thank you to everybody present here. Ma'am Justice Nagaratna, my senior colleague and chair of the session, and all other delegates present here today. Yes, as far as this issue, which has been specifically focused, the role of advocates, I think, is the most important. In our legal system, in the legal system, there is the initiator of the legal system or the responder. Initiator may be the petitioner or plaintiff who takes recourse to the legal system, and the responder who responds to any such plaint or petition filed. Now, what happens to the initiator? If he has a problem, obviously he will look forward for the first lawyer. So, a lawyer is the first person of contact through which the legal system is invoked as far as the particular litigant is concerned. Now, lawyers by nature, by training, we are trained to, there is the adversarial system. The lawyer's skill is honed to that, how to extract the maximum for the litigant, his client. So, the mediation, which is a totally different kind of skill which is required, accommodation, trying to understand other adversary, which is not in the DNA of a lawyer. Therefore, there has to be a paradigm shift in the training of the lawyers. Therefore, I say that in this training, it starts not in the court after formal initiation as a lawyer, but a very educational system where the lawyer gets his legal education. In today's legal education, though a lot of emphasis is given on moot court competition, which is again based on the adversarial system, not so much importance is given on the importance and significance of mediation. Therefore, I think the first important thing to strengthen this whole issue movement of mediation must start with the legal institutions, where the importance, significance of mediation must be emphasized and brought to the students' mindset. Then, of course, the lawyer. Unfortunately, our legal system, training for legal system consists of judicial officers. We have a very robust system in judicial academies. But unfortunately, as far as the lawyer's training is concerned, I see a glaring lack which I have felt since my entry in the judicial system. There is hardly any institution which is geared. Bar Council of India is supposed to be the lead, playing the lead role. I am sure the Bar Council members who are present here will take this initiative much more in trying to prepare a scheme of training for the lawyers, not only in the other adversarial system, which is there, we cannot avoid that, but this also arena where the lawyers have to be taught in accommodation, the skill of conciliation, scheme of dialogue, understanding others, because this is going to play a very important role. These are, I think, the role of advocates comes very important. Today, just like there is a digital divide, there is certainly a mediation divide. While the cosmopolitan cities like Delhi, Bombay, Bangalore, you have a robust system where a lot of well-skilled mediation lawyers are available. But if we go down the other district, provinces, taluka level, where most of the cases are pending, we see a pathetic lack of skilled mediation. This is something, a huge challenge which the judicial system alone cannot take. To that extent, I am really commend this movement initiated by the government of India and also the government of Orissa in initiating this dialogue and the system where we can have a more robust movement of mediation. Therefore, the lawyer is going to play a very, very critical, important role in the strengthening of this movement. They have to be told that you are the most important person who are going to bring this litigant to the legal system. Either you, therefore, the first thing I think the lawyer should do is to see that if there is a possibility of settlement at that stage, he should encourage the parties to come settle. Therefore, we are giving so much importance to the pre-litigation. All these concepts of pre-litigation, mediation and conciliation are provided in the Commercial Courts Act, Family Courts Act. All these have to be initiated by the lawyer. Well, if it's successful at the stage that that's lawyer, very fine, very good. But if not, then it goes to the court. The court has again a very important role to play. Section 89 has been amended. Earlier was little bit more legalistic, more procedural, because earlier the court were required to formulate the points of where the court felt that there could be a settlement. Orders have been now dispensed with. The court can play a very, very, very proactive role under Section 89 and Section 9 of the Family Courts Act also, where mediation is of prime importance, especially in family disputes, family settlement. These are areas where the court can play a very, very proactive role. Yes, there's other issue I also wanted to highlight. How do we enhance this mediation ecosystem? I mentioned again, so far mediation training, my knowledge goes, is confined to the NALSA, because MCPC, that regime is there, where it is confined to the members of the higher judicial service. Training is generally confined to the members of the higher judicial service, and lawyers having only 10 years of standing, or other experts who are about 15 years. Now this has to go. From the very beginning, just mentioned by other speakers also, we must encourage this training right from the beginning, not only in the education stage, but the moment he is enrolled as a lawyer. We should not put this cap of 10 years or 15 years as the case may be. But if we have to make mediation a really important and popular movement. As I mentioned again, this awareness program is so important. The litigant at a community level, at an institutional level, how much we can do. So far, the judiciary has been taking the lead role through NALSA and other activities, MCPC. Now it has to go beyond. The government has to take a very, very important role in this again, awareness. Because judiciary, by our very nature, we are not trained to do these activities. We are basically trained to decide cases, not for training, for awareness. Of course, NALSA is there, but then the government has to take the lead role, I think. There has to be a shift also in the activities. There are certain things which I mentioned from my experience in Lok Adalat. What I found is that in many of these Lok Adalat cases, the settlement could not be arrived at, as also pointed out many speakers earlier, because the bank official or insurance company official who are in the Lok Adalat, they said, sir, we cannot agree to this amount because our headquarter has said that we cannot agree more than 10 lakhs. Situation gets stuck because of that. Anticipating that, what I did was that we used to call the highest authority of the bank or the national insurance company a meeting in the High Court, saying that you must give more flexibility. You don't just penalize a person because the officials are apprehensive, because if we feel that contrary to the direction of the higher authorities, if we had agreed a settlement beyond the limit, he may be penalized. That fear factor is there. Therefore, we urged upon these authorities to give some flexibility to these limits. They agreed that. So these are various areas where we have to be innovative, but for which we need to interact with the other officials. Coming to, I just wanted to mention, I will not take much time, that public policy and government contracts. Here, what we have seen is that the bureaucratic functioning is coming in the way of mediation. Therefore, I would urge the Government of India to ensure that mediation is a subject not only taught in law schools and colleges, but also in the academy. For example, our Lal Bahadur Shastri Academy, where the Masuri, or in Hyderabad also, Lal Bahadur Shastri, there, yes. So they have to be taught the importance of mediation, that during the discharge of the official duties, if there is a possibility of mediation, they should themselves also encourage, because it is not only the responsibility of judiciary, of course, to encourage lawyers, it is the responsibility of everybody. That's why the whole this concept of community mediation also has come into existence. Therefore, what I am trying to say is that this is a movement, this is a concept which is not confined necessarily to the legal process, but it must go beyond to other areas where, and other areas, bureaucracy, the politicians, and all other stakeholders, they have to play a much more proactive role also to really make this mediation movement as successful. So with these few words, certainly I would like to, because I had at the time, because of time constants, I would not like to dilate upon others. I would like to listen to the other participants also. Thank you very much for giving me this opportunity.
Thank you, Brother Justice Koteshwar. Now I would like to request Justice Jayant Banerjee to share his thoughts on the subjects.
Thank you, Sister Justice B.V. Nagaratna, Brother Koteshwar Singh, Brother Justice Pancholi, Learned Attorney General, the Chief Justices of various High Courts, Honorable Judges, Learned Solicitor General, the Advocate General, lawyers, friends. I would like to speak on the mediation agreement. Mediation culminates in a settlement or failure to reach a settlement. At each stage of mediation, the mediator has to establish his neutrality, competence, and control over the process to gain the confidence and trust of the parties, making them aware of the process and developing a rapport with them. A successful mediator aims to get the parties to the mediation feel at ease, safe and comfortable. That trust that he builds up can easily and irretrievably break with the parties even losing faith in the process of mediation. If an effective, acceptable, enforceable, and clear settlement is not made after its terms being thrashed out rigorously. An onerous and undeniable liability coupled with a duty is attached to each mediator who makes that settlement. Therefore, the importance of such a settlement cannot be overemphasized. As in Order 23, Rule 3 CPC, in mediation process also, it is open for the parties not only to seek settlement of the disputes that were in issue prior to referral, but it is open for them to settle on other matters also. Therefore, the written agreement should clearly specify all material terms that have been agreed to between the parties. It has to be made sure that the parties understand the nuances of the terms. The language should be plain, precise, and unambiguous. The role of each party in performing his part of the obligation has to be specified as to who will do what will be done, when will it be done, where and how. Nebulous language and expression should be avoided. It should be that the agreement is executable and in accordance with law. Ambiguous words like reasonable, soon, cooperative, frequent, etc. should be avoided as far as possible. The mediator must analyze the terms of the agreement, and the parties should agree that due compliances can be made by the persons concerned and that transparency of the compliances can be ensured. Penalty clauses on delay of compliances, for example, imposition of damages, interest can be considered. Where legal proceedings are pending, it is imperative that by the settlement their withdrawal is ensured. If needed, monitoring and review of the mediation agreement can also be provided. There may be occasions that parties may feel the need to revisit the agreement, and the mediator should carefully consider the future possibilities of the need for such revisitation of the mediation settlement in the background of his careful understanding of the dispute between the parties. As we see that mediation settlement, mediation agreement settlement, these terms are defined under the Mediation Act, but unfortunately, the selective notification of the Act has rendered the Act ineffectual. Therefore, the courts have to fall back on Section 89 and Order 10 of the CPC. Time and again, settlements entered into between the parties come before judicial officers. They have to see that the various aspects of settlement entered into during mediation proceedings and ensure they meet the criteria for an effective settlement. If they find that the settlement is not in accordance with those considerations, they should not unhesitatingly affirm it, but proceed to actually refer it back to mediation for drawing up fresh settlement. In mediations between corporations, or when one party is a corporation, or where the government or its agencies, local bodies, or where a cooperative society is a party, the person authorized to sign the agreement must be known beforehand. The written authorization must be available. There may be instances where the matter of the settlement may have to travel back and forth several times. The mediator has to be prepared for such eventualities. So, I would very humbly, with all due respect, like to state, the fact that the mediator has to be a lawyer of standing has to be emphasized. Only a lawyer who has certain knowledge of the law and or knows where the relevant law ought to be found, looked for, can prepare a legally sound agreement that meets the requirement of the particular laws involved. We cannot expect a mediator who has dealt with family law alone to mediate on matters concerning corporate matters, trademark infringement, copyright disputes, and commercial court matters. Looking at the enormous challenges that the process of mediation in India would be required to face, particularly with regard to drafting of settlements in mediations in environment and climate disputes, in healthcare and medical negligence, IPR matters, corporate governance, government contracts, service and employment disputes involving the state, recurring disputes between citizens and government agencies, it may be necessary to develop and enhance an ever-extending pool of quality and specialist mediators. Experts comprising of bureaucrats, engineers, doctors, lawyers, businessmen, chartered accountants should be empaneled. Specializations of mediators is to be encouraged. In IPR matters, I'm just giving an example. The fact of recognition and acknowledgement by a party to the exclusive right of a trademark and giving up of challenge to the same by the other party should be spelt out in the agreement. The consequences of such acknowledgement must be specifically laid out, like stopping of manufacturing, restriction on putting material on internet, stopping and promoting, etc., of the items that carry their trademark. It should be provided that failure to do so may amount to infringement and passing off. For violations, it should be provided that the party infringing would be liable for damages and costs. Other restrictive covenants have also to be specified. As with other matters where parties settle out of court, right to claim refund of court fees may also be mentioned. So this mediation then requires a specialized attention. As her ladyship has already addressed the issue of section 442 of the Companies Act, I did not delve into it any further. So we find that writing a settlement agreement is hardly an easy work, but rather as onerous and as important as each step of the process of mediation. As they say, the proof of the pudding is in the eating. The proof of success of the process of mediation is evinced when the mediation settlement is drafted meticulously and is executed smoothly and to the full satisfaction of the parties concerned. It may also be that the parties may agree to disagree, yet agree that later they would return to the mediation process. Thank you.
Thank you. Thank you, Brother Justice Banerjee, for concentrating on the various aspects of drafting a settlement agreement. This is ultimately to ensure enforceability and legal soundness. I have a small suggestion as a follow-up to your sharing of thought. That is, every mediation center must have what is called a empaneled mediation persons who are well versed in mediation, and also experts who can vet mediation settlement agreement. They should vet it before they are actually signed by the parties. After all, the mediator is concentrating on arriving at a settlement. There may be no focus on the actual terms as such. And the settlement is drawn up. The parties are naturally, in most cases, lay persons, but there must be a person having not only expertise in that particular field in which the dispute arises, but also a legal brain who can vet a mediation settlement agreement so that there is no problem later in the enforceability, and it has the legal soundness so that there is no further problem in enforcement of such an agreement. Thank you, brother. Now I request Sri Birender Sharaf, Learned Advocate General Maharashtra, to share his thoughts on the subject, focus areas.
Thank you, madam. Good afternoon to all of you. I have been attending seminars in relation to mediation for some years now, and with all respect and humility, in every seminar we emphasize the need for mediation, how mediation can be an effective tool to resolve disputes, and what all needs to be done. Now I think if mediation is to become the backbone of dispute resolution, then we need to go a step further. We need now to study what really has been done and the performance of each of these sectors where we have tried to incorporate mediation as a part of a dispute resolution. And once we have these statistics, we need to consider what has been the success rate, what have been the obstacles, what have been the roadblocks, and then try to remove them. And important for that is we learn from each other's experience. We identify in which sectors it has been successful. We need to understand if some state has initiated measures which have been successful. I heard with a great deal of interest the Advocate General of Odisha and the Law Minister of Odisha yesterday saying that they are formulating a policy of introducing mediation at a grassroots level through Anganwadi Sevika, etc. Now these are shared experiences, specific instances which we need to now start discussing. Also, I think we need to differentiate between pre-litigation mediation and post-litigation mediation and not confuse between both of them, because the nature of mediation which takes place after a litigation has been initiated or maybe in court for 10-15 years is very different from a mediation which has to take place prior to the initiation of a litigation or a dispute, when the parties are volatile, their emotions are high. Very often settling a dispute which has been in court for 10-15 years, where parties are already exhausted, maybe spent enough money on lawyers, is an easier exercise, but the pre-litigation mediation is a different ball game altogether. I was very shocked to read some statistics which I found in one of the white papers prepared by the Economic Advisory Council to the Prime Minister, which did a study of 2 commercial courts in Maharashtra and said that under 12A mediation, 97 to 99% were non-starters, where the parties did not even effectively participate in the mediation. Of the remaining 3%, total out of 100%, only 1% of the 12A pre-suit mediation was successful. Now that is the kind of statistics which we now need to focus upon. Identify what is going wrong there. What is the lack of, is it a lack of training? And if not, what is it that we need to do to set it right? Now this statistics I found is very stark, and therefore the Economic Advisory Council to the Prime Minister has said it should not be made compulsory because it serves no purpose. Now this is a step which we all took in a right direction. We cannot let it be defeated. And therefore, in my belief, it's important now that we come down to real facts, real statistics, and try to resolve this, the problems that we are facing. In Companies Act, today Section 442 is not a new introduction. It's been there from 2013. But do we have the statistics today of how many matters were really resolved under Section 442 of the Companies Act in the last 12 years? And in the absence of that, how do we today identify what are the roadblocks which need to be resolved? Maybe we require, if it's not satisfactory, then maybe we can replicate it in other sectors. If it is not, then we need to identify what is it. Do we need to have more trained mediators, with more sectoral training? That's a focus which we need to do. Like in intellectual property, the Delhi High Court Intellectual Property Division rules have introduced a provision which permits a judge to send a matter for mediation even without the consent of the parties. Now we need to identify how that has fared in Delhi, get the statistics from the Delhi arbitration, the IP division, and if that has done well, then maybe other states can also replicate it and try and incorporate it in their own states. So that's an exchange of learning which in my belief we need to do in these seminars, because in some of the fields these provisions have been there for a very long time. Similarly, under the Consumer Protection Act also provision has been there for a long time. We need to understand what are the nature of disputes under the Consumer Protection Act which have led to settlements, and if that is a good result, can we also enhance or increase the span of disputes which can get resolved. In relation to criminal law, the state of Maharashtra has recently introduced an initiative. In any complaint under 498A, when a complainant comes to a police station, that complainant is told that before you lodge an FIR, you have an option. We have something called a Bharosa cell, which is in effect a mediation cell, which has a trained police officer trained in mediation, somebody from a self-help group, an NGO, and two or other people from the society. That is a mediation body, and the complainant is told, you have a choice. If you would like to file an FIR, you have a right, you can do it. But if before lodging an FIR, you would like to go to the Bharosa cell and try to mediate the dispute, you can. And that option is now being given. If the mediation does not happen, the complainant can come back and file an FIR. So, and that proceedings are kept confidential. They cannot be relied upon in the course of investigation. So that is an initiative taken by the state of Maharashtra. I still do not have the statistics of how well it has performed. But as I said, if things like this perform well, then we need to expand that, sharing the experience of one another. State of Maharashtra has taken this initiative. I'm sure other states would have taken various other initiatives. So this shared experience can enrich us and help us achieve the object of the mediation far better. The government of Maharashtra office memorandum of 3rd June 24 had in effect formulated a scheme under section 48 of the Mediation Act and said every department can have a mediation, and left it to each department to evolve their system of how they will mediate. A committee was suggested of a retired High Court judge or a retired officer, but it was said this is only suggestive, you can ultimately form your own committee, and some guidelines were given. Now, we need to understand whether any of the departments have actually followed that office memorandum in the last 1.5 years. If so, what has been a result? I must confess that a mediation and a decision on a mediation, particularly in high-stake matters at a government level, is not a very easy task, because the officers are now apprehensive to take a final decision that yes, this dispute can be resolved. So some kind of a confidence building or some assurance of the officers, which is there under the Mediation Act, will have to be brought about, and we need to see whether the office memorandum has been successful, and if so, we need to give a chance to, we need to replicate in states also. I just make 3 or 4 pointers. Now I think we have other speakers who you need to hear. What I really believe is required is sectoral training for mediators. A mediator cannot perform a good job in an IP dispute unless he knows the nuances of IP law. Similarly, for a corporate dispute, unless he knows what are the nature of shareholders dispute, what are the approach of the court in those disputes, that a mediator will not be able to perform. One suggestion I have, that instead of a court very often does not have a power to compel parties to go to mediation. But can we have a thought where the court can ask the parties to attend a hearing or a committee which can explain to them the advantages of mediation? Maybe that committee will tell them what are the advantages of mediation, place success stories before them, say such cases have been successfully mediated in the past, and thereafter if parties are not willing to accept it, of course the court may not be in a position to compel them. But that one initial approach which they get before the party, where the entire advantage of mediation is explained to them in an organized manner with success stories, etc., may help lead parties to mediation. And one more thing I must, before I close, the role of Advocate Justice Koteshwar Singh mentioned. That's a very important role. One of my most satisfying matter which I ever did was when I was representing a mother-in-law against a daughter-in-law, mother-in-law, a stepmother against, in a case filed by a stepdaughter. The lawyer of the stepdaughter took a very strong stand against the stepmother, said a lot of things about the stepmother. And when my turn came, all I told the judge was that she may not treat me like her mother, but for me she's still a daughter. I don't want to fight against her. The learned judge intervened and the entire dispute was resolved in 2 days. Relationships were restored. So yes, there is a great deal of need to also build a the lawyers need to be sensitized about the fact that there are categories of disputes where they can play a very proactive role in the resolution, and maybe that we can also achieve by rewarding lawyers by acknowledgement who have held and led their clients to dispute resolution. So these are some thoughts. I mean, you have other speakers to hear, and therefore I'll not take much of your time. Thank you very much.
Thank you, Learned Advocate General Sri Sharaf. Just to sum up your points, one is regarding audit of mediation in various sectors, which has to be made since we have progressed on various aspects of mediation for all these years. The second is, my suggestion is, when we should have seminars on sector-wise mediation, where the expert mediators in the various sectors, advocates who are experts, domain experts in various sectors, and anybody else who is a domain expert in a particular sector would meet up to see how in a particular sector mediation can be made successful. And with regard to the intergovernmental departments, although the ONGC case has been set aside by the Supreme Court, there is no impediment between various departments of state government or the union government going in for mediation to settle. And the other laudatory suggestion made by Sri Sraf is with regard to having a committee in the mediation center to explain to the parties with regard to the advantages of mediation. That could also be, that is a very good suggestion, so that the parties could thereafter be satisfied that there is some outcome which will be successful and advantageous to them. Thank you, sir. Now I request Sri Praful N. Bharat, Advocate General, Learned Advocate General, Chhattisgarh, to address the audience.
A very good afternoon to everybody, and thank you, Chair. Before I start, Lord, I will catch the line which my Lord Justice Nagratna has initially said, why a litigant come to the court. A litigant come to the court for a satisfaction. Satisfaction does not mean whether he wins or loses. Satisfaction means that he got his issue adjudicated finally. That is the core thing by which, due to which he comes to the court. Therefore, for a successful mediation, this satisfaction has to be arrived in the mind of the litigant, that even without going to the court, without approaching the regular litigation process, if he comes to this mediation course, then he can get that final satisfaction of that his issue has been adjudicated. So therefore, our first attempt should be that the litigation which through mediation has been decided becomes the finality. If that recognition and that satisfaction goes to the mind of an ordinary litigant, then certainly this mediation process would be successful. Because as of now, most of the person does not know about this mediation process. They do not believe it because they do not know that this process is also gives a finality to the issue. So first of all, we have to develop that satisfaction in the mind of an ordinary litigant. Now the second issue which I would like to address is the specialized mediators, because a mediator cannot work in all types of cases. A successful mediator in a family matter or in a property dispute matter cannot be a successful mediator in a company matter or in an IT matter. Therefore, we have to bifurcate this issue, that the mediators which we are training gets a specialized training in various fields, so that they can come up with the stand with the party who comes before the mediation, that look how this way your dispute can be resolved. If he knows the law of that particular field very well, then only he can satisfy the litigant who come to him. The another aspect which requires consideration is that this adjudicatory, since it is not an adjudicatory process, it is only a mediatory process. Therefore, whenever a matter comes to the court, there should be a window, a mediation window, that the litigant should be told that, look, this is a mediation process, you can avail this benefit, and the benefit of this mediation process is that you do not have to wait so many of the years, you do not have to spend so much of the money, and it is also a recognized mode of adjudication. So what can be done? That immediately after the pleadings are exchanged, this mediation window can be open for all the litigants, and with a timeline that if within that timeline, if the mediation does not fulfills, if it does not comes to a result, then certainly the proceedings would go on. The another thing is the recognition of this mediation settlement award should be there, because most of the clients think that even after the mediation settlement, how it can be enforced. So this should be brought in their mind with clarity, that this mediation award are enforceable. This is the way where which it can be enforced. Like in Commercial Courts Act, there is a specific provision. So that specific provision should be made in the other statutes also, or in the Mediation Act itself. The certainty of the adjudication, the final adjudication, if it comes to the mind of the ordinary litigant, then the mediation process would be successful. The another aspect which Mr. Saraf had just said, that the data of the successful mediation and unsuccessful mediation has to be shared along. Because it is only when the data are shared, we can come to a decision that why these mediations have become successful and why these mediation could not become successful. So we can identify the core issues for which the data are available with us, the core issues that why this mediation has become unsuccessful. We can work on that data, the unsuccessful data. So far as successful is concerned, we can applaud it that look, this percentage of the mediation has become successful, but we have to care about that unsuccessful mediation also, and we have to make a strategy. We have to overcome that lacuna due to which that mediation had not become successful. The another aspect is if we bring in the mind of an ordinary litigant that this is an alternate process which has also a finality of adjudication, then certainly the persons would voluntarily join this mediation movement. Because till today, the attitude of the parties and their mindset is that we will sue in the court. We have to overcome that attitude. We have to inform it that mediation is not a process by which you are winning. Mediation is a process in which both the parties can win with an open heart. Another aspect is the confidentiality. As Mr. Saraf has said that in Maharashtra, they had developed a scheme like Bharosa, and anything said and done in that counseling would not be used against the person. Certainly, a system has to be evolved so that this type of confidentiality can be in the mind of the litigant that what he had said before the mediator cannot be used against him in a legal proceedings. Apart from it, a supportive legal framework has also to be made, because till now there is a lack of supportive legal framework for the purpose of mediation. Though we train mediators, we give a training for a period of 40 hours and 80 hours, but to my mind it is not sufficient, because by the change of law, by the flux of time, many of the things are changed. So this training process has to be done continuously, so that the person who is working as a mediator, who is working as a trained mediator, must know what the law is today. Otherwise, if we do not give the training for a continuous period, the mediation may fail, and that is especially with respect to the specialized mediators. I had worked with many of the institutions, especially in the banks. We know that there is a OTS system. What is this OTS system? OTS system is virtually a mediation. Both the parties sit together and come down to a figure that this figure has to be paid by you, and the entire loan would be disbursed. Similarly, in the state disputes, the service dispute, those petty disputes regarding the pay fixation and the other retirement dues, it can be decided. But for that purpose, there should be a policy has to be developed by all the state government that these type of litigations which are burdening the courts should be decided by the state at the first instance. Similarly, in the contract, though there is an arbitration clause, but many of the contracts are so highly staked and it requires some policy decision. So the authority does not have that power to decide in terms of the dispute raised by them. That is why we have to go for the arbitration. So in my mind, we have to develop an ecosystem. Ecosystem means the trained subject-wise specialized mediator. We have to give a confidentiality to the person who is coming to the mediation, that the things which he had said in the mediation would not be used against him. We had to give him a confidence that the settlement made by the mediator is also attached with a finality. So I am closing with these words. Thank you very much.
Thank you, Sri Prafulla and Bharat, Learned Advocate General, Chhattisgarh, for sharing your thoughts that a litigant must be satisfied with the system of mediation, for which there must be an awareness. And secondly, you have spoken about the data regarding success and non-success of a mediation. The reasons for the same must be identified. Then confidentiality of a mediation process and supporting legal framework. You have emphasized on continuous mediation training for mediators. I may give a small example. A mediator who is dealing with, let us say, a partition suit, dividing of the property, unless the mediator is aware of the Supreme Court judgment in Vinita Sharma, which has interpreted Section 6 of the Hindu Succession Act 2005 amendment, and what the Supreme Court has said there. There cannot be, you see, a real mediation, particularly when there are female members of the family who are also seeking a share. So the continuous mediation education is important. When I had the opportunity to be the president of the Bangalore Mediation Center, which unfortunately is now changed as Karnataka Mediation Center, Bangalore Mediation Center has a brand by itself. There I had introduced continuation mediation education for the mediators, so that the resource persons from the Karnataka Judicial Academy were requested to talk to the mediators, to speak to them about the latest law in particular branches of law, judgments, so that the mediators are aware as to how to go about mediation, because ultimately a mediation agreement cannot be contrary to what the law actually states and what the latest judgment is. Thank you. Now I request Madam Geeta Ramasheshan, who is a senior mediator in Chennai, to address us.
Thank you, ma'am. I just wish to share my thoughts on ethics and confidentiality in mediation, though confidentiality in mediation has been discussed by the other speakers. While one understands the simple ethics of, not being honest, etc., I want to go a little deeper and refer to certain aspects. And the first, I start with ensuring impartiality. This can sound easy, but it can actually be difficult when, say, for example, there is a dispute for the mediator between a school or a wine shop, or between a builder and people who are wanting to protect the park, or between a husband and a wife. In all these cases, there could be a tendency on the part of the mediator to emotionally relate to one party because of whatever the mediator has as belief. And therefore, I would say that internalizing impartiality requires a lot of honing skills, which is very different, and I think it's more so difficult for a lawyer mediator. And then the idea that there has to be a permanent, continuous education on us to actually address this issue becomes very important. Now, we are trained, and I'm talking about the court-referred mediation, of which I'm a part. Now, we have been trained to say that we should follow the facilitative method and not the evaluative method, namely that mediators are only facilitators. They cannot evaluate the case or the dispute of the parties before them. It is important because at some stage, some mediators may evaluate and then completely pass judgments on the dispute. But at times when there is only a facilitative method, evaluation, not evaluating the dispute to one portion becomes very difficult, because simply for the for the fact that the act which Justice Mushtaq mentioned about is trained, the whole concept of mediation that we are learning has been a Western methodology that we have been following, and there is a whole lot of difference between the way the mediation works in a scenario where people are always expressing their opinion, to another scenario in our culture and country where expression of opinions does not come that easily. And that is why one would actually look into the fact that when we talk of self-determination, when we say that the party has to determine, and we tell them in the mediation that this is only going to be your decision, we have nothing to do in that. There are at times when the parties just look askance, because then they do not understand what the actual process of mediation is. And that is why there is a report, you know, there is a very well written report of the Singapore Mediation Center, which has brought an Asian perspective of mediation in 2009, which talks about mediation strategies, techniques and operational methods that have to vary to align with the Asian culture, such as hierarchy, or the fact that people are silent, they don't know how to talk, etc., etc. And some of this, I think we actually need to understand and incorporate in our mediation. The other aspect that I want to share with you is in the concept of confidentiality. Of course, mediators are trained to be confidential, and other speakers have spoken about it. But how does one then, the act is also silent on some of the issues where one may have to reveal, and I find that, say for example, in a matrimonial dispute, the wife complains of sexual abuse, then that is an offense under POCSO. Now, is the mediator bound to share this information? Because under POCSO, not revealing an information is also an offense. And hence, in such a case, as of now, there is no clarity. Therefore, probably one method could be that when the mediation, when the acceptance of the mediation is done in the court process, there could be a clause that can contain that if a child abuse is stated, it will be reported, so that parties are then aware of that process. Now, some of the other issues that I actually wanted to say have already been spoken about by others. In terms of confidentiality, there has been a very interesting judgment of the Supreme Court, which came in Moti Ram TR LRS versus Ashok Kumar, Civil Appeal 2008. Here actually the mediator had set out in detail all the terms and counter terms that were put forth by the parties, and had annexed this to the report and submitted it before the Supreme Court, where the Supreme Court had then held that this is not so and this should not be the case, and has actually described on what should be the terms, namely that one sentence has to be written if the mediation is unsuccessful. And this is again a case where the court has dealt with in terms of confidentiality. As far as competence and professional role is concerned, everyone has definitely spoken. The mediator must have a knowledge of the subject, and I am not going to go into that. But at that time, supposing the mediator gets a case of a subject where they are not competent, there should be a full and fair disclosure of the prior experience and qualification in this regard by the mediator in definite. Otherwise, the mediator would just keep hearing and not addressing. Of course, relationships with reference to parties and connections is well known, that has to be stated. But other aspects, again, one point which I actually wanted to make was that in the process of mediation, if there is no continuous training and education, we find in our own experience that most mediators get very flustered when parties are very aggressive, or when they talk and they are not able to stop. And the other flustering is when they have to write a report or help in terms of an agreement, because there again they are not able to address what is there in the agreement. So the suggestion made that there has to be persons who can actually vet the agreement to some extent is, I think, a very valuable suggestion, because sometimes even when we get flustered with the agreement, we share with other mediators how we have to do that. So, but that is, I think, one important aspect which I believe is very, very relevant. I only want to say two things. I just want to end on one aspect, namely that the mediator must not want a settlement rate, because if the mediator wants to have a settlement rate, then there will be a pressure on her to arrive at a settlement at all costs, and therefore this is something that would be very, very, very relevant in terms of how mediation success goes on. And last but not the least also, ma'am, when you were speaking about the environmental cases, where even if the mediator is trained in that field, there has to be a duty to the third party who are not participating in that mediation process, especially on all the larger ones. So with these few words, because what others have already said what I had wanted to say, I end my thoughts.
Thank you, Ms. Geeta Ramasheshan. You have spoken about the confidentiality in mediation. I would like to say one aspect on this. See, when we have transfer petitions at the Supreme Court, where mostly the wives file the petition for transfer of a case which is pending in a family court in one state to a family court in another state, inevitably we send the parties for mediation to see if the dispute itself can come to an end. For example, I told in one case, you please go for mediation, and I also told the husband, what is a life without a wife? That was before the summer vacation, and the mediation took place, and after the summer vacation, the husband said, Madam, I have taken your advice, I am now going to live with my wife. So these small things we do to see that there is a process of mediation and coming together. But when the mediation fails, of course, there is only one sentence, which is the mediation has failed. Then we ask, why has the mediation failed? This is not to judge the mediator. Mediation fails sometimes on quantity, in the sense of the settlement being with regard to alimony, for example. The wife would have asked for 30 lakhs. The husband would have said 20 lakhs. So we try to bring in a settlement in the court. All right, you increase it a bit, and a settlement is arrived at, and then we say, all right, the matters are settled. So this is not to judge the mediator when we ask why mediation has failed, but to ask the parties why it is not successful from their point of view. So let there not be any, apprehension with regard to confidentiality in mediation, and when we ask the parties why it is not settled. Secondly, you have spoken about facilitative method versus what you call the evaluative method. Then you have spoken about the Singapore reports speaking on Asian perspective of mediation. And of course, a very valuable point regarding mediators should not keep settlement rate in mind. That is, of course, important. I thank you for your valuable thoughts and suggestions. With that, I now request Sri Jawad AG, mediator, to give his thoughts on the subject.
Thank you, Honorable Chair, learned members of the panel, and the honorable delegates who are seated in the audience. For 18 years of my life, I have lived, breathed, spoken about, talked, eaten mediation. So obviously I have a lot to say about that. But then apart from the glare of these spotlights, I can feel the glare of the looks of the audience, because it's going to be 1:30 now and it's lunchtime. So I don't want to take up much of your time. I'll just put one or two points before you for your kind consideration. Because how do we look at dispute resolution? Because all along the cultural paradigm has been that of a binary of victim versus oppressor. Every plaintiff is a victim, every petitioner is a victim, and the other party is a an oppressor. So the whole, the paradigm works, the legal paradigm works on the demonizing of the opposite party. So when you walk into a lawyer's office, the other party, from a rascal, he becomes a bloody rascal. So that's how we look at it. And the dispute, the conflict keeps on, increasing. Now, we are talking about a cultural transformation in how we look at dispute resolution, which is humanizing the conflict and helping people to look at each other as human beings and try to work with each other to find solutions to their problems. So from a fault-finding paradigm, we are talking about shifting into a problem-solving paradigm. Now, Justice Koteswar rightly pointed out that we lawyers are not trained for that. We lawyers are trained in the adversarial paradigm. So many of us have undergone the transformation by undergoing the training. So one of the most critical aspects of promoting mediation is having the right kind of training. And I think the 40-hour training program that we have right now is completely outdated, and it calls for a relook at what should be the curriculum for mediation training. That is number one. Number two is, if somebody is going to undergo mediation training, what about professionalizing mediation? Because we have to seriously look at professionalizing mediation. Now, all these years, we have been having one leg in the court and one leg in the mediation room. So morning you wear the hat of a lawyer, and afternoon you go and sit and mediate. It doesn't work that way. That is why 18 years back I decided that either I'm going to do only litigation or I'm going to do only mediation, and mediation was the obvious choice. So we have to, unless we professionalize mediation, we have to come out of this concept of mediation being an honorary service, for which we need to professionalize mediation as a service. Just as we lawyers, do advocacy, we also have to start doing mediations. So you have to make a choice between litigation or mediation. And unless you make that choice, mediation is not going to flourish in India. We can talk a lot about it, we can hold conferences, but unless we make that paradigm shift in our thinking, it's not going to work out. So, sorry if I sound very radical in this, but that's my belief, that's my strong belief, and that's what I wanted to put before this August gathering. So that is number two. Number three is, for this to work, for the professionalization to work, I think we need to establish a proper institutional framework. Autonomous institutions supervised by the courts, because the courts are already overburdened. Now you're taking on the additional burden of promoting mediation. And it has been a fantastic job, because today we are sitting in such a huge conference and discussing mediation. It is thanks to the efforts of the judiciary that we are sitting here and talking. But now it is time to outsource this to institutions. The courts and the state should establish autonomous institutions that would deal with dispute resolution, where those cases that are fit for mediation should mandatorily go for mediation before these institutions, and they should be resolved. It's only when that resolution fails that we can have methods like arbitration or perhaps even the courts to come back to. But mandatory mediation is an absolute imperative today in India if we really want to seriously address the problems that we are facing. So with these points, I'll just stop here. Thank you very much for the opportunity.
Thank you, Sri Jawad, for your thoughts. A cultural transformation in mediation is what Mr. Jawad has said. And to shift from fault finding to finding a solution through mediation. He has also said, as an experienced mediator, that the 40-hour mediation training is outdated. I agree with that. We need to have a more professional training for mediation, and it should not be an honorary service or a part-time activity, so to say. In fact, when I was in Karnataka High Court, many mediators would say, my lord, please don't have this matter on a Friday, because I go to mediation center on Friday. Please don't fix my case on Friday. So it can't be one day in a week. So we would accommodate, all right, the learned advocate is doing mediation work on Friday. All right, I'll give you another date. So as Mr. Jawad has said, there has to be a professional mediation personnel and not an honorary service. But some service now is better than no service at all. Institutional framework for mediation. There has to be a college, so to say, with a formal curriculum for having a mediation training for those who are interested. a curriculum in the colleges where law is taught on what is mediation, how to go about mediation, to ensure that the students who are interested in mediation have that, you see, inkling of an idea in the college itself. And then when they get into the bar, if the advocates are interested to be mediators, of course they must have some idea of advocacy. Now Supreme Court said even to be a civil judge junior division, you will have to have 3 years of practice. That has been re-recognized now. I also feel that mediators who are have a law degree must have some kind of an experience in the bar, if not 10 years, at least 5 years, and then they can undergo a specialized training. There must be an exam after the training. There is no exam after the training for persons who become mediators. They just get a certificate saying, yes, you have attended the training, which is signed by the president of the mediation center, but no exam is conducted. I feel they have to be examined. And institutional framework for mediation must incorporate all this. And of course, mandatory mediation in certain types of cases where I have said the sector-wise mediation, that is also an important suggestion. So thank you, Mr. Jawad. Now I request Honorable Sri Justice Gurmeet Singh Sandawalia, Chief Justice, to give his remarks as the co-chair.
Thank you, Chair. Co-chair also, the other members on the dais, other persons who have come from all over the country. If you all notice the topic which we all have, it is a very wide topic, and as we were just discussing co-delegates, this kind of a topic, just these topics could make the conference go on at least for 2 days, because it requires a lot of thought process. I'm thankful to the organizers to give us such a ripe topic, I would say. I would like to just touch briefly by giving some various examples on issues which we usually deal with by way of our judicial experience also. I happen to be at present in the state of Himachal. So we are facing issues like development projects, like 4-laning, which is taking a toll, railway lines being set up, which is leading to collapsing of hillsides. It's affecting the landowners and the houses of locals. These are issues and disputes which I would say that the contractors are having the right of way on account of acquisition, principle of eminent domain, as we all know. There's muck dumping causing landslides and damages to the environment, is leading a permanent scar on the ecological footprint of the state. We are setting up river valley projects for power generation, a major source of revenue for the state. Is leading to harnessing of rivers, the tributaries, is leading to displacement, I would say, of villages, which is where agriculture land is scarce. There's a lack of public employment by the said companies who take benefit of all this development which is taking place. Maybe, as they say, the cost of the environment also has to be equally protected. Now, is there enough a redressal system by all these infrastructural companies in the form of maybe employment to be given to the local displaced persons, and the lack of sometimes for smaller projects, lack of environmental clearance, which saves them from this? These are issues which we see that the government would have to address. There are issues for 60 years, Pong Dam ousties have not been able to get their dues. The state of Rajasthan is a beneficiary, but not the second generation is still fighting for what their rights were. The setting up of industrial belts and leading to pollution, the groundwater by industrial units, the lack of inaction by the pollution control boards, leading to a lot of litigation coming up on the public interest side, the percolation effect of the industrial waste. These are matters of grave concern. For all this, what is the requirement of the day? is to collaborate and action taken by involving the state, the corporate bodies, the individuals, and as we just talked about, there is a little gray area regarding the bar, because under section 6 in the first schedule relating to NGT matters, whether these matters can be resolved by way of mediation on a process which these companies having the corporate responsibility need to put some mechanism in place. This it's not just the state of Himachal, I would say. We talk about mining, displacement of tribals in this other states for huge contracts, and balancing the interest of the stakeholders and the tribals who are not aware of their rights. As also pointed out by Javed also, as I said, 40 hours. We have such a wide assorted range of mediation areas. Now we would have to require some kind of trained people in all fields and domains. So this is, we will have to go back to education, and at the first instance whether you will have to choose that in which area in mediation also you want a specialization. National parks displacements, conflict with the wildlife protection. These are again issues which require a lot of thought, and it is only the government who can put it in place. We have other issues again, let us say the states of Punjab and Haryana and Himachal, they're fighting over water issues, and there should be a statutory institution in place which is the need of the hour for this. The infrastructure takes a beating in the meantime because of lack of interest due to the litigation. I would also briefly touch the issue of medical negligence, the Bolam principle, the doctor following whatever is to the best ability. Now, the patients are up against reputed corporate houses. Medicine, as we know, has been commercialized, and it is the personal injury the patient has to endure. An open dialogue is required, and the trust has to be created between the patient and his LRs to find a mutually agreeable solution to all the issue without assigning any blame as such. The power imbalance is apparent. There is almost a 10% litigation on this side in the consumer courts due to surgical complications, wrong diagnosis, informed consents, overcharging issues. Thus, matter of in-house procedure to be put in by such big institutes who are running hospitals on a commercial scale. So firstly, resolve the issue within their own premises, and then to reduce the litigation by setting up a mediation board. Another aspect what I would like to touch is on the criminal justice and juvenile cases. It's a restorative justice offers as a shift between the harm and the obligation to repair. I would put it like that. We would require NGOs, an intervention required where crimes sometimes are offenses which are arising out of emotional issues of relationships. Both the victim and the accused, the police may have to require a change in their approach. The Act again says a bar for prosecution of criminal offences, the first schedule, especially only limiting it to the compoundable offences. This also might require a relook, especially in cases of consents where sometimes children are born out of such relationships where parties are willing to reconcile. But the question is that if we are sending them behind bars, the restoration is not possible. So I thank you. I think, as Javed also pointed out, lunch seems to be awaiting everyone. Thank you so much.
Thank you, Chief Justice Andawalia, for your thoughts. You have spoken about Himachal Pradesh specific problems where there can be mediation in the government discharging its duties regarding project displaced persons. That is an important point. I would like to also add, since learned Attorney General is here, why not mediation between states with regard to water issues or border issues? Mediation between states could be there, one state and another state. Similarly, mediation between the central government and the state government Then you have also spoken about restorative justice and mediation in that regard. I thank you for your valuable thoughts. I think I can now just wind up by saying that in India we have talent, skill and experience in mediators. They are like the best in the world. They act in conciliatory capacity, and therefore the faith in the impartiality and independence of the mediator is important. I need not go into all those aspects again, but I would say that every mediator must bear in mind that his or her conduct has a direct bearing on the people's perception to participate honestly in mediation proceedings. The possibility of the development of a formal code of conduct that would serve as a guide to such mediators in India must be explored. The establishment of a dedicated Mediation Council of India is a favourable step in this direction. And lastly, I would like to quote from the Supreme Court with regard to the role of lawyers in mediation, what the Supreme Court has said in Patil Automation Private Limited, quote, "The realization has been growing over a period of time that formal courtrooms, long drawn-out proceedings, procedural wrangles, mounting and crippling costs, delay which never wanes but only increases with the day, that at least in certain category of cases, mediation can be the way out." With this, I thank each one of my esteemed panelists for their valuable suggestions, and I thank the learned moderator of this session, and I thank each one of you for your kind attention, particularly before a delayed lunch. Thank you and namaskar.
To ensure time efficiency, the Honorable Chair has shared her thoughts and remarks on the address of the Honorable Co-Chairs simultaneously. I thank the Honorable Chair, Co-Chairs, panelists for sharing their valuable thoughts based on their experiences on the topics. I also thank the distinguished audience members for their attention. We hope the significant suggestions raised in this session will transform to action points. At this juncture, Shri Pitambar Acharya, Learned Attorney General Orissa, would like to make an announcement, please.
So thank you everybody. Now that the second technical session is over, we had plans to go for lunch after the third session. Since we are running behind the schedule, I am now requesting everybody to go for a lunch break. We should make it maximum 30 minutes, Chief Sir ne bole, but it may extend another 5 minutes. So we will try to finish the lunch by that time so that we can go for the third session early, because 3 more sessions are there and it would be presided by 3 honorable judges of the Supreme Court, so that we can, Law Minister has already reached, Union Law Minister, so now we can go to the lunch. I will request all delegates, except we have made 2 separate arrangements for all the honorable judges, both Supreme Court and High Court, both former Attorney General and Solicitor General in the upstairs. That is a separate entry. I request earnestly, humbly to all the distinguished delegates to go to the other dining hall. There is no difference, only for convenience we made it. So therefore, let us break for the lunch.
Good afternoon, distinguished delegates. May I now request Learned Advocate General of Odisha, Shri Pitambar Acharya, to facilitate the distinguished members on the dais. Honorable Shri Justice Arvind Kumar, Supreme Court of India.
Thank you. Welcome.
Honorable Srimati Justice Sunita Agarwal. Honorable Honorable Shri Justice Ashutosh Kumar, Chief Justice Guwahati High Court. Now, Honorable Shri Justice Arindam Sinha, Judge, Allahabad High Court. Honorable Shri Justice Shri Hari Shankar, Judge, High Court of Delhi. Honorable Shri Justice Gopinath Puzankara, Judge, Kerala High Court. Shri Sudarshan Reddy, Learned Advocate General for State of Telangana. Shri R. Sanathan Krishnan, Learned Advocate.
Justice K. Shanthanan, in fact, is a very reputed, one of the celebrated mediators of the country. He is the president of the Commonwealth Advocates Association and is a global mediator. So he moves globally. Today he has become regional. So I welcome him. He is a master orator and a erudite scholar and has many more laurels to his credit. I welcome you, sir.
Good afternoon, ladies and gentlemen. It gives me great pleasure to welcome you all to interactive session number 3 on the theme Mediation in State Litigations. This session will explore some of the most pressing questions before our justice system today, like how can we strengthen government dispute management mechanisms, what is the role of mediation in policy implementation and public interest matters, how do we build the requisite capacity among government officers and legal representatives to embrace mediation, making them well equipped to not just defend cases but resolve them as well, and what lessons can we learn from the best practices and successful case studies of mediation around the world. We are deeply honored to have with us an eminent and distinguished panel to guide this conversation. Presiding over this session as chair is Honorable Shri Justice Arvind Kumar, Judge, Supreme Court of India. A distinguished jurist with decades of experience, Justice Arvind Kumar has contributed significantly to constitutional and commercial jurisprudence and is deeply committed to promoting efficient dispute resolution mechanisms. Justice Kumar has also in the past advocated for and highlighted the important role that district judiciary can play in resolving any dispute through conciliatory mediation. Joining as co-chair is Honorable Shrimati Justice Sunita Agarwal, Chief Justice of the Gujarat High Court. Chief Justice Sunita Agarwal is widely respected for championing access to justice with a keen focus on ensuring that the justice system remains responsive to citizens' needs. Justice Agarwal is also a trained and certified mediator and was part of the very first batch of the Allahabad High Court that was trained in mediation and conciliation. We are further privileged by the presence of our distinguished participants, Honorable Shri Justice Ashutosh Kumar, Chief Justice of the Guwahati High Court, Honorable Shri Justice Arundam Sinha, Judge, Allahabad High Court, Honorable Shri Justice C. Harishankar, Judge, High Court of Delhi, Honorable Shri Justice Gopinath Purankara, Judge, Kerala High Court, Shri Sudarshan Reddy, Learned Advocate General, State of Telangana, and Shri R. Santhan Krishnan, Mediator and Advocate. With such an illustrious panel, I have no doubt that today's session will offer deep insights into how mediation can transform the state's role from being the largest litigant in the country to becoming a leader in resolution through mediation. I now invite our chair, Honorable Justice Arvind Kumar, to kindly open the proceedings.
Namaskar. I know we are running late, as usual, which happens in every conference. And every speaker seems to have overshot their time, and we do not propose to do the same mistake. Assuring you of completing this session within 1 hour, I would like to welcome all the dignitaries on the dais and my esteemed brothers, Justice Maheshwari and Justice Sanjay Karol, of the dais, and all the Chief Justices, the learned judges, the learned mediators, the learned advocate generals, learned advocates, and all the stakeholders of the mediation. On the different subjects, my brothers and sisters will be throwing light. However, I would like to share one experience of mine, which I hope and presume would be the subject matter of discussion in this session. This goes back to somewhere around 2002, when I was the Assistant Solicitor General in Karnataka High Court. There was a matter relating to acquisition, land acquisition. There was approximately about 392 cases pending. So with great difficulty, it was a matter relating to the defense estate. And we were able to bring about, after about 9 meetings, a settlement amongst all the losers of the land who are waiting for compensation being paid for approximately around 17 years. So we thought that the matter has ended fruitfully, and the settlement agreement was drawn and it was proposed to be signed. and it was signed by all the claimants, that is the land losers. And when it was sent to the Defense Estate Office and then subsequently to the Secretariat, one of the secretary who was supposed to sign, he said, I refuse to sign. We were all shocked. We asked as to why, what is the reason that you don't propose to sign, put your signature. And everyone has agreed. Even your officers had participated in all the 9 meetings as to what is the reason why you do not want to put your signature. His answer was simple, straight, and candid. He said, sir, I have worked for 31 years, 2 months, 17 days. I will be retiring in another 2 months, 22 days. The moment I sign, I will get a notice from Vigilance Commissioner. I do not want to sign. You blame me, you curse me, do whatever you want, I will not sign. You get it signed from any other officer. I said, by this process, do you know that you will be saving around approximately 280 crores to the exchequer? He said, and I also told him, if you don't settle, additionally you will be paying around 400 crores more. That is, in the process, 680 crores is lost to the exchequer. He said, sir, it is not my headache. I will not sign because I will be in problem. At this fag end of my career, I do not want to get into the problem. This is the basic mindset in majority of the officials in state litigation. This is number one. Number two, during COVID period, we wanted to have a Lok Adalat and mediation. So we said we will propose e-mediation and e-Lok Adalat. In this, when I was just seeing which are the best cases which can be settled through mediation, I found out one land acquisition execution case which was pending in a remote taluka court for past 27 years, execution petition. And when I got the papers and looked into it, I saw that the award was passed by the special land acquisition for 23,000 rupees, enhanced by the reference court to some around 70,000. High Court had enhanced it to 1,85,000 and it had been affirmed by the Supreme Court. And out of this 1,85,000 plus interest, solation, 15% interest, including everything, at the time the execution petition was filed, it was around 9 lakhs. Friends, do you know what was the amount that was paid for all these 23 years by the government? They had paid 72 lakhs and still the execution petition was pending, because every time he used to file an execution petition, an application for attachment of movables, get the attachment order, go to the deputy commissioner's or district magistrate office. Under the threat of the movables being attached, they used to deposit 1 lakh, 2 lakhs, and it was a win-win situation for all the stakeholders, including the officials of the land acquisition officer. This is another type of mindset. When I told the chief secretary, this is what you have done, and there are so many number of cases pending, he said, sir, please give me the list. I will see that the amount is deposited. Though it was COVID, the chief secretary then was very kind enough and he agreed, and they deposited somewhere around 56 crores, which disposed of around 7,000 execution petition cases. One decision by the chief secretary. Only thing is, we had to have a meeting to convince him as to why the state has to change its mindset. With this preface and being conscious of the fact that 46.78% of the litigation pending in all the forums relates to the state, either the government, union government or state government or statutory bodies, it is high time that we think of settling the dispute through mediation. There are various subjects lined up, that is strengthening the government dispute management mechanism, role of mediation in policy implementation and public interest matters, capacity building, best practices, reducing the burden of state legislature. And we have 8 speakers here lined up to speak on these subjects. So before I conclude, I would only highlight what the Union of India has done in the recent past, which can be taken as a cue by all the stakeholders. That is, they have developed what is known as LIMS, and software that is called Legal Information Management and Briefing System. It is a web portal where you can track and monitor the court cases involving the government. This is crucial. You will know as to how many cases you have on hand and what are the types of cases. You can be of informed decision, like grouping of the same, deciding the policy changes, and to ensure that it doesn't occur in future also. And I found out from the web portal of these LIMS that there are around 27% of the union government's cases which accounted, apart from railways, defense, labor ministry, which accounts to about nearly 39%. When such data is available, the government can target the biggest contributors and ask, why are we litigating so much in this particular area? Can we not resolve this? Yes, my answer is yes, it can be resolved by simple mediation. For that, the legal trained mediators' efforts are required, and I know there are number of mediators who are present in large numbers here who can make a valuable contribution. Only thing is, the state and its official machinery has to make up its mind to engage these mediators in ensuring that the government disputes also can be resolved. With this preface, I throw open the House for discussion, and the first speaker will be Justice Ashutosh Kumar, Chief Justice of Guwahati High Court. He would... Okay, yes, sorry. So he will be giving us insight on some of these subjects. Over to you, brother.
Thank you, sir. My salutations and courtesies to everybody in the hall. Justice Arvind Kumar on the dais, Honorable Justice Maheshwari, Honorable Justice Sanjay Karol, the learned Attorney General, Honorable Justice Sunita Agrawal, all the persons sitting on the dais, and all the stakeholders. Now, let me just be brief with this formalistic address, because the time is short, and as taking clue from what sir has said, state mediation is not a soft option. It requires courage, it requires skill, and it requires an understanding whether this skill has to be used for mediating. Now, my experience has been somewhat different, but it tells the same story what Honorable Justice Arvind Kumar just said. There was a lady in her late 60s, while alighting from a bus, she fell down, hurt her legs, and she had to be operated upon. She challenged the bus company, and she asked for compensation from the bus company, which was very vehemently litigated against. And when the matter came to court, the bus company was very rigid that no compensation is awardable because there was no mistake of the bus driver, there was no mistake in plying the bus. So why is it that the company would give compensation? In fact, the lady was reckless. She started alighting when the bus had not stopped. At this point of time, the judge, I was an onlooker, I was not participating there, but the judge at that point of time, he just put a simple question that, well, I believe that somebody from the bus company, management of the bus company is here. Would he raise his hand? And then a very senior officer from the bus company raised his hand. He was asked to come forward. And when he came forward, the judge of the High Court, he asked him, well, would you have taken the same stand if the lady were to be your mother? And then this man was absolutely flummoxed, and he said, no sir, let me get back to you tomorrow. And out of interest, I went and saw what happened next day. He said that, well, the company is ready to pay compensation for the old age, for the fact that she has been permanently injured in her knees. So I think this would not cost the company anything more. This is an earmark fund for compensation. The lady got up on her crutches And she says that, well, I relinquish my claim. I don't want anything to be done now. I don't want even a rupee as compensation. Everybody was surprised. Why? I mean, after this long drawn battle from all courts, why do you say no? She says that I just want vindication of my rights. And if the bus company has agreed to pay me compensation, I am happy without compensation because my son looks after me well. So this is the power of mediation. And why I say that I took clue and my experience had been different is that this officer from the bus company, he realized the importance of mediation and conceding. So as I said in the beginning, state mediation is not a soft option. Now, so far as the concept is concerned, it is no longer state mediation. Mediation in state litigation, these are not aspirational now. It is an imperative duty, it's an imperative obligation. Now, instead of getting back to the rhetoric of the importance of mediation and state mediation and state litigation, we all know that courts are facing the burden, the weight of disputes where the state is a party, be it service litigation, land and rehabilitation claims, welfare and regulatory grievances. They consume public money, and therefore there is a great necessity of having a robust system in the departments. Now, let me give you a blueprint which is slightly different from what is conceived of in the Act of 2023. So if justice is to be fair to both sides and if it has to be effective, the state must evolve a dispute management mechanism. So institutionalizing it, the process would be that every state department, say finance, say public works department, say welfare department, they can come up with a dispute resolution unit with officers or the unit reporting to the principal secretary or the secretary of the department who would have the backing of the government, where they would not shy away from taking a decision which might on face of it appear to be conceding to the claims of private parties. But in the ultimate analysis and going by the state litigation policy, which I believe every state has now framed, it would be a very speedy and a very good way of resolving the dispute at the threshold. I thought of this special dispute redressal units in the departments. They should be assigned a special task, and what tasks can be performed by them is what I have listed as the first is to triage the incoming disputes unless they catalog it and make more imperative claims as the first ones to be resolved. I think they will get detract from the real way to resolve the dispute. Then maintaining a central docket of all cases involving monetary threshold, say anything above 5 lakhs, 10 lakhs, depending upon the payability of the state. So that should be taken second. Then allocating cases to departmental conciliators. And who are these departmental conciliators? No specific need for hiring or engaging their services. If capacity building is given a fillip, if the officers of the department are trained properly with the mindset, see, when long time back, about 14, 15 years ago, I had undergone a 40 hours mediation training. And somebody from Bangalore was telling that, you see, you need to suggest to the parties something out of the box which will immediately attract their attention. And this helped me in resolving many of the disputes, husband-wife dispute of course, governmental disputes also. In Lok Adalats, these skills come very handy. So if the training curriculum is made mandatory for officers of the department, it would go a long way in capacity building and that getting translated into resolution of disputes without any difficulty. These are easy ways of understanding what can be done without getting stuck up with the procedural aspects and the rules. What can be done is a training to the officers of the government with the backing of the state government, the mindset of the state government that, well, instead of going to litigation, it could be resolved very amicably. These welfare or welfare measures not being given to parties, or the denial of permits, these could be settled at the governmental level without any difficulty. There is something called, in statistics and in various other departments, they have come out with a concept of key performance indicators. So these state dispute redressal units are beset with key performance indicators, as was spoken by the Advocate General of Maharashtra. If we have the statistics of it, those experiences could be shared with other departments, other states. Settlement of cases often require releasing of public funds, which may not be very easy for an officer of lower rank to immediately accede to. He has to have the approval of the head of the department and the government. So therefore, if this disposition could be made to the concerned conciliator, who would more often than not be an officer of the department, I think the work would be seamless. Then there is another aspect which I wanted to sort of flag, is the purposes of bringing in mediation for community disputes. Could it be done? This is a very important question which is asked. Can it be done in a welfare state? Of course it has to, but who would decide? And if the government, which is a welfare state, whether it would be amenable to any mediation proceeding. After all, what would the state look up to? In fact, they are under an obligation to decide to take welfare measures. So whether this could be done, quite often this question is asked, and the answer is, to my mind, yes. But it has to be done carefully, transparently, and with safeguards. More importantly, it has to be kept in mind that there should be a provision for judicial intervention. That judicial intervention is required to be preserved. If we close it at that, perhaps people would not be more forthcoming in coming to this forum of mediation. Because the moment they realize that this mediation, where the government is a party and government officer is a mediator, and he is the conciliator, he may not agree, and then that would be the end of the option. Perhaps that option would not be exercised by the party. And therefore, there should be a preservation of a limited judicial review with respect to that. Though it may again become tardy, the process may linger, but then that has to be there for the confidence of the public at large. So, just to cut the, any other statement would be a repetition of this concept, but we say that we have a domestic foundation on which a superstructure has to be built. Section 39 of the Act of 2023 needs to be incorporated. Something else has to be thought of by the government as a measure. And the law has provided us the tools. The courts have encouraged ADR. So where is the difficulty? In this connection, I must say that now what is necessary is administrative will, the discipline and imagination. If the state builds robust dispute resolution architecture, like I said, special disputes redressal units, policy of fast mediation, capacity building, e-mediation platforms, the benefits would be very tangible in a very short period of time. There will be better delivery of services, it will reduce the cost of administration, the courts would not be clogged, and there will be a greater public trust on the government. Well, rest other speakers would dwell upon. Thank you very much for your attention. Sir, anything more?
Thank you, Brother Justice Ashutosh. Before proceeding further, I just wanted to bring it to the notice of my esteemed brothers and sisters that on account of time constraints, each speaker can restrict his or her highlights for 5 minutes. So that at the end we may have at least 5 minutes for interactive session or any question and answer, and to wrap up the session. With this, I request Justice Arvindanand Sinha, Judge, Allahabad High Court, to share his thoughts, please.
Honorable Chair, Honorable Co-Chair, my distinguished, the distinguished panelists, Chief Justices, Judges, Honorable Judges, distinguished members of the audience, delegates, good afternoon. The Learned Advocate General of Odisha invited me and put me on as a speaker, I think on subjective satisfaction. I do not have any formal training in mediation, so I took this opportunity to learn a bit about mediation relevant to the topics. I'll share with you what I have learned. Mediation is a key form of alternative dispute resolution which offers confidential, swift and cost-effective way to settle disputes involving a neutral third party who facilitates dialogue between the disputing parties, helping them to identify core issues and arrive at a mutually agreeable solution collaboratively. The courts must proactively use their powers under Section 89 of the Code of Civil Procedure to urge government bodies to settle disputes through alternative dispute resolution processes. The foundational principles for referring a case to ADR originated from the case of Afcons Infrastructure Limited versus Cherian Varke Construction Company Private Limited, reported in 2010, Volume 8, SCC, page 24. The judgment elaborated on, amongst others, the scope of disputes that can be mediated. I want to place before you paragraphs 36 and 41 of the judgment. This is 2010. Paragraph 36. If the parties are not agreeable for either arbitration or conciliation, both of which require consent of all parties, the court is to consider which of the other three ADR processes, Lok Adalat, mediation and judicial settlement, which do not require the consent of parties for reference, is suitable and appropriate, and refer the parties to such ADR process. If mediation process is not available for want of a mediation center or qualified mediators, necessarily the court will have to choose between reference to Lok Adalat or judicial settlement. If the facility of mediation is available, then the choice becomes wider. If the suit is complicated or lengthy, mediation will be the recognized choice. If the suit is not complicated and the disputes are easily sortable or could be settled by applying clear-cut legal principles, Lok Adalat will be the preferred choice. If the court feels that a suggestion or guidance by a judge would be appropriate, it can refer it to another judge for dispute resolution. The court has to use its discretion in choosing the ADR process judiciously, keeping in view the nature of disputes, interests of parties, and expedition in dispute resolution. Paragraph 41. Having regard to the provisions of Section 89 and Rule 1A of Order 10, the stage at which the court should explore whether the matter should be referred to ADR processes is after the pleadings are complete and before framing the issues, when the matter is taken up for preliminary hearing for examination of parties under Order 10 of the Code. However, if for any reason the court had missed the opportunity to consider and refer the matter to ADR process under Section 89 before framing issues, nothing prevents the court from resorting to Section 89 even after framing issues. But once evidence is commenced, the court will be reluctant to refer the matter to the ADR processes, lest it becomes a tool for protracting the trial. The greatest challenge in mediating with the government is the fear that a settlement can be later revoked by a bureaucratic hierarchy. The law has now addressed this under Section 27 of the Mediation Act 2023, which places a mediation settlement agreement at the same level as a judgment or decree of the court. This provision holds the state accountable and provides clear and swift enforcement mechanism for the party. However, to best of my information, this section has not yet been notified. In cases where the central or state government is one of the parties, the application of the Mediation Act has been restricted to either commercial disputes or other disputes as notified by the government, which excludes a vast number of other civil disputes involving state and central authorities from the process of mediation. Establishing a selective gateway for resolution, wherein the government is not automatically bound to participate in mediation in all civil matters and retains the prerogative to notify which types of disputes it is willing to participate for settlement by mediation. However, the judiciary's push towards resolution of disputes through mediation extends to government entities involved in commerce and contracts. In Patil Automation Private Limited versus Rakheja Engineering Private Limited, reported in 2022 Volume 10, Supreme Court Cases 1, page 1, the Supreme Court upheld the constitutionality of mandatory pre-institution mediation under the Commercial Courts Act. The Supreme Court said, Section 12A of the Commercial Courts Act 2015, which deals with pre-litigation mediation, and I quote, cannot be described as a mere procedural law. Exhausting pre-institution mediation by the plaintiff with all the benefits that may accrue to the parties and, more importantly, the justice delivery system as a whole would make Section 12A not a mere procedural provision. The design and scope of the Act, as amended in 2018, by which Section 12A was inserted, would make it clear that Parliament intended to give it a mandatory flavor. Any other interpretation would not only be in the teeth of the express language used, but more importantly, result in frustration of the object of the Act and the rules. The same provision has been inserted in the Mediation Act 2023. While mandatory pre-litigation mediation, except for suits seeking urgent interim relief, risks compromising the voluntary nature of mediation and turning it into a mere hurdle, the Supreme Court clarified in Yamini Manohar versus TKD Kirti, reported in 2024 Volume 5, SCC 815, that the need for urgent relief must be evident. The court ruled that the words contemplate any urgent relief grant the court the power to determine satisfaction based on the plaint, documents and facts to bypass mediation. This ruling is a clear message for contractual or commercial disputes, even for those involving state-owned enterprises, that an honest attempt at mediation must precede the filing of suit. There are certain situations where the state is on both sides, such as interstate river or boundary disputes. Solutions become more about cooperative federalism and political facilitation, governed at its core by the Constitution of India rather than mediation. However, a successful mediation in these cases will result in a flexible, durable, and easy to implement solution as compared to a binding judicial award. The Supreme Court had even made an attempt at mediation in the Ram Janambhoomi case, appointing a 3-member panel headed by retired Justice F.M.I. Khalifullah with Sri Ravi Shankar and Senior Advocate Sri Ram Panchu as members. It being a politically sensitive issue, to enable the parties to reach a common ground, the Supreme Court made the effort to push the parties for a settlement that achieves overall healing as the most desirable form of justice. This principle applies directly to interstate conflicts, where an amicably mediated and mutually respected solution is far more durable than a tribunal's binding order. Deeply rooted in the principles of democratic decision-making, mediation empowers one to take ownership of the resolution process, fostering understanding and cooperation rather than confrontation. In large-scale service matters like pension or seniority, a mediation that establishes a model settlement for a few petitioners can be applied at length by the government in resolving thousands of similar pending cases without the parties even entering the tiresome judicial process. Thus, there can be transforming a case-by-case legal battle into an efficient policy-level solution, reducing the judicial burden. Another aspect is that in disputes concerning the state, the mediator's identity is crucial, as the authority must command respect of the government officials. The Mediation Act 2023 covers this issue to an extent by giving primacy to the choice of the parties involved, and in cases where it cannot be decided by the parties, then to the choice of the mediation service provider. On an application of the party seeking to initiate mediation and further giving the mediation outcome the status of a decree. The question here is whether the authoritative government agencies will honor the resolution achieved through mediation under the mediator so assigned, or if they will prolong the case by appealing to the judiciary, further increasing the judicial burden. The steadily rising volume of disputes has been straining the capacity of conventional courts and draining the public exchequer. This surge has led to prolonged litigation timelines that have already eroded confidence in timely justice. The resultant gap can be filled by shifting towards alternative dispute resolution methods like mediation, which offer faster, accessible, and cost-effective pathways to justice, provided both parties respect the outcome. In the Act of 2023, the grounds for challenging these agreements are also very narrow, namely fraud, corruption, impersonation, or if the dispute is unfit for mediation under Section 6. Apart from mutually reached solution, it is essential to ensure sufficient capacity building training programs for the government officials and legal representatives. The success of mediation hinges upon the competence and mindset of the officers and lawyers representing the state. Here, there must be ratification on decisions taken by participation in mediation. This is yet to be achieved. The creation of the Mediation Conciliation Project Committee, MCPC, by the Supreme Court following Salem Advocates Bar Association versus Union of India, reported in 2005, Volume 6, SCC, page 344, and the establishment of the Mediation Council of India under the 2023 Act are evidence of a sustained effort to raise the dispute resolution quotient of the country. This includes training on non-adversarial negotiations and mediation to ensure that the officers become solution facilitators rather than rule enforcers. There are instances where the government itself is a party to a dispute, land acquisition being a notable example. In the case of Bondu Ramaswamy versus Bangalore Development Authority, reported in 2010, Volume 7, SEC, page 129, the Supreme Court put emphasis on the importance of designing tailor-made schemes for particular acquisitions, which can ensure the process is efficient, conflict-free, and advantageous for all stakeholders, stressing the need for proper planning, effective counseling, and timely mediation with affected land losers to facilitate smoother outcomes. In the case of Vikram Bokshi versus Sonia Khosla, reported in 2014, Volume 15, SCC, page 80, the Supreme Court held, and I quote, "There is always a difference between winning a case and seeking a solution. Via mediation, the parties will become partners in the solution rather than partners in problems. The beauty of settlement through mediation is that it may bring about a solution which may not only be to the satisfaction of the parties and therefore create a win-win situation, the outcome which cannot be achieved by means of judicial adjudication. While providing satisfaction to the litigants, it also solves the problem of delay in our system and further contributes towards economic, commercial, and financial growth and development of the country." The nature of litigation itself is adversarial, which can escalate conflict rather than promote mutually respected solutions. Sometimes to the extent of subjecting the litigants to public media trials, which may compromise their right to privacy. These challenges have made alternative dispute resolution methods like mediation quite appealing. Unlike lengthy trials, mediation is cost-effective and confidential, safeguarding the privacy of both parties. Its collaborative nature fosters mutual understanding. Moreover, with its people-centered approach, mediation allows for flexible and customized solution, ensuring outcomes that are both practical and mutually satisfying. I have one suggestion. That is, every case cannot be, every case in which the government is involved or a government institution is involved cannot be referred to the topmost legal officer. So, there can be outsourcing for purpose of obtaining an opinion as to how or what can be done by way of negotiation in a mediation. Thank you very much for your attention.
Thank you, Justice Rabindan Sinha, for having explained the nuances of the AFCON's case and in what method the capacity building by the government officers can be taken up. And the next speaker would be Justice Hari Shankar, Judge, High Court of Delhi. Again reiterating what I said in the beginning, having time constraint. So we request the speaker, my next speaker, to be as brief as possible. And I know you will definitely be very brief.
Will do.
Thank you. Thank you.
Will do.
Over to you, Justice.
So, in the interest of brevity, I am first cutting short my felicitations. Honorable Justice Arvind Kumar, by Justice Mishra from the Supreme Court, Honorable the Attorney General, my Chief Justice Upadhyay, and all other esteemed dignitaries on and off the dais. I'll take I'll just give some bullet points of what I have to say because we are short of time. But I want to, taking a cue from the example which Justice Arvind Kumar gave, I have a very interesting example to cite. It's something which many people know about, but especially people who are in tax. So the largest central excise case, at least at that time, which was against any company, was an 850 crore dispute against ITC, in which my father, who was at that time Additional Solicitor General, he had appeared on behalf of the government, both before the Commissioner of Customs, the Customs Tribunal, as well as the Customs Tribunal. So the Commissioner of Customs, it was almost a foregone conclusion. He confirmed the demand of 850 crores. Against that, the ITC went to the Customs Tribunal. It was heard by a bench of Justice UL Bhatt for almost a division bench for almost 3 months. And thereafter, his Lordship also confirmed the demand and dismissed ITC's appeal. Thereafter, the matter went to the Supreme Court. In between, they introduced what was called the Kar Vivad Samadhan scheme, which was in the form of a mediation, where if you declare 50% of their demand against you, you escape prosecution, etc. So ITC came forward and said, the demand against us is 850 crores. We are willing to pay 425 crores. Please exempt us from prosecution. They came to my father, asking him, should we agree to this? He said, certainly, because it's a purely legal issue. We don't know which way it will go in the Supreme Court. You may end up losing the entire 850. So better don't be penny wise, pound foolish. Agree to the 425, close it. But the Kar Vivad Samadhan scheme had a clause in it which said, if prosecution is commenced before the matter is filed in the court, you can't get the benefit of the scheme. So some Chief Commissioner of Customs or the member of the board at that time was very, I know who it was, I won't take names, was very brilliant. That member said, no, 850 crores is at stake. Don't go by what the ASG says. One day before they go to the Supreme Court, start prosecution. So they filed a charge sheet a day before they filed the appeal in the Supreme Court. The result was, then they came to my dad saying, will you appear for the Union of India in the Supreme Court? He said, nothing doing. You acted against my advice. Now you take whatever happens. It came before Justice Rumapal's division bench. Justice Rumapal told them, please settle this matter. Though it's a tax case, normally we won't ask for settle it, but settle it. They again were very clever. They said, nothing doing. We won't settle it. Ultimately, the entire appeal was allowed. 850 crores went down the drain. So this is an example of where, though it was a case where they could have settled it, a typical example of what my Lord Justice Arvind Kumar said, where the officer said, look, it's such a huge amount. How can we settle it? God knows what will happen. And the result was the entire money was lost. So that was a typical situation where it was a government litigation which could have been settled up to the Supreme Court, the advice was given. Now that said, On the issues before us, I have just 2 or 3 points to say so that I don't cross the time. The first thing is that when we are talking of government litigation, they can be of 2 types. Either they can be litigation which pertains to statutory liabilities or statutory rights, or contractual litigation. Contractual litigation is much more amenable to mediation because it's a contract. But where it is a case of a statutory liability or statutory rights, a major problem hurdle that appears is that you can't by mitigation take away what is flowing from a statute. So you can't unless that is also by statute, like the Karvivada Samadhan scheme was. Otherwise, a mediator cannot sit down and say, all right, this party has to pay 50 crores excise duty which the party has evaded, and nonetheless between the two we'll settle and he'll pay only 40 crores. That can't be done in a mediation, it has to be statute specified. So in a mediation you cannot bring down the statutory liabilities. That can be done by a scheme which is itself statutory in nature. And otherwise, the maximum you can do in a mediation is to maybe say that you won't go in for prosecution, etc., provided you subscribe to a particular amount. That said, actually the government put into place 2 very laudable mediation schemes which were dealing with statutory liabilities. The first was the Karvivad Samadhan scheme and the second was the Sabka Vikas scheme. They have resulted, as I believe, in huge amounts of revenue realizations because the parties came forward. They said, yes, we don't want to go in for prosecution, etc., we are willing to pay this amount. And whatever is the amount that is being demanded, and they had, I think, some reduction of the amount was permissible. In Karvivad, it was 50%. I don't know what it was in Sabka Vikas. But whatever it was, on those terms, it was settled. And the company escaped prosecution, and the entire thing came to a halt. A huge amount of revenue was earned by the government. So it is not as though government disputes are per se not amenable to mediation. That said, at one time, now I'll just come to what were some of the main problems that arise in this case. One of the major problems is reflected by actually a statutory provision which was section 32 of the Customs Act. In fact, I don't think there is any such provision ever in any other statute, thankfully. That was a provision which dealt with the constitution of the Customs and Central Excise Settlement Commission, which again was, so to speak, a mediation forum, but it was not a real mediation because you had to admit your liability. And if the Settlement Commission felt your liability was not correct, they can disregard your settlement. So there was no question of 50-50. Section 32 of the Customs Act says, and it's something which I must read, because it says the chairman, vice chairman and other members of the Settlement Commission shall be appointed by the central government from amongst persons of integrity and outstanding ability. This is the first and last provision I have seen in any statute which says you must have a person of integrity as a member of that commission, as though in all other posts you don't need persons of integrity. But the point is that, so they put this in their place for a reason, because Settlement Commission or any mediation proceeding normally is not amenable to further challenge. So they said it has to be by persons of integrity who settle it, and so so that brings in the element of, you see, trust. You must trust the person who is actually being empowered to enter into the settlement scheme. So there are basically, as I see, only 2 solutions for this. First, you must recruit persons of unimpeachable integrity. So the persons at the higher echelons of the government who can mediate settlements in sensitive disputes with parties, they must be persons of outstanding integrity. If they are persons of outstanding integrity, then you can't question it, because even in the Settlement Commission, I can't say it lived up to that statutory hope. But they must be persons of outstanding integrity. And the second is to take from what in the morning was pointed out, section 49 of the 2023 Act is a step in that direction, because it immunizes the officer who comes in who negotiates this mediation in a case of a mediation with a citizen. They must enforce section 49. If you enforce 49 and you ensure that the persons who are selected and who are empowered to enter into mediation in government litigation are persons of integrity and ability, then I don't see any reason why government litigation or disputes between citizens and the government cannot be subjected to mediation. The only other point which, in the interest of time, I'm only now talking of one other aspect, which was the last point in our sequence of points which was put to this panel, which is the nature of government disputes which can be settled by litigation. One was like Honorable Dr. Justice Nagaratna was pointing out in the morning, though they say NGT is out of the province of the Mediation Act, there is no reason, even in a pollution control case or in a case of environmental pollution, if let's say an industry is polluting and the industry is willing to put in place measures to minimize the pollution or to eradicate the pollution, which will involve a huge amount, and the citizens are seeking compensation, some kind of a mediated resolution is not possible, cannot be attempted. Of course, without in any way sacrificing the environmental concerns to any degree. If there can be a mediated settlement by which maybe even the government can pitch in some amount or the industry can pitch in some amount and the compensation can be suitably moderated, and it can come to a win-win solution for everyone so that the environment is also saved and the citizens are also not subjected to environmental pollution. So that is one possibility. The second is commercial matters, of course, can be subjected to mediation. One of the kind of disputes which is specifically noted in our agenda are service matters. Now, for example, I've been sitting on the Armed Forces service roster for almost the last 6 months, and we find several cases which can be mediated. We have cases of persons who are coming for pension, who are coming after several years. So then the question is how much arrears will you give? That amount can be mediated. We have labor matters where persons are brought back into, are reinstated in service. In the meanwhile, their employer may have gone into the doldrums. He may not have money to give back wages. Back wages are awarded. That can be mediated. There are so many aspects. In fact, as I see in Lok Adalats, labor disputes are settled, a dime a dozen, any number of them are settled. So those are all aspects in which litigation can considerably be brought down on mediation. Similarly, we have cases of land acquisition, solatium. Solatium can be a matter which can be subjected to mediation, though of course a 4/9 may not be amenable to mediation, but amount of solatium to be paid depending on the area where the land is situated. These are all aspects which can be decided in mediation. And they are all, of course, litigation with the government, but there is no reason why they cannot be settled. So if we put the requisite the infrastructure in place, infrastructure both statutory as well as on ground, then there is no reason why government litigation cannot be mediated. And I am sure that with the Attorney General has already been requested by persons much senior to me to try and see that the Mediation Act is implemented. If all the provisions of the Act are put in place, I think a large chunk of government litigation can be settled by mediation. We must realize that mediation is now no longer alternative dispute resolution. It is as much dispute resolution as anything else. So with that, I hope I have stayed within the time constraint. Thank you very much, and I am very grateful for having invited me.
Thank you, Justice Harishankar. Now I request Justice Gopinath, Judge Kerala High Court, to throw light on the subjects which is now the subject matter of this session.
Thank you. Thank you, sir. Justice Arvind Kumar, Chair, all other distinguished panelists, and distinguished guests, my brother and sister judges. I will strictly follow the timeline set by the Chair, and I wish to add to what Brother Justice Ashutosh, Chief Justice Ashutosh Kumar had just said. Now, I believe that I have noted out something which is completely outside the point of mediation. Finland is supposed to be the country with the happiest persons in the world. Now, I read something interesting about Finland. It said that people have trust in each other. They don't view each other with suspicion. Now, I think this is the basis on which any successful mediation will work. And without trust, whether it be government on one side, citizen on the other, trust is absolutely essential for mediation to succeed. I agree with Brother Harishankar when he said that all kinds of government litigation may not be suitable for mediation, because as he correctly pointed out, tax disputes, of course, they have kept it out in the first schedule. But what I note interestingly is the first schedule also contains the land acquisition matters, which I thought, as the Honorable Chair had pointed out, those are cases where possibly mediation would certainly work. I can't understand why land acquisition disputes are kept out of the mediation in the first schedule as item number 12. So this is one aspect. The other aspect which I would like to point out is that mediation or any other form of alternate dispute resolution can be successful only if litigation becomes expensive. For some reason or the other, as judges, we have stopped imposition of heavy costs on the losing party. We rarely see judgments where we mandatorily impose costs. I think that one way of making mediation more effective or any other alternate dispute resolution more effective would be to impose heavy exemplary costs on the losing party. I say this because I have seen in some jurisdictions abroad, after the hearing of the main dispute, they have a hearing on the costs to be included, costs to be paid by the losing party, which includes the solicitor's costs, the barrister's costs, cost of court fee, completely, and that takes place, that hearing is as good as the main hearing because people fight over costs. So I think that costs, by ensuring that the losing party in a court litigation is imposed with heavy costs for having litigated throughout the court system, I think that is one way which we can enforce the success of alternate dispute resolution. One other point, and I'm done. Section 49 was mentioned earlier. It has not been notified. Now, one issue is in a government where government is a party to a mediation settlement, the approval of the competent authority is made mandatory by virtue of Section 49. The problem that I see is Section 49 does not have a time limit for the competent authority to give approval. Now, this may create a problem because once the mediation settlement is arrived at, if the settlement is not approved by the competent authority within a time frame, it becomes a problem and it may give rise to a situation where one of the parties who has agreed to the settlement may back out from the settlement. So this is something that we have to certainly look at because we need a time frame for approval of the competent authority under Section 49. One other aspect is I suggest, the learned Attorney General is here, I am not suggesting for a moment that the faceless assessment scheme of the income tax under the Income Tax Act has become a success. But in order to ensure that there is no bias in the decision making by the competent authority, possibly the government could think about having a system akin to some faceless assessment scheme where the persons who the competent authority is not known to the parties who are entering into a mediated settlement so that you can avoid, and later possibly the government officers who take the ultimate decision can also be saved from any allegation of bias in the decision making. With these words, I think I have wound up. I'll wind up. Everything else has been talked about. Thank you so much.
Thank you, Justice Gopinath. Before proceeding further, one aspect which you highlighted is relating to Section 49 of the 2023 Act. Section 49 is not yet notified. It is kept out of it. So first thing is the central government will have to notify that it comes within the purview of the Act. Until and unless it is brought within the purview of the Act, the problem which you have expressed, it would be difficult for it to be addressed. Thank you for having highlighted as to why Land Acquisition Act is kept out, and cost should follow the costs, and other aspects of the 2023 Act. Now, I feel and I think the best person to speak on as to why the state should be on the board for resolving the dispute through mediation would be none other than the stakeholders of the respective state governments, led by the Advocate General, and we have Mr. Sudarshan Reddy, Advocate General of Telangana, to share his thoughts on mediation in state litigation. Over to you, Mr. Sudarshan Reddy.
Honorable Chair, Honorable Co-Chair, distinguished panelists, all of a sudden the Honorable Chair has made my job more onerous all of a sudden. Mediation has definitely grown from its nascent stage and took long strides, but insofar as mediation in state litigation is concerned, it is still at the nascent stage for various reasons. The Mediation Act of 2023 also took note of it, and therefore Section 6 and Schedule 1 was placed, because the difficulties of the state in mediation was understood by the legislatures or the parliament also. Insofar as the state of Telangana is concerned, to tell us few statistics from the morning session onwards, it was said that the mediators should be compensated or paid a due honorarium. Insofar as the state of Telangana and the State Legal Services Authority are concerned, we have paid an amount of rupees nearly 72.20 lakhs for the year 2024 and 2025 for settlement of about 1983 cases, that being the statistical part. 12A of the Commercial Courts Act also specifies or mandates that there should be a mediation before a suit is filed, or else in the case of Dhanbad Fuels versus Union of India, an application was filed under Order 7 Rule 11 to dismiss the suit filed by Union of India for an amount of about 7 crores due to the Union of India. The Supreme Court said that insofar as suits which are filed before 2022, they need not be dismissed. They can be kept aside for the purpose of mediation to take place. Otherwise, after 2022, though a state also or the union, in the event you don't take up mediation before filing a suit, the suit is liable to be dismissed under Order 7 Rule 11. The state, insofar as the Telangana state is concerned, the State Legal Services Authority, led by Justice Sam Koshi, who is the chairman of the State Legal Services Authority, has suggested to the state many issues, more particularly on the service side. For the purpose of settling compassionate appointments, we are on the process of having a standard operating procedure where the senior officers would sit and settle the issue insofar as compassionate appointments are concerned and pensions are concerned. That would address majority of the service litigations in the state. And to the credit of the Telangana state, I take it for the state myself that we have an international arbitration and mediation center which is totally supported by the state. No doubt every speaker have said that state is one of the very big litigant. My brother advocates general are here and my big brother the attorney general is here. The state is a big litigant for the sole reason that the state of India is not a state which professes laissez-faire theory, but it is a socialistic state. In order to implement the directive principles, we do take up any number of welfare measures for the people at large. When you take up a welfare measure, in the South India it is normally said Taneshai. We don't resort to Taneshai. We need to have a legislation in order to implement a welfare legislation or a welfare scheme. Such welfare schemes being large in number, there will be some amount of litigation. That is what is more in number in the states, in the high courts, which is being noticed by everybody. But this is in order to see that the welfare of the people at large are taken into consideration. Therefore, the state being a big litigant is more for the purpose of welfare, but not for any litigating purposes. Section 6 of the Mediation Act, that is the legislature, the parliament itself took into consideration the difficulties of the state for the purpose of mediating, because who is to bell the cat is one of the oldest slogans which the states do have a difficulty, or the officers have difficulty. But as more than one of the panelists here have said that why is land acquisition put into it? Though it is put into land acquisition, insofar as the state of Telangana is concerned, we have amended the Act to include section 30A and 31A, wherein we have provided for land acquisition through consent decrees. And we have the rules framed under that to take up land acquisition through consent decrees. And these consent decrees are awarded through mediation by the district collectors and the farmers together, sitting together and mediating. In situations of this nature, the collectors or the revenue divisional officers or the officers concerned may not have enough time. Like many of the panelists now and the sessions earlier have said, that the state or the office or the district collectorates and all, we can have mediators to look into this aspect of land acquisition, where land can be acquired through mutual consent, that is through mediation with the farmers or the land losers. The learned Advocate General from Maharashtra has said that they have Bharosa centers. Similar Bharosa centers are there in the state of Telangana also. We have very recently in Hyderabad had a conference where we have titled it as Voice for the Voiceless, wherein the children in dispute with law, whom we normally call juvenile children, or abused children, or who have been violated against, as to how to deal with them. We have mediators and counselors who take care of the children and also try to settle issues of this nature. Insofar as one of the panelists here have said that about the settlement of compensation in respect of accidents, insurance companies apart, state also has every state has have the biggest transport systems, road transport corporations, which we normally call them. I can assure this august body that the highest number of settlements in respect of compensation regarding motor accidents are settled by the road transport corporations, not only in the state of Telangana, but I have statistics across the country. Road transport corporations have settled the maximum number of motor accident claims. Then many of the panelists here have said that regarding river disputes, water and river disputes in respect of states have always been there, but there has been any amount of coordination between various states wherever river disputes are there. When you construct a project in one state, quite a lot of land in the neighboring state gets submerged. The states do come to an understanding for the purpose of building up that project and the compensation to be settled in the other state also. Therefore, I would submit to the Honorable Chair and the panelists here and or the august body that those states may be the number of litigations against the state or for the state may be more, but they are more one for the welfare purpose of the state, and the states have been doing taking great strides in order to see that the litigation is lessened. But as the panelists have said, every state needs to take up mediators as on the board, like in the district collectorate's office or in the secretariat, in order to settle many a dispute. Thank you very much.
Thank you, Mr. Ribu. We started our program at 3:07, and still we are having another 6 more minutes. So I request the chairman of the Commonwealth Advocates Association, Mr. R. Santana Krishnan, who is a senior mediator, experienced mediator, and mediator who knows all nuances of mediation. And I think he will be the best person to throw some light as to how the state can also contribute for the mediation to be successful in the litigation. Over to you, Mr. Santana.
Thank you, sir. Respected chairman, the dignitaries on the dais, I just wanted to make a couple of points. See, today we are sitting here after witnessing various developments both through the legislations and judicial pronouncements from the year about the time when the section 99 of the CPC was amended, and till date when we are yet to see the taking into effect of the 2023 Mediation Act. Although more than 2 decades have passed, what we witnessed is the mediation ecosystem has emerged in India, akin to many other countries across the world. So that gives enough to tell us that the mindset has really changed. Honorable Chair, you started with saying that change of mindset is needed. Today we see the mindset is changed, and that's the reason why probably for the first time we are talking as to how state and mediation can go together. In this regards, I would like to make a couple of points. One, that every state or its instrumentalities or various departments under every state has to think in terms of as to any issue that arises which can be called as dispute, emerging dispute. The internal mechanism can be set up to take a call as to whether we should litigate, either by being a petitioner, or if any notice comes, this mechanism will sit and take a call as to whether we should prosecute this matter or not. This is one aspect. The second aspect which I saw is the mechanism of having a person appointed like ombudsman. In some of the Western countries, we see the concept of ombudsman where the department has got an ombudsman. Any dispute that arises within the department, whether it is a service matter among the employees or with the department, or whether it's a matter connected with an infrastructure project, or something arises out of contractual obligation, or as to whether a dispute between citizen and the state, a call can be taken by the ombudsman as to whether this particular matter could be resolved by way of mediation. Only after the fact that this dispute, this resolution mechanism fails, you think of the court. This way, a major chunk of litigation that are pending before the courts can be brought down. Because today, as we see, state is the major litigant across all the courts in the country. These mechanisms, if they are taken very seriously, the pendency before the court will sizably come down. But for all these things to take effect, we need a strong army of mediators from across the country. For this purpose, there are a number of organizations across the country, number of them are sitting here, who are conducting mediation trainings. That by itself will not be enough. It has to be much more, substantially much more than that, so that we create as many mediators as lawyers that are in existence in this ecosystem. Only then all these disputes or redressals which we are talking of today can be effectively tackled and the pendency can be brought down very effectively. Thank you very much.
Thank you, Mr. Santanam. Before I request my esteemed sister, Justice Sunita Agarwal, Chief Justice of Gujarat High Court, to wrap up the session, I would just like to highlight two issues. One is relating to where these deliberations should not end here. At least to start with, the Learned Advocate General and Additional Solicitor General or Assistant Solicitor Generals should meet once in 3 months virtually and to exchange the best of practices which they are having and inculcate those in their respective states to ensure that the litigation, state litigation, comes to an end, or at least it gets substantially reduced, like what Mr. Reddy, Sudarshan Reddy said regarding land acquisition through consent decrees and Maharashtra's that Bharosa centers. All these can be adopted by every state, which would be of great benefit. Last but not the least, I think every one of us are on the same page to thank Mr. Pitambar Acharya, the Learned Advocate General, for the wonderful arrangements and excellent hospitality extended through the officers of the state and the entire protocol team of the state for making us our stay and these deliberations very comfortable and a healthy discussion being taken place in this conference. I thank on behalf of all my co-panelists, for myself and on your behalf, the Learned Advocate General, Mr. Pitambar Acharya, once again with a big load of applause, please. I request Justice Sunita Agarwal to wrap up the session, though we are late by, as of now, by 4 minutes.
Thank you, Chair, Justice Arvind Kumar, for giving me this opportunity to wrap up the session. Dignitaries on and off the dais, like this discussion, we are in a sandwich session, I must say, like 2 sessions before us and 2 sessions after us. So, what my take from the 2 sessions, discussion in 2 sessions is that there is we all recognize the government being the major litigant and significant involvement of litigation, which underlines the urgent necessity for alternative dispute resolution to reduce the backlog. There is a need for robust government policy to establish institutional mediation centers. We also recognize the need for clear and transparent referral criteria, because in cases where the government is one of the litigants, so there are considerations like public interest considerations and the impact on governance, capacity building program, transparent and citizen-centric public mediation. While all these issues were highlighted, I would start with the issue highlighted, and there is a lot of emphasis. In the first session, Justice M. Sundar emphasized on the need to notify section 48 and 49, which are not notified as yet, of Mediation Act 2023. Justice B.V. Nagaratna in the second session also impressed upon the need to notify. What Justice Mushtaq has pointed out in his address about a concern that the Act does not connect with the society. There is a need for compartmentalization of the dispute, which are personal and impersonal, categorization. And he has also highlighted distinction between the societal setup in India and the Western society. So our whole concept of mediation, which we have borrowed from the Western world and we have implemented in our ecosystem. And Mr. R. Sanathan Krishnan, one of the panelists in our session, has rightly said that mediation ecosystem has developed in India and we have come a long way. The mindset has changed. But while all these issues were being discussed, being a mediator by training, I started thinking out of the box. So my out of the box thinking, my take is that if we want to really establish an ecosystem where the government is one of the parties and the other side is private litigant, then two issues like for framing of policy, section 48 says that government may frame any scheme or guidelines where the government is one of the parties, and in such cases mediation or conciliation may be conducted in accordance with the scheme or guidelines. 49 says prior written consent of the competent authority of such government before signing of the mediation settlement agreement. Now, issue of time frame not being provided is also highlighted for such approvals. So, what I consider is that when we are considering section 48 and 49 to be notified, then we should look for section 51 and 52 also, which provide for rules and regulations. So, what my concern is that whenever these two sections are notified, simultaneously rules and regulations are to set in place, because there would be no purpose of notifying these provisions without there being rules and regulations to carry out the provisions of those particular provisions. So when I am talking about the rules and regulations, then according to me the negotiation is the heart of mediation. Being a mediator for years together, like I was also a trainer on subject of negotiation. So negotiation is all about dialogues, and it requires collaboration, it requires sustained dialogue, and that dialogue which foster a sense of ownership upon the parties. Like every party, the thrust of mediation is that the parties who are participating in the process must have this feeling that they have control over their decision, voluntary process. They can participate and can leave anytime. Then the government agencies, when we all know that how government appeals are being filed in the court, and the government officers, they in almost every case, even delayed appeals are being filed, where there is no merit in the case. So what Justice Arvind Kumar has highlighted is that the officers want to save their skin. So if a nodal officer, my worry and my query is also that if a nodal officer is appointed to participate in a mediation process where a third party is mediator, whether it is a mediation center established for the purpose, then what would be his take during the process of mediation, whether he would be having that voluntariness in participating during the mediation process, whether he will be in a position to take a call during the mediation sessions, whether joint sessions or single sessions, to mold what he has been transpired, what he has been told, what his limitations are as told by his senior officer. What would happen in a case where there is an impasse? We all know then in mediation, negotiation process goes on and there may be a situation of impasse. whether the mediator would be able to break that impasse, whether the officer who is a nodal officer would be in a position to take a decision which would encourage breaking of impasse. So this liberty and voluntariness to in the whole process of mediation, according to me, can be taken care of when rules and regulations are framed to implement the these provisions of section 48 and 49, where prior written consent of the competent authority is needed to arrive at a mediation settlement. So, with these words, I suppose that I have highlighted the issue. One more issue which is highlighted by Justice Gopinath is about trust deficit. We all know that when one side is litigating party is government, then the private party has some kind of trust deficit. So then when the courts are deciding the matters, I'm not discouraging mediation in government matters. I'm not discouraging mediation. I'm just highlighting these issues so that they can be taken care of by the rule making or regulation making authority, that this is how mediation works. It is different from any kind of settlement in any kind of scheme framed by the state government or the central government. So this voluntariness of the process and then trust deficit, even if you establish mediation institutions, whether the parties will have the same amount of trust on those mediators who are appointed in those institutions as mediators in government litigation, which they have in other mediations where they are litigating with the private parties. With these words, I would say, I would thank all of you for giving me this opportunity, and my panelists and my co-chair, my chair, for giving me opportunity to place my views on the subject. Thank you so much.
I thank the Honorable Chair, the Honorable Co-Chair and the learned speakers for an enlightening session and for giving their wide-ranging views and diverse recommendations on the theme of the session, and I hereby close the session.
Thank you. We thank all the audience for having lent your ears after the sumptuous lunch. Thank you.
Good afternoon, everyone. I'm Sonal Kumar Singh, advocate. I'll be moderating the 4th technical session today. I welcome you all to this technical session. I can understand post-lunch sessions could be quite difficult, but bear with us. We have a stellar panel with us today and who will be sharing their views on very interesting topic. The panel will be chaired by Honorable Justice J.K. Maheshwari. Justice Maheshwari is a judge of the Honorable Supreme Court of India. Justice Maheshwari, in his long and distinguished career, has served as an elected member of the State Bar Council of Madhya Pradesh and has been on the bench for close to 2 decades. While Madhya Pradesh is his parent High Court, he has also served as the Chief Justice of Andhra Pradesh High Court and Sikkim High Court before his elevation to the Supreme Court. With this, may I request Honorable Justice Maheshwari to please share his opening remarks for the session. Please, sir.
So I'm so sorry to interrupt, but we have to felicitate the honorable judges and the chairpersons. Okay.
Good afternoon, everyone. As we are looking forward, since morning, everyone is having a very tired day. So looking to this situation, but we have in a national conference, so its importance is more paramount, but at the same time, we cannot stop the clock, but how the time will run, we have to decide accordingly, and accordingly our panelists have agreed for the same, that we'll go in a panel, but with time limits. So now coming to this session is mediation in commercial matters under the Commercial Courts Act 2015. Certain focus areas have been specified therein. Prior to starting with the same, I welcome to all of you in this city of temple, Lord Jagannath. So, Jai Jagannath, and I will say that the mediation in the recent past has become a cornerstone of the dispute. We are discussing all these issues. Now when we are going, we have 4 focus areas, and those focus areas we decided to divide amongst all. For every focus area, I will put certain points which will be discussed by our panelists. They are well versed of those subjects. Coming to the first topic, pre-litigation mediation under Commercial Courts Act. If we look into this area, then while looking to the same, they will explain it. I will put a remark that the Patil Automation Private Limited versus Rakheja Engineers is the judgment on section 12A. When this judgment came, then the issue came, then mandatory pre-litigation required, otherwise what would be the recourse of pendency of the suit. Then it was further discussed because of the conundrum arise. When mediation says it must be a consent, 12A of the Commercial Courts Act says no, it should be a mandatory mediation. Then this arises, then 2 judgments, Yamini Manohar versus TKD Kirti, and this another is Dhanwad Fuels versus Union of India 2025. This is Justice Jamshed judgment. So this is the issue on the particular pre-litigation mediation. Then the next is coming to hybrid dispute resolution models, mediation, arbitration, arbitration, mediation, arbitration. So this is the hybrid mode as suggested. When we go to this, there are certain issues, our panelists would emphasize this. This why it has been thought it appropriate. When we go for any of the contract, we find either settlement or otherwise there would be a conciliation then arbitration. So this is one of the issue. So this is a settlement by way of mediation probably, or otherwise it will go to the arbitration. But even in the issue of neutrality and so many other confidentiality arises in those cases. So probably I think section 30 of the Arbitration Act specifies that arbitration, mediation and arbitration may be a better recourse for the perspective of the India. When we go to the online dispute resolution, which is a third focus area, then we look into, then Niti Aayog has issued a policy of ODR policy plan of India 2021. This is, I am touching the issue, nothing more. Our panelists will emphasize of this. Then global perspective. Global perspective is global model, contemporary trends and innovations. Then hub of international trade and investment mediation. Then finally, I will put two things. How and what manner this mediation should be successful and what our role, mediators' role, and what is the mindsets of the people. Yesterday when I was here in the opening session, then the example was put about from the time of the Treta Yuga of Angad was sent for the purpose of mediation prior to starting Ram-Ravan Yuddha. Then thereafter Lord Krishna was visited for the purpose of prior to starting Mahabharata. I was taking that clue from that story. If we take that clue from that story, then we have to thought what are the circumstances in which the mediation which was proposed asking only 5 games for the purpose of the 5 villages for the purpose of Mahabharata was not succeeded. Then I feel there are certain situations wherein it has been done. Lord Krishna told Pandavas that this is a situation you decide. If actual interest was being served, the thought process of the Duryodhana was not like this, that he has to give it or not. It was his kingdom, he should not want to lose any of the things, and for even on the cost of war and to lose so many lives. So here is the point lies for the mediator, to put the circumstances, how and what manner, and the mindset of a person by which can be changed. So now with this I invite my all mediators, my panelists. In addition, this Mediation Act Chapter 10, Brother Koshi probably will be addressing on that. So all these issues will be started, and if we say for India we have a rich history as I discussed for the mediation, and mandatory statutory framework is in process. Some of the provisions have been notified, some of the provisions of Mediation Act 23 has not been notified. So it will go ahead. Now the discussion on the topic on the focus areas probably may give the pivotal opportunity to everyone to think and understand and to apply in the field, because provisions may be there, but overall until the application in right perspective is there, we cannot reach to the goal. So this is we thought, and I further request to my all panelists, please don't go for pleasantries to anyone and go on the topic. Now I am giving to Mr. Singh.
Sir, thank you so much, sir, for the opening remarks. May I now move on to Honorable Justice D.K. Upadhyay, and echoing the sentiments of Delhi Bar, I can say that we are honored to have him as the Chief Justice of Delhi High Court. He's also a former Chief Justice of the Bombay High Court and also served as a judge of the Allahabad High Court. So, Section 12 has been extensively discussed today, and if I may ask you your thoughts, whether the Section 12A has been effective and been able to achieve its intended purpose, and if not, what can be done to improve it?
Honorable Chair and other dignitaries, Namaskar. Now, Section 12A has already been discussed, and after this Patel automation matter, it is mandatory. Its mandatory nature has further been emphasized by the Supreme Court in those two judgments which Honorable Chair just recounted. So far as the
intentionally
my
not discuss on the intentionally not discuss on the judgments. You discuss on the judgments. I will.
So, but so far as my view about section 12A being mandatory is concerned, if mediation is to succeed, that needs to be made mandatory. Otherwise, perhaps the same litigation process will have to be followed by the parties even in commercial litigation matters. So that works, and in one of the discussions in the earlier sessions, it was said that Delhi High Court IP rules makes it mandatory. So far as the IPR matters are concerned, our experience has been that at least 60 to 70% matters are being settled through the mediation, at least in Delhi High Court. So I would think that this should be made mandatory. It is already established. But what are the other issues? Now, this mediation process has to be viewed in the backdrop of the fact that the very ecosystem in our country of the arbitration is faced with a lot of stress, and therefore it has to be viewed in that light. Mediation has to go. Why mediation is not the issue? How mediation may be an issue which we need to discuss. The legislature has already come up with a statutory framework. It's only that the provisions are to be implemented, they are to be notified. And if you see section 12A, the mandatory pre-litigation mediation is to be done by two types of mediators. Number one, of course, the Legal Services Authority, and it also talks about mediation service providers. So where are those mediation service providers? Number one. So as was said earlier in one of the earlier sessions, that we need a battery of, rather an army of mediators. That is true if mediation has to succeed. But at the same time, how to ensure the quality of mediators? So there is a provision for registration of mediators, there is a provision for accreditation of mediators, but all that can be done only once the Mediation Council of India is established. Mediation Council of India has not only been entrusted with accreditation, registration, etc., but training and spreading education as well. Second most important aspect would be even in commercial litigation alone. There is a lot of commercial litigation with the government, especially the PSUs and other governmental agencies. Unless we notify section 49, now this kind of what you call policy paralysis that grips the officers, they don't come forth, and they have some or the other kind of a fear in coming forth and getting into the negotiation or getting into the kind of mediation process. Setting up an internal process of settling the dispute, that needs to be differentiated between from the mediation. Appointment of an ombudsman or a kind of a nodal officer, these are all processes to further facilitate mediation. But unless and until in case of a dispute, the government officer comes forward and takes a decision without any fear, perhaps the mediation, so far as government disputes are concerned, will not achieve that much success which we expect by implementation of the statutory regime by this 2023 Act. So this formation of the Arbitration Council, number one, notification of various other provisions of the Act that are very, very essential. So far as the apprehensions in the government sector, PSUs and other government agencies are concerned, they can be very well taken care of by framing the rules and regulations, where in fact it is the government which has been empowered to frame the rules. So all those apprehensions can be very well taken care of by the government, but need of the hour is, especially considering the stress through which our arbitration ecosystem is going on vis-a-vis at least the PSUs in the country at the moment. My view is that this mediation process should be given more fillip so that the concerns of the government sector can at least be addressed, and the time being lost in the litigation in the adversarial system may be saved. It's not only the question of time. As I said, why mediation is not the question at all, it is not the issue at all. How mediation should be an issue which should be discussed, and the first step perhaps towards how mediation is notification of various provisions of the Act, constitution of the Mediation Council, energizing the Mediation Council not only for registration of the mediators, not only for registration of the other mediation service providers, grant of accreditation, education and training, etc. That's how I would conclude.
I will add something more. Brother Upadhyay has pointed out that procedurally and it should be done in the cases when, as I discussed in the partial automation, you people would be aware that it was a case of pre-institution mediation, section 12A, suit was filed, application section 711 was filed, or Code of Civil Procedure. It should be dismissed because of 12A was not complied. So the suit was dismissed. Conundrum arises that when the suit can be saved, in that situation the trial court has passed an order, keep it pending and send it for mediation. High Court confirmed, Supreme Court changed it because they said 12A's language is mandatory. So now this conundrum arises, how it has been dealt with, so that I will clarify. Then in that situation, Yamini Manohar, when it came, then the issue arrived when you ask for a mandatory relief, injunction or otherwise, then what would be the situation? Then the court said is merely asking is insufficient. Then this is further clarified in Dhanbad, and in Dhanbad this court, Supreme Court said that the nuance holding that question is not whether interim relief is granted, but whether it could reasonably contemplated by the plaintiff on the standpoint. So this was the overall. So meaning thereby, otherwise pre-mediation litigation is permissible and it ought to be done first, as I am supporting to that extent just as Mr. Upadhyay, and this is the reality.
Thank you. Thank you so much, sir, for your views. May I now move to Honorable Justice Arun Palli. Justice Arun Palli served as a judge of the Punjab and Haryana High Court and is now currently serving as the Chief Justice of Jammu and Kashmir and Ladakh High Court. Sir, there are various hybrid dispute resolution models such as MedArb, ArB-MedArb, which are proposed to be used these days. How do you see the prospects of these models in India?
Thank you, Sonal. Although the question seems short, straight and simple, but in my opinion, it requires slightly a longish answer, of course, within the bounds of the permitted time. So what we are required to deliberate upon is the hybrid dispute resolution models, which combines hybrid mediation and arbitration, offering pathways along the journey to settlement while retaining the final adjudicatory step. The hybrid dispute resolution models represent extremely advanced approaches to resolve disputes that aim to blend the strength approach of mediation as also the arbitration into single integrated process. By integrating these two, the hybrid models seek to resolve dispute efficiently, cost effective and greater party satisfaction. In fact, Sam Kagel was the first to coin and devise this alternate dispute resolution mechanism. It was he who first hybridized the two methods and mechanism. One, the mediation and arbitration, and of course, later named as MedArb, as you said that. And he utilized this for the first time while settling a controversial San Francisco nurse strike in 70s. So MedArb and ArB-MedArb, which is called the changing hat problem, whether the same neutral can act both as a mediator and arbitrator, or whether the both have to be kept, both the roles have to be kept separately is again another question which is being debated across the globe. So in India, as we move towards becoming a hub for international dispute resolution, so the situation throws up quite a few questions as regards the confidentiality and the fairness of the entire process, and therefore it becomes all the more vital that we develop the clear protocols for Med-Arb and Arb-Med arbitration. Although the Arbitration Conciliation Act 1996 already provides some facility, as pointed out by Justice Maheshwari, that Section 30 permits that even though the arbitral proceedings in progress, there is a provision to still settle the dispute by way of arbitration. And importantly, this is something worth your consideration, that in Jammu and Kashmir, Section 8A is a state-specific amendment which provides a counter, a court-integrated referral mechanism, while during the pendency of the proceedings, be that under Section 9 for interims or 11.6, the court can refer the parties to mediation, and if successful, the settlement can be recorded as an arbitral award. Now, Section 80, as most of us know, of the Arbitration and Conciliation Act allows the same neutral to act as a counselor, conciliator, as also the arbitrator, but of course by express agreement by the parties. Now, this provision, Section 80, has been omitted by the Mediation Act 1923, but since, as we heard in the morning also, that the Act has not yet been enforced, only few of the provisions have been notified, so Section 80 stays as we speak. So therefore, all it says is that yes, the same neutral can act as a conciliator as also the arbitrator, provided the parties agree by a formal agreement in writing. So this shows how Indian law has so far allowed some relaxation, permitting even the same neutral to mediate and arbitrate if party agrees. But yes, in so far as the international models are concerned, the Singapore Arb-Med-Arb protocol uses different neutrals. So they are very strict, and they stick to this and very strictly adhere to this theory that arbitration, if arbitration is paused, mediation is attempted. And if successful, the settlement is recorded as a consent award. And of course, if the mediation also fails, it's back to the arbitrator again. But yes, there is no changing of hats. So this model is hailed as best practices, though in China, the situation is absolutely to the contrary. There they allow the same neutral to act as a mediator, as also an arbitrator, although the settlement rate is phenomenally high. This information is available on the net. But so far as the question as regards confidentiality and the fairness, etc., on an international level, that's quite a concern and is being debated, as I said earlier. But Brazil completely prohibits changing hats altogether. So if at all somebody is acted as a mediator, he's totally prohibited. Rather, he is disqualified to act as an arbitrator, and of course, vice versa. Now, these examples highlight the risks of the changing hat model, and insofar as the Mediation Act 2023 is concerned, then again, you see, this will seek an answer to each one of you sitting here. That Mediation Bill 2021, the draft Section 19, originally allowed waiver of this bar, that if during the course of mediation, the parties have revealed and confided some information with the mediator and somehow the mediation fails and the parties are back to the adjudicatory process by way of arbitration. So there, if at all the arbitrator uses that information while recording an award, of course, it could be challenged by, raising a challenge to the award on that ground. So originally, when the bill is produced in 2021, Section 19, the draft Section 19, it originally allowed the waiver. The parties could enter into a formal agreement and say that the same man can wear the two hats, and they would also sign an agreement that if at all for any reason the mediation fails, there won't be any question as regards the confidentiality is concerned. If later somebody tries to question the award on that ground, that was totally impermissible. But the Parliamentary Standing Committee put its foot down and firmly rejected this. This emphasizes the confidentiality. The Mediation Act 2023, now as we speak, Section 17 provides, now this completely changed the whole scenario. Section 17 provides that a mediator cannot act as an arbitrator in the same matter. So there's no waiver permitted. Even if parties agree and they enter into a formal agreement in writing in this regard, and there is a clause, is no question the law prohibits it. Section 17 takes care and caters to that situation. So this marks a decisive shift. India is aligning with the global best practices, moving away from the same neutral model. So to conclude, considering the time constraints, the MED-ARB or ARB-MED-ARB efficiency and enforceability, but without safeguarding the risk, undermining trust. The Mediation Act 2023 has rightly placed confidentiality above convenience. The task before us now is to craft detailed, uniform protocols like Singapore's ARB-MED-ARB, adapted to Indian conditions. Only then India can realize its ambition of becoming a true global international hub for mediation and arbitration. So with this, I thank the organizers, also Justice Maheshwari, for affording us an invaluable opportunity.
I would add one word for this topic, that Brother Palli has rightly pointed out Section 17, which is yet to notify, which is not yet notified. But the another part is, if we look into particularly of Section 30 of the arbitration, then arbitration, mediation, arbitration. If it is change of mediation, it may come again back to that, and this may be a swift. The another thing is, whatever is in the situation of Singapore, as pointed out in other places, that may be a circumstances in a thought process of the citizens. Here, if we go on that at present, it is a debatable topic, what would be the situation, and therefore probably this Section 17 may have been introduced. I can say this much, nothing more. Let us hope that the things may go in a right perspective.
Thank you so much, sir. This is very informative. May I now move to Honorable Justice T.S. Chauhan. Justice T.S. Chauhan is the serving Chief Justice of the Jharkhand High Court and has also served as a judge of the Himachal Pradesh High Court. Sir, in this age of technology, online dispute resolution system is much discussed. Sir, if you could share your views and thoughts on the practices, challenges, and scalability of online dispute resolution mechanism in India.
Thank you. Good evening, everyone. Online disputes resolution, which I will be referring to as ODR, has emerged as an innovation that promises to democratize access to justice. It's not merely a technological add-on to existing mechanisms. It represents a paradigm shift in how we think of dispute resolution itself. It defines questions of time, space, participation, and enforceability. But then technology is a double-edged sword, as they call it. So I'll be delving on what are the best practices. I've culled out about 9 of them. They could be far greater, many more. To harness the full potential of ODR, certain best practices are essential. 1, user-centric platforms. Interface must be intuitive, multilingual, and mobile-friendly. In a diverse country like India, inclusivity must be built into the design, ensuring even the first-time users feel confident. Second, hybrid models. While technology can automate routine tasks such as scheduling, document sharing, and even initial screening of cases, the human element, that is mediators and arbitrators, remains central. A balanced hybrid model builds both efficiency and trust, as Justice Palli said. Then third is capacity building. Training professionals in both legal and technological skills is vital. Mediators and arbitrators must learn to navigate digital tools. On the other hand, technologists must understand the nuances of dispute resolution. Fourth is legal recognition and enforcement, which is very vital. Parties must be assured that agreements and awards emerging from ODR are binding and enforceable, just like those in offline ADR. Clear legal frameworks under Arbitration and Conciliation Act and judicial recognition are vital. Next would be transparency and accountability. Standardized procedures, clear fee structures, and defined timelines should be adopted to instill confidence amongst the users. Sixthly, integration with institutions. Courts, tribunals, and regulators must actively interrogate ODR into the processes. A seamless handoff between traditional systems and digital platforms will build credibility. Seventhly, neutral and impartial processes. The credibility of ODR depends on trust. Parties must feel that mediators, arbitrators, and even automated systems are neutral. This requires transparent algorithms, well-trained neutrals, and clear ethical standards. Then flexible and tiered mechanisms. ODR should support a variety of resolution types like negotiation, mediation, arbitration, or even hybrid processes. Best practices recommend tiered dispute resolution starting with negotiation, moving to mediation, and escalating to arbitration if needed. The next is data security and compliances. Platforms should comply with existing data protection norms, including the Digital Personal Data Protection Act. Encryption of two factors authentication and robust audit trails should be built into the system. Dealing with confidentiality and challenges, these are at the heart of the ODR, but it faces digital risk. Cyber attacks and data breaches threaten sensitive information. Metadata may be inadvertently reveal details unless deletion policies are enforced. Cross-border disputes face conflicting data protection laws, complicating confidentiality. Human error, such as using insecure email or storing files poorly, adds risk. To preserving confidentiality, ODR platforms must be embedded securities in their designs, end-to-end encryptions, secure servers, multi-factor authentications. Legal obligation must mandate confidentiality, supported by audits and certificates. Parties and mediators must be also trained to follow secure practices. Trust in ODR depends fundamentally on confidentiality being protected in both law and practice. While ODR provides speed and convenience, confidentiality remains one of its greatest concerns. The challenges could be like data privacy risk. Disputes often involve sensitive business contacts, personal data, or trade secrets. If platforms are not secure, this information is vulnerable to leaks. Cloud storage risk could be another factor, because many Indian ODR platforms use third-party cloud services, and these are hosted outside India and thus not following Indian jurisdictional laws. Cybersecurity threats, hacking, phishing, ransomware attacks can undermine trust in the process. Then fragmented standards, different ODR services. Providers may follow inconsistent data protection services. Lastly, trust deficit. Parties may fear that their data could be misused or monitored, leading to reluctance in full disclosure. Then what could be the solutions? Number one, robust encryption protocols, strict compliance with Digital Personal Data Protection Act 2023, independent audits of ODR platforms, awareness programs assuring users about confidentiality safeguards, using of privacy, preserving technologies like zero knowledge, proof of differential privacy in sensitive disputes. Then need to prioritize data localization and ensure platforms adhere to Indian privacy laws. As regards scalability in India, ODR is one of the greatest opportunities for India's 800 million net users, which creates unmatched potential, but barriers remain. Digital literacy is uneven. Platforms must offer multilingual support, visual guides, and offline facilitations. Internet access remains patchy in rural areas. Hybrid online systems may be necessary. Institutional capacity is limited. Mediators and arbitrators must be trained in digital tools. Trust is another barrier. Citizens must see ODR as legitimate justice, not inferior justice. Legal clarity is needed to assure enforceability. Government adoption of ODR in contracts and consumer disputes will normalize it. With inclusivity, awareness and legal support, ODR can resolve millions of disputes annually and strengthen Indian justice system. Lastly, I may conclude that ODR is not only a tool of efficiency, but a constitutional imperative for access of justice. With the concerted and coordinated effort by government, judiciary, bar, academia and private sector, ODR will become a mainstream pillar of justice. Like UPI in finance, ODR can be India's global contribution to justice. The vision is justice that is timely, fair and universal, delivered digitally and inclusively. Thank you.
In addition to Mr. Tarlok Singh ji, Madam Justice, I have certain word of caution, which is online dispute resolution ODR, the difficulty which we have faced and due to which probably I am thinking this policy is still not come. That is, it is vulnerable of data breaches, unauthorized access, cyber attacks and confidentiality that is required to be done. Probably the government may be thinking of it, or otherwise we can suggest for it.
Thank you. Thank you so much, sir. Now, may I move to Shri K. Gopalakrishna Kurup. Shri Kurup is a designated senior advocate from the High Court of Kerala and is currently serving as the Advocate General of Kerala. So from technology now, let's move on to some global perspective. So taking a cue from what Justice Suryakant said to borrow best practices from the global players, would you like to share your thoughts on the global perspective or international trends or best practices that we may adopt in India?
Thank you. Honorable Chair, distinguished panelists, all dignitaries of the dais, friends. My attempt will be to make comparative analysis of global models, including the Singapore Convention, the European Union, the United States, the United Kingdom, Australia and Singapore, which provides invaluable insights, institutional structure, enforcement and training. Regarding the Singapore Convention of Mediation adopted in 2018 established a global framework for the cross-border enforcement of mediated settlement agreements in international commercial disputes. Although India signed the convention in 2019, ratification is still pending. The primary lesson for India is the absolute necessity of establishing a global standard for enforceability to build a more resilient institutional mediation ecosystem. Turning to the European Union, the 2008 European Union Mediation Directive aimed to help member states create robust legislation and establish uniform guidelines to enhance the legality of mediation in cross-border civil and commercial proceedings. The directive's key insight for India lies in its balanced approach. It encourages the judicial referral to mediation, but stops short of mandating it, upholding the process's voluntary and autonomous nature. This principle is essential when we negative the procedural complexities associated with the mandatory type pre-litigation mediation under our Commercial Codes Act. Furthermore, European Union framework offers two structural lessons. First, despite remaining challenges regarding uniform standards of mediator qualifications, the directive encourages voluntary codes of conduct, offering an excellent blueprint for the newly created Mediation Council of India to regulate mediator standards. Second, the directive ensures that engaging in mediation does not prejudice a party's legal rights by suspending limitation periods. Though we have enacted a similar provision in India, as per Section 29 of the Mediation Act, the same has not yet been notified. Notifying the same will build greater confidence among disputants. The United States presents one of the world's most mature and effective systems, characterized by strong judicial support and a multi-tier approach aimed at reducing the burden and costs associated with the expansion of the court system. The crucial lesson is judicial integration comes from the multi-door courthouse initiative. This successfully embeds the mediation into the justice system. India's courts must emulate this by strengthening court-annexed mediation at the district and local levels. The US experience also shows the transformative role of lawyers. Initially skeptical in the mid-1980s, lawyers professionalized mediation by developing ethical guidelines and training standards. India must incentivize lawyers and mandate mediation disclosures in professional conduct rules to accelerate adoption. Lawyers, by consolidating mediation, became instrumental advocates and mediators themselves. Moreover, the US model boasts a robust infrastructure with numerous professional organizations and comprehensive training standards, lending critical credibility. The Mediation Council of India must draw lessons from these organizations to develop strong, uniform standards for training and professional conduct. The United Kingdom's Center for Effective Dispute Resolution conducts regular audits and publishes empirical data. India must develop a robust institutional framework for empirical data collection to inform mediation policy. UK demonstrates an effective model of judicial encouragement through the civil procedure rules, using cost sanction to balance voluntariness with pressure to mediate. Australia's New South Wales provides compelling models of legislative support for mediation, such as the Farm Debt Mediation Act. Singapore requires a legal obligation on parties to consider amicable settlement via the rules of Code 2021. India may consider introducing the practice of filing a genuine step statement before litigation. Singapore has particularly pioneered by hybrid processes, allowing the parties to transition seamlessly between arbitration, litigation, and mediation, providing procedural flexibility suitable for complex commercial matters. There is a lack of specific legal mandate in India governing the hybrid alternate dispute resolution model, which creates uncertainty regarding its application, though authority for the same can be vaguely traced to Sections 30 and 31 of the Arbitration and Conciliation Act 1996. In closing, the analysis of these global models provides the following takeaways for refining India's mediation framework. The Mediation Council of India must draw lessons from successful US professional organizations to set high, uniform standards for mediator training and conduct. India must focus on promoting mediation through judicial encouragement and lawyer incentives, as is seen in the US and European Union, to foster a voluntary and robust mediation culture. We must foster partnerships between courts and mediation institutions, following cues from Singapore and the US to establish a seamless referral system and improve efficiency. Leveraging global experience, especially the extensive online dispute resolution platforms of US and the European Union, will allow for tech-enabled mediation to reduce costs and significantly expand access to justice across our vast nation. To conclude, by adopting these critical lessons on enforcement, regulation, professional standards, and judicial integration, India can ensure its new mediation framework is not merely compliant, but truly world-class. Thank you.
Thank you so much, sir. Now, may I request to Honorable Justice Girish Kulkarni. Justice Kulkarni is a judge of the Bombay High Court and had a robust commercial and civil practice before he was elevated to the bench. Sir, it's not only India, but other countries that are promoting mediation as a mode to resolve disputes. Can we have your views on comparative mediation practices, the lessons that we may learn from the Singapore Convention, EU, and the US models, please?
Thank you. Good evening. Honorable Chair, the Justice Maheshwari, distinguished dignitaries on the dais and off the dais. The full day we were talking about the mediation possibly in the domestic perspective. But what would be the situation insofar as the international mediation practices are concerned, and more particularly when we are looking at India to be a 4.19 trillion economy, the fourth largest economy in the world, and the estimate of India reaching the second position in 2038. GDP today, as all of you know, is 7.8%. So in this scenario, when we talk about mediation and the resolution of disputes in regard to cross-border transactions or agreements, I think the topic definitely becomes significant and important from the international perspective. Now, we have seen that in the Mediation Act, there is a definition of international mediation in section 3G. But if you see the corresponding provisions of the Act, there does not appear to be much which we can take insofar as the international mediation is concerned. Now, three options are given about what is the situation of the Singapore Convention, the practices in the European Union, and in the US models. Now, insofar as the Singapore Convention is concerned, we are all aware that United Nations Convention on International Settlement Agreement resulting from mediation, popularly known as the Singapore Convention, was conceived in 2018. It was adopted by the General Assembly of the United Nations in 2018, and 2020 it was brought into force. 59 countries so far have adopted the Singapore Convention. 19 countries have ratified the same. However, although India is a signatory to the convention, but we have not ratified it. This definitely has certain consequences when it comes to the mediation and the settlement of disputes in the international scenario. 2026 is going to be the year where Brazil also is ratifying, has already ratified, and it will take effect. Now, coming to this, what is the whole intent and purpose? It is considered to be a very significant achievement because it is based on the New York pattern, as we have seen in the Arbitration and Conciliation Act, the New York Conventions on the UNCITRAL model. It's a landmark treaty providing for a uniform legal framework for enforcement of a mediated settlement across borders. It would definitely facilitate international trade and commerce. The whole perspective is to have confidence of the businessmen dealing with international trade and disputes which may possibly arise, which are required to be settled. Confidence of the businessmen, therefore, and certainty are the basic principles which are actually cherished under the Singapore Convention. Now, there are some drawbacks, possibly in respect of family settlements it is not applicable. It is not applicable in respect of employment disputes. Somebody is working abroad and the country which is ratified this, he may not be, or he or she may not be in a position to take advantage of any settlement. And in any case, because we have not ratified it, there appears to be definitely some disadvantage. Now, coming to the EU model, in the European Union, the model has been there in existence since 2008. The Mediation Directive 2008 has been adopted by the EU countries. It is integrated into the civil justice system, applicable to cross-border civil and commercial disputes within the European Union. Significant feature is that the judges have a right, as we don't have it under our, either under section 89 of the CPC or even under the Mediation and Conciliation Act. But under this model, the judges have a right to invite the parties to mediation and issue an order that you have to go for mediation, which is something which is significant.
Now, member states would be required to establish a mechanism for enforcing the mediation settlement agreements. So, that liberty or that free play in the joints has already been conferred. What is the ultimate, the ultimate conclusion is that assuming that there is a mediation and there is a settlement which is brought about, it is in the form of a consent decree. Although the period of limitation is saved as we have in our act, but the problems which arise in respect of the consent decree being executed definitely are existing, and it may quite possibly lead to litigation. Confidentiality is one of the aspects which is also a matter of concern, and it has been specifically thereafter provided that it cannot be used in subsequent proceedings, which is a safeguard which was subsequently brought. It is a full voluntary model as far as the EU is concerned, has made it not very successful because of the complete voluntary nature of the scheme which is in operation, as there are no sanctions or obligations for a failure to mediate. Now, this is the situation in the EU. They are not somehow accepting the Singapore Convention in the fullest form because of certain issues in regard to that they are not comfortable, it says one of the articles, they say that they are not comfortable with the nature of the mediators who would be available in the international scenario, and as we discussed in some of the sessions, whether they would be persons of that expertise in handling such disputes. The third model which is put up for this discussion is the US model. Now, the US model possibly is more US oriented, I would say. It is a multi-tiered and fragmented landscape for mediation because of the federal nature of the laws in the US. However, at the federal level, Federal Mediation and Conciliation Services is a body which has been constituted, which is a specialized independent agency which would look into such disputes and which would guide parties to come to such settlement. Now, which is focused also on preventing and resolving labor management and such categories of disputes, which is nationwide because it is a federal agency. In 1998, the US federal laws conceived a civil litigation which is known as the ADR Act of 1998. The court is free to devise its own mediation programs under the said act, and the ultimate result would be a consent agreement which is entered between a agreement which is entered between the parties, like consent terms. The consent terms possibly on many of the occasions they go for some kind of disputes even on those consent agreements, and they are challenged on the basis of the argument, the pleas which are available of fraud, duress, mutual mistake, etc. But ultimately it becomes a costly affair. So, comparing all these three models, in fact it appears that we are not in a very, we are in an advantageous position. We have all these laws which are already seen on the global perspective, and we can bring in changes so that we can adapt to the international model, and possibly in future India may also embrace the Singapore Convention, which would make us more compatible, and once there is a definition of the international mediation already in the act, I think there is definitely a good way forward. Thank you.
Thank you. I will add for Mr. Kurup as well as Girishji. Girishji has emphasized rightly Singapore Convention, EU and US model. But overall one thing still remains that that topic would cover by Archana ji, that how we should be, how for international trade and investment mediations, we are thinking how the India can be of this, and for this, for Singapore, ratification required. EU, cross-border, certain their policies are there, so they can go abroad. and so far as US is concerned, it's not fruitful. I do also concur of the same, but here some gray line area, what we have to make the India as a hub. And
Thank
yes, Sunil. Let Sunil first.
Yes. May I now introduce Srimati Archana Pathak Dave. She is a senior counsel designated by the Supreme Court of India and is now serving as the Additional Solicitor General of India. And I may extend the same question with Honorable Justice Maheshwari has extended to you. Since we are speaking about how to improve mediation in India, your views on how we can make India a hub for international mediations, ma'am.
Thank you, Honorable Chair and Sunil, for putting this pertinent and pointed question to me. Honorable Chair, Co-Chair, distinguished panelists and dignitaries of the dais. Well, when on all fronts India is shining and wading its way through the pinnacle, then why not mediation? And the question that I ask is that if not today, when? And if not now, and how? Today we can see that India is emerging as one of the fastest growing economies, has projected to the world its ambition through Make in India, Atmanirbhar Bharat and Viksit Bharat. Trade and investment are no longer confined within national borders. They are the bloodstream of a globalized economy. We know that due to the investor-friendly foreign direct investment policy, under which most sectors are now open for 100% FDI through the automatic route, FDI inflows have been on a very steady rise. The figures are before me, and I can say that it's almost 40% increase now from US $71.28 billion in FY 2024, 23 and 24, as compared to financial year 2013 and 14. Litigation, if we see, is too slow at times. Even arbitration, while effective, often proves adversarial and costly. Mediation, by contrast, embodies speed, confidentiality, and collaboration. It is no longer now a soft option. Rather, it is becoming the preferred global standard. That is the new grammar of global commerce. The time has come for India to embrace not merely the practice, but the leadership of international trade and investment mediation. Well, if we see the global landscape, the adoption of the Singapore Convention on Mediation 2019, which we just talked about, has been a turning point. For the first time, cross-border mediated settlements have been given international enforceability, much like the New York Convention did for arbitration in 1958. Singapore and Hong Kong have already leveraged this, building brands as global mediation hubs. The European Union, too, has embedded mediation into its legal and commercial architecture. Well, we are talking about India as emerging as the next mediation hub. Let me tell you the three major strategic advantages that India has. The first being the geography. Located between the world's two largest trade routes, the West and the East. Whether it is energy from the Gulf, goods from Europe, or technology from East Asia, India sits as the natural crossroads of trade flows. Number two, the market scale and cost competitiveness. With 1.4 billion people and a thriving manufacturing and services sector, India is both a producer and a consumer, making it indispensable in global supply chains. India also offers the world-class professional services at significantly lower costs than Singapore or Europe. Number three, and most important, legal infrastructure and judicial backing. Reforms in arbitration and commercial courts have been deepened by the Mediation Act 2023,
which places India firmly on the global ADR map. Indian courts, including the Supreme Court, have consistently encouraged ADR, lending institutional legitimacy to mediation. Put together, these advantages make India not just a participant, but a potential leader in global mediation. Let me now, since the time is short, I'm just skipping the Mediation Act. There's much talk that has happened on the Mediation Act 2023. However, I would like to stress on the opportunities for India and why they are immense. One, the regional leadership. India can emerge as Asia-Pacific mediation hub, complementing but also competing with Singapore and Hong Kong. Investor confidence. A predictable, neutral and enforceable mediation framework lowers investor risk and boosts inflows. FDI magnet. Strong ADR systems are today as critical to investment decisions as tax regimes or labor laws. Institutional growth. Establish a flagship India International Mediation Center on the lines of SIAC. Capacity building. Develop a cadre of mediators trained in trade, investment law, multilingual skills, and cross-cultural negotiation. Digital platforms harness India's IT strengths to pioneer secure, scalable online mediation platforms accessible even to SMEs in cross-border trade. And last, not the least, I propose 5 steps how we can achieve this. One, of course, we have signed the Singapore Convention, but to ratify the same with suitable modifications. Number 2, embed mediation clauses in future bilateral investment treaties, BITs. Establish and train specialized panels of mediators in trade and investment disputes. Develop PPP-based mediation centers in commercial hubs like Mumbai, Delhi, Bangalore, and Hyderabad. Once all these are done, we could have a campaign like Resolve in India, positioning India as a trusted destination for mediation. Thus, mediation is not merely about resolving disputes, it is about building trust, ensuring predictability, and strengthening diplomacy through commerce. By embedding mediation in our economic architecture, India will not just ease its domestic burden of litigation, it will project itself as a nation that is fair, neutral, and reliable to investors worldwide. Arbitration gave us recognition. Mediation can give us global leadership. And I, being a very positive person, I believe that while we see that so much of work is already done in this direction, our judiciary and government, they are both at the same level when we are talking about mediation. So therefore, I feel well begun is already half done. Thank you very much.
I will not, for a lighter side, you are listening for a long time. So I will only say, learned Attorney General is sitting, hearing, ASG, Additional Solicitor General, seriously thought it. I can only say one line, that Indian judicial system is being recognized one of the highest pedestal globally. I can say this much.
Thank you so much, sir. Thank you so much, ma'am. May I just now move to Honorable Justice P. Sam Koshi. Justice Koshi is currently serving as a judge of the High Court of Telangana. He has previously served as a judge of the High Court of Chhattisgarh, which is his parent High Court. So, the concept of community mediation has been introduced in the Mediation Act 2013. May I have your views on how this community mediation is different from normal mediation process, and how can it be effectively implemented in India, and if there are any international best practices that we may adopt?
To answer Sonal's question, it has to be divided into 3 parts. First is the difference between the normal mediation and the community mediation. Second part is what are the steps to effectively implement the community mediation, and the third part is some of the best practices followed internationally. The first one being the difference, though it's a question which is more subjective in nature, but to put it broadly, I will say a few of them are: first, the focus. A community mediation normally focuses on the grievance. It is not always on disputes. A community mediation focuses on resolving the grievance that can affect the peace, the harmony and the tranquility of the community or locality. Whereas the normal mediation normally tries to resolve a dispute between two of the parties. Second being the selection of a mediator. In a community mediation, now under the Act of 2023, Chapter 10 deals with it, there has to be a constitution of at least 3 mediators being there in a community mediation. Whereas under the normal mediation, it has to be a mediator appointed by the parties themselves. The third being the process of mediation that is adopted by the community mediation, which is totally informal, unlike the normal mediation. Community mediation is mostly informal and also very flexible, recognizing the importance of the traditional practices, the customs, which otherwise does not have the following in the normal mediation process. Last is the accessibility. Community mediation provides a forum for resolving the grievance that is accessible to all the members of the society, particularly in the rural areas where the formal justice systems may be too limited. Whereas the normal mediation is also applied to urban and also in the major cities as well. The second aspect was the steps to be taken for effective implementation of the community mediation. In my opinion, there has to be an awareness and education campaign which needs to be taken at the first instance. There is a need for conducting awareness campaigns and provide comprehensive training programs for mediators, lawyers and the public to promote understanding and utilize the community mediation. Just to put the statistics so far as the state that I am representing, in the state of Telangana, by now we have trained more than 500 lawyers across the state representing the different bar association. We have been calling the trained mediators to the different district headquarters and training the lawyers at the respective centers. We have more than 150 judicial officers who have got the training imparted. We have got a few retired judges of the High Court who have also undertaken the mediation and are also seriously pursuing it. The next aspect to be taken for the effective implementation is the institutional framework. There is a need to establish well-supported institutional mediation centers that can provide accessible and reliable mediation services. So far as the state of Telangana is concerned, we have around 49 mediation centers across the state. And in the last 1 year, with mediation being taken quite seriously by the state of Telangana as also by the High Court, we have by now resolved around 2,000 matters up till September 2025 in last 1 year time, starting from 2024. From the time the campaign for mediation for the nation had begun, that is from July 2025 to September 25, we have settled around 381 matters by way of mediation. So far as community mediation centers are concerned, in all about 586 matters were referred, of which 356 matters were settled by way of community mediation in the state. Another aspect which has to be necessarily taken care of for the effective implementation of community mediation is there being legislative backing, strengthening of the legislative framework governing the community mediation, drawing inspiration from the international best practices also have to be taken care of. The new act has been enacted from 2023. Chapter 10 has been envisaging community mediation. So we believe that the process of community mediation would fast catch up. There has to be a grassroots level implementation also. This can be done by leveraging the community members as mediators and promoting the dispute resolution in the local within the local communities itself. Some of the international best practices that can be adopted is one that is adopted by the Singapore Convention on Mediation. India's ratification to this convention would definitely strengthen its position in international dispute resolution and facilitate the enforcement of mediated settlement agreements across borders. United Nations guidance on effective mediation also gives an importance at this juncture. Impartiality, inclusivity, and the national ownership in mediation processes, providing valuable insight for the India's community mediation initiatives. Some of the indigenous community conflict resolution systems adopted across the globe is one that is adopted in San Francisco, where there is a community boards program. This program employs volunteer mediators who receive specialized training in handling a variety of neighborhood disputes. These community volunteers develop skill in conflict resolution, active listening, and facilitating to help neighbors address issues ranging from noise complaints to property boundary disputes. This grassroots approach makes justice more accessible, reduces the burden on formal court systems, and helps preserve relationship between neighbors by providing non-adversarial forum for resolving conflicts. Similar is a process which has been adopted in Brazil, which is known as agentes comunitários. This community serves as local mediators in areas where formal judicial system have limited presence. These trained community members help resolve neighborhood disputes, family conflicts, minor civil matters through culturally appropriate mediation techniques. They navigate complex social dynamics with an intimate understanding of local norms and relationships, providing accessible justice solutions that prevent conflicts from escalating to violence. Similar is the Singapore's community mediation centers. These centers exemplify culturally sensitive dispute resolution in a multi-ethnic society by employing mediators trained in cross-cultural communication and conflict resolution techniques. These centers provide accessible mediation services that respect Singapore's diverse ethnic, religious, and linguistic backgrounds, ensuring that cultural nuances are understood and honored throughout the mediation process. In Australia, there is an aboriginal tribe known as Dadidri. It is an indigenous Australian community where there is a practice of deep listening that creates space for reflection and mutual understanding between individuals. This contemplative tradition emphasizes patient, quiet attentiveness that allows participants to fully hear each other without interruption through thoughtful consideration rather than reactive responses. By encouraging participants to truly listen to one another's perspectives, this practice fosters empathy and connection, ultimately facilitating more meaningful conflict resolution that honors the wisdom and experiences of all involved. Likewise, there is also a community in New Zealand which is called as Mari Hui. These are formal community gatherings guided by customary protocols that create a structured space for addressing conflicts or grievances. During these meetings, each participant follows established speaking rituals, with elders often facilitating proceedings. The format emphasizes respect, active listening, and collective decision-making, allowing all voices to be heard while maintaining cultural values that social bonds within the community. These are some of the practices that are followed across the globe, which can also be kept in mind by this group of gathering that we have assembled over here when we go back to our respective place, pondering how to develop the community mediation aspect. Thank you.
I will put one example and then I will request how is peripheral area must be increased. Right, brother Kosi has rightly pointed out about the state. We hope that every state is doing well. I put an example of a community mediation in the state of Madhya Pradesh. What happened in tribal community? There is a tradition that when the boy and girl who are major having some affection, then at the time of Holi, they have one function 2-3 days prior, and 3 days probably he may also aware of this fact because he originally from Chhattisgarh. Then they organize this function Bhagoria, who are having affection and they go with each other, then they come and by way of community mediation, they resolve this dispute and finalize that. And otherwise that will go to the court, meaning thereby pre-litigation, pre-institution, this community mediation is one of the successful example there. But this is not merely an example. We have to enhance it on every aspect and in particular in commercial litigations globally. So this is our issue which I want to convey. Now it is on the...
So thank you for these remarks. With the permission of the chair,
I can put my all panelists, if they wish to say within 30 seconds any of the mantra, thereby this mediation can be successful in India, that can globally enhance, can they put, we can give an opportunity from Girish starting.
The mindset to have resolution of disputes by mediation would be most important, I feel. The mindset of the lawyers, all stakeholders, it has to be very positive and progressive in the approach to embrace the settlement of disputes by mediation. Now, it would take little time, but I think the moment is already gathered and I see a very bright future for this.
If ODR can be adopted in a far-flung area of Tawang in Arunachal Pradesh, so it can be replicated and imitated throughout the country.
Brother Upadhyay.
Mediation, in my view, can act as an alternate to arbitration, provided we have properly registered, accredited individual mediators and the service providers. So government needs to act. That's my request to learned Attorney General.
Brother Palli.
Although there is a lot to say, but I say that a successful mediation must be preceded by a definite mindset change, and only then it works.
Brother Kose.
So far as the campaign that I was stressing on, the first thing that needs to be done is to carry it to the schools, colleges and all the educational institutions, highlighting that there is this mode which needs to be adopted first before going into for any other litigation.
Archana ji.
I feel that community mediation is a really important thing that we must really stress upon, because that's what we have been seeing traditionally also. So if that is nurtured well enough, I think it can be really successful.
Kurup ji.
As suggested in the earlier round of discussions also, that the need for mediation as a tool for alternative dispute resolution scheme will be included in the curriculum in all universities who are undergoing law graduate courses, and that also will help us to train better mediators in future.
Thank you so much, sir. I would like to specially thank our chair, Honorable Mr. Justice J.K. Maheshwari, co-chairs, Honorable Justice Upadhyay and Honorable Justice Arun Palliji, and all the panelists, and the entire audience for being so patient at this hour of the day. Thank you so much. And with the permission of the chair, may I close this session, sir? Thank you so much.
Good evening, distinguished judges. May I now request Shri Pitambar Acharya, Learned Advocate General of Odisha, to kindly facilitate the esteemed dignitaries on the dais. Honorable Shri Justice J.K. Maheshwari, Supreme Court of India. Honorable Shri Justice Deven Kumar Upadhyay, Chief Justice, High Court of Delhi.
Thank you.
Honorable Shri Justice Deven Kumar Upadhyay, Chief Justice, High Court of Delhi. Honorable Shri Justice Honorable Shri Justice Arun Palli, Chief Justice, High Court of Jammu and Kashmir and Ladakh.
Probably you will not come for a week due to this tiredness in the Supreme Court. Okay.
Honorable Shri Justice Tarlok Singh Chauhan, Chief Justice, High Court of Jharkhand. Honorable Shri Justice P. Sam Koshi, Judge, High Court for State of Telangana. Honorable Shri Justice Girish Kulkarni, Judge, Bombay High Court. Honorable Shri Justice P. Sam Koshi, Judge, High Court of State of Telangana. Honorable Shri Justice Girish Kulkarni, Judge, Bombay High Court. Srimati Archana Pathak Dave, Learned Additional Solicitor General, Supreme Court of India. Shri K. Kopal Krishna Kurup, Learned Advocate General, Kerala.
Meghalaya. Shri Anil Singh, Learned Additional Solicitor General, High Court of Maharashtra. And Shri S.D. Sanjay, Learned Additional Solicitor General, Supreme Court of India. May I now request the Advocate General of India, Odisha, Shri Pitambar Acharya, to felicitate the Honorable Judges and the distinguished dignitaries on the dais. Honorable Shri Justice Prashant Kumar Mishra, Supreme Court of India. Honorable Shri Justice Arun Bhansali, Chief Justice, High Court of Allahabad. Honorable Shri Justice Arun Bhansali, Chief Justice, High Court of Allahabad. Honorable Shri Justice Sanjeev Sachdeva, Chief Justice, High Court of Madhya Pradesh. Honorable Shri Justice Guhanathan Narendra, Chief Justice, High Court of Uttarakhand. Honorable Shri Justice M.I. Arun, High Court of Karnataka. Honorable Shri Justice Sujit Narayan Prasad, High Court of Jharkhand. Shri Amit Kumar, Learned Advocate General of Meghalaya. Shri Anil Singh, Learned Additional Solicitor General, High Court of Maharashtra. Sorry. Shri S.D. Sanjay, Learned Additional Solicitor General, Supreme Court of India.
Esteemed delegates, there is an announcement. I take this liberty with my good friend, Advocate General of Meghalaya, Sri Amit Kumar. I requested him that the second baton you carry forward to Shillong. So the next conference on mediation, he has agreed with his consent. This is a declaration, you have to stick to it. So would be held in Shillong. The time, date, everything after the winter preferably, that would be done in Shillong, Meghalaya. He will be the host.
Good evening, everyone. Welcome to the last and final session of this historic conference. The topic for this session is development of institutional mediation. The focus areas of today's session is specifically going to be accreditation, the Mediation Council of India, the standards of mediators, and how to ensure quality and accountability in mediation. Considering that the introductions are already done, I leave the floor to the chair, Honorable Justice Prashant Kumar Mishra, Judge, Supreme Court of India.
Esteemed Brother Justice Arun Bansali, Chief Justice of High Court of Allahabad, Brother Sanjeev Sachdeva, Chief Justice of High Court of Madhya Pradesh, Justice G. Narendra, Chief Justice of High Court of Uttarakhand, Justice Sujit Narayan Prasad, Judge, High Court of Jharkhand, Justice M.I. Arun, Judge, High Court of Karnataka, Amit Kumar, Advocate General of Meghalaya, Sri Anil Singh, Additional Solicitor General, High Court of Maharashtra, Sri S.D. Sanjay, Additional Solicitor General, Supreme Court of India, Learned Attorney General, the Chief Justices of different High Courts, including Orissa and Gujarat, and Delhi and Chennai, my esteemed sister and brother judges from different high courts, the trained mediators, participants, ladies and gentlemen, we have been requested to wrap up this session at the earliest. Though we thought that development of an institution is the most important area for any institution. But as the coincidence is that the deliberations would not be much longer and it will not be to the satisfaction of the panelists. But still, we'll try to focus on the key areas of the development of institutional mediation. And as we know, after this enactment of the Mediation Act 2023, the process of development of institutional mediation has already begun. Some of the provisions have been notified, some have not been, and there has been discussion throughout the day as to whether the provisions which have not yet been notified should be notified at the earliest. And another interesting thing is that the focus areas of this technical session is devoted to Mediation Council of India and standards for mediators and service providers, and accreditation, mediation councils and recognition of bodies, and those provisions are yet to be notified. So now in fact, focus for this technical session should be, if we shift the onus will shift to the Attorney General, so that it is notified and the focus remains focused in real terms. Anyways, there are provisions in different enactments ensuring institutional mediation, and those are the provisions contained in Hindu Marriage Act, then MSME Act, Consumer Protection Act, Commercial Courts Act, CPC. All those enactments provide for an institutional mediation. Sometimes they are resorted to, sometimes the judges manning the courts, they don't resort to, they are hesitant to resort to at the beginning, and it happens so most of the time because the litigants are also hesitant in going for mediation at the threshold. Unless it's a commercial dispute where the parties have their own financial and commercial stakes, the other parties in the traditional litigation, they, because of problem of ego, they don't resort to mediation at the threshold. After spending some time in the litigation, maybe 6 months, year, 1.5 years, they reconcile that it is better to go for mediation and settle the dispute and live in peace. And with this peace word, I am reminded of the focus on peace mediation rather than procedural and other mediation and commercial mediation. When we say commercial mediation or any other mediation, contrasting to peace mediation, when you buy peace through mediation in the litigation, and even before the litigation begins, if the peace can be bought without resorting to litigation, with peace you grow. If the parties adopt mediation and adopt peace, then they grow in a better way in their own field, whether be it a dispute of title or be it a dispute of commercial nature or be it a dispute of marital relationship. So the point is that peace mediation includes every kind of mediation. And as we have been telling it, that mediation is always for peace, like it is said in Ramayana or Mahabharata, and you see the other religious texts, including Buddhism, Bible, and Quran, all have preached dialogues for settlement of disputes. The mediation has been there since time immemorial, and the need for institutionalization of mediation is much more required, and rather it is inevitable today. The kind of pressure of litigation we are facing, mediation is one such area which will reduce litigation and bring prosperity to the warring parties to achieve their goals in life, in every walks of life. One of the most focused area of building an institution is capacity building. We have to build capacity. I am just giving the bullet points. Capacity building is the most important area to build an institution we have to train the mediators in huge numbers, because as in the earlier session, one honorable speaker was saying that 65% of the India's population lives in rural areas. So this mediation is not only for rich and prosperous people, it should be brought to the ground level. It should be made available to the man in the villages. So we may consider building this capacity building and institutionalization to be brought to the district level or to the block level or to the panchayat level, where trained mediators would be available in due course to provide the required facilitation for the parties and somebody who is there to convince the parties at the grassroots level to curb the litigation even before it begins. So that should be the idea and spirit, to build an institution of mediation. Institutionalization will come after we build an institution called mediation. That is how we will proceed, and time is less. I will request the speakers to please cooperate and finish up as early as possible. I will request first Justice Bhansali, and Mr. Justice Sachdeva would wrap up in the last after the other speakers would finish.
Thank you, sir. Respected chair, co-chair, all the participants on the dais and in the audience. The theme of the session is development of institutional mediation. Now, we start with what institutional mediation means. It can be described as a process where parties agree to use an institution with established mediation centers and specialized mediators to resolve their commercial or other disputes. The Mediation Act 2023 facilitates such mediation by establishing the Mediation Council of India, promoting community mediation and online mediation, and by providing for the enforcement of mediated settlement agreements. Now, why institutional mediation? What are the advantages of having a institutional mediation? The institutional mediation makes a shift from the ad hoc mediation towards institutional framework to bring standardization, accountability, and neutrality. The problem of uneven quality, lack of accountability, lack of accreditation, and absence of regulatory oversight is taken care of. The Act of 2023 in India explicitly envisages institutional mediation and a regulatory body, Mediation Council of India, to oversee the institutional mediation. The institutional mediation would further lead to faster resolution, consistency in process, greater trust from parties, and reducing the burden on the courts. The Act provides for the statutory provisions for institutional mediation under Chapter 8 and 9, with Mediation Council of India, mediation service providers, and mediation institutions, their registration, recognition, and related regulatory powers, their duties, functions, guidelines, regulation, registration, suspension, cancellation, etc. is taken care of. The regulations pertaining to their working is required to be made by the Mediation Council of India pertaining to qualification, assessment, accreditation, suspension, cancellation, etc. under the Act. Now, the role of Mediation Council of India is primary under the Act of 2023 for the purpose of making happen the institutional mediation. The mandate and the functions which have been indicated under section 38 pertains to framing the regulations, standards, guidelines for professional and ethical conduct of mediators, service providers, and mediation institutes, recognize, renew, withdraw the recognition of mediation service providers and mediation institutes, maintain an electronic depository, registry of mediated settlement agreements subject to confidentiality safeguards, monitor compliance, audit, review of MSPs and mediators, report annually to the central government on implementation of the Act, promote mediation domestically and internationally, the awareness, outreach, training, research, and the best practices. Now, the challenges and practicalities of the working of the Mediation Council. The first and foremost is establishing the Mediation Council itself. Now, recently, when I was searching for it, I read it somewhere. Recently, the law minister in one of the speeches said that it is at an advanced stage of constitution. Then its staffing, governance, its independence, funding of the Mediation Council, which may require infrastructure, systems, and human capital, ensuring legitimacy by involving the stakeholders, that is the judiciary, mediation community, and user parties in its governance and standard setting, avoiding over-regulation or over-bureaucratization, striking balance between oversight and flexibility, take care of conflict of interest, shielding political interference, ensuring autonomy. The most important thing would be transitioning the existing institutions and mediators into the MCI regime without disruption, handling complaints, appeals, reviews, discipline by the adjudicatory arm or overseas committee which may be required, ensuring data protection, confidentiality of registry, preventing misuse of the settlement data, international cooperation and alignment would also be required. What would be required also would be to standardize the standards for the mediators and service providers for whom the core ethical and professional standards would be impartiality and neutrality, no bias, no predisposition, must disclose if there is any conflict which is provided in the Act itself. They must be independent, should maintain confidentiality, there should be self-determination by the parties. The mediator should not coerce or impose terms. There should be competence and continuous training for the mediators. They should follow due process and have procedural fairness, ensuring parties have a chance to be heard, understood, and there should be a meaningful participation. There should be transparency in the fees to be charged, costs which are to be borne by the parties. the record keeping and documentation also would be a very important thing, wherein the confidentiality will have to be maintained. The performance evolution of the mediators from time to time, that will also enhance their quality. And what would also be required is to have the standards for the service providers, like what infrastructure would be required from them, having secretarial support, neutrality of the administration, selection, rotation of the panel, conflict systems, process, rules, transparency, complaint mechanism, etc. So the sum and substance, or the bottom line of the entire issue is that first and foremost is that the MCI should come into being, and the regulations for its working, they have to be framed, which will be the bedrock on which the institutional mediation can thereafter proceed. Thank you.
Thank you, Justice Bhansali, and I especially thank Justice Prashant Kumar Mishra for his rather pragmatic and insightful comments. With this, we now go to the next participant, Honorable Justice Guhanathan Narendra, Chief Justice, High Court of Uttarakhand, to share his views on the theme for this session.
Honorable Chair, dignitaries on the dais and off the dais, ladies and gentlemen. My brother, Chief Justice Arun Bhansali has done a complete overview of the Act, leaving no scope for me delving into it. So I'll just take off on a slightly different path. Mediation is rudimentary and as primitive as civilization. Especially in our culture, in the backdrop of the joint families that we witnessed earlier, any dispute between siblings or between in-laws, you had the others stepping in, the other elders in the family stepping in and mediating. Even as on today, we find the husband mediating between the mother and the wife, between the father and the children, to bring about peace at home. So initially this mediation, if you see the objective, in earlier times the objective was peace. Was some of the two of the earliest and most celebrated events of mediation, as His Lordship Justice J.K. Maheshwari was mentioning, was the attempt by Angad and his Lord Krishna. If we look at the timing of that attempt, when both parties were at the doorstep of war, yet the parties thought of mediation even at that critical time. And what made that attempt possible was the stature of the parties who were proposed for undertaking the mediation. I refer to this with reference to the quality and the standard of mediators that we need to create. The stature of a mediator is very relevant, because if the mediator and the stature is known, it draws away the initial hurdle of mistrust in the parties. The mediator is an unknown quantity, and the parties reposing trust in him would not be a short-term affair. So if persons of stature, and how do we create persons of stature? We must profile them and we must place this profile in public domain. And people today with the access to information technology, it would help in them knowing about the mediator, and that would help them to repost trust in the mediator, and when trust is reposed, we can expect quick and easy resolutions. With regard to institutionalization, yes, there is no, I don't think there can be a second opinion. It is the onerous task which the state will have to take up upon itself. Without the state's helping hand and aid, I don't think it would be possible to create infrastructure. And infrastructure has to be from the district levels. Person speaking the local dialect, an arbitrator speaking the local dialect, an arbitrator who is a local and fluent in the local language and the practices will be more successful in convincing the parties to think of an alternative rather than sticking on to litigation and trying to achieve the objectives through litigation itself. But at the same time, when speaking of standardization, should standardization be taken to such an extent where it could lead to rigidity? Can standardization of accreditation standards or qualifications, can they lead to stereotyping? I think flexibility in approach and flexibility in assessing the parties is crucial for mediation to be a success. If we allow rigidity to enter the process in the form of standardizing qualifications or practices, probably we may again be going the arbitration way. And the mediators may make an effort, but asking for accountability would in my opinion be a little placing a little more burden on the mediator. The main attraction of mediation is the freedom, is the latitude that the parties get with regard to the process, with regard to the person. And if somewhere down the line we are going to say, no, it is A who will do it or B who will do it, probably then it may, especially in cases involving personal relationship like matrimonial cases or partition cases. I think if the system is going to impose somebody, probably there may be some resistance and it may be a little more time consuming. And if it is left to their choice, if the mediator is a person of their choice, there is every possibility that the process can quicken. There are several techniques of mediation, and person should not only not only be a good mind reader, he should also be a good counselor. Unless he can assess and second guess the parties, and he cannot be a step ahead of the parties before him. In view of the time constraint, I would like to, with the permission of the chair, I'll close my presentation. And I thank the organizers for having given me this opportunity, this wonderful opportunity to be part of this wonderful occasion. Thank you.
Thank you, Justice Guhanathan Narendra, for your engaging comments on today's theme. With this, we will move on to our next participant, Honorable Justice Sujit Narayan Prasad, Judge, High Court of Jharkhand.
Thanks to the chair, co-chair, and all the panelists, my esteemed sister and brother judges, Honorable Mr. Justice Sanjay Karol, the Judge, Supreme Court of India, the Chief Justices of Bombay High Court, Gujarat High Court, and the Madras High Court, all the participants, a very good evening to everyone. That we are discussing about the institutionalization of the mediation, issue of mediation. We know that mediation, we have talked about the Ramayana era, the Mahabharata era, the Vedic era, known as the Panch Parameswar. The Parameswar have been said by the people of the Panchas due to have the faith upon the Panchas. The faith is the cornerstone of the mediation. The trust upon the person who is functioning as a mediator for the settlement of the dispute. Now, for the first time in 1989, the CPC, the section 89 has been, the formal institutionalization of the system of mediation has been taken note by the parliamentarian, but it was still to be institutionalized. Now, the Mediation Act has come in 2023. The Mediation Council has been proposed to be constituted in view of the provision of section 31 thereof. But still it has not been given effect to. The Government of India is working upon it. But the question is that this can be a challenge, but whether on the basis of that challenge we can tie our hand, that is the thing to be deliberated upon today on this issue. Because we all know that the mediators are working under the guidance of MCPC. MCPC is working under the auspices of NALSA, and on the basis of instruction of the NALSA, the SALSAs, and on the basis of the instruction of SALSA, the DALSAs are working to have a chain of the system of mediation also, in addition to the settlement of the dispute through the Lok Adalats, the state level and the national level. So, during the intervening period, until the date of establishment of the Mediation Council of India as a regulatory body, that we have to take care of through this system, which we are carrying out under the control of the judicial system in the administrative side. The development depends upon the regulation of the body. In absence of regulation, there cannot be a development. So, regulatory body is required, but we cannot wait that so long as the Government of India will not come out with the regulatory body, the system is to give him go by. We are having the State Legal Services Authority, the district level services authority, and we are appointing the mediators also, giving training of 40 hours on the auspices of the MCPC, guided by the instruction of the NALSA. So, we have to take care of till the Mediation Council is being instituted by the notification to be issued by the Government of India. Because mediation, if we will wait for the establishment of the Medical Council of India, then what will happen to the statutory mandate as contained under section 89 of the CPC? and the faith of the people and the overburdening of the courts of the pending litigation. And moreover, if the issue will be settled through mediation, then certainly that there will be no appeal, there will be no further appeal to the apex body, that is the Honorable Apex Court. So by that, a faith will come upon the people, will be in a position to have that trust upon the people, and the people will have that through mediation also the settlement is possible. Then question is how the trust will come. The trust is on the scrutiny of the appointment of the mediators on the basis of their integrity, on the basis of their expertise on subject, and moreover working without any vice of malice and showing any opinion, by having impression upon the litigants that the mediator is having idea to support one of the party. So that my opinion would be that so long as the central government is coming with the Mediation Council of India, we are having with the system, through this also, through the also, we have to look into. And I must say that as a executive chairman of the State Legal Services Authority in the state of Jharkhand, that I have tried to engage the mediator on the basis of their absolute integrity, and integrity cannot be tested in one day, that I understand. But I used to review the functioning of the mediator periodically by getting report regarding the proceeding of mediation, whether it is unnecessary adjournment and how many adjournment, why the adjournment has been given, whether the parties are appearing or not. Being conscious with the fact that the depanelment of the mediator is not permissible. So orally I have instructed that if such is the attitude of the mediators, then don't give any proceeding to any matter to the mediator at least for a period of 3 months, so that they have an idea in their mind that if they will do, then they will not be given any matter for the purpose of mediation. And that I personally got the result, and I have got the data that up to the month of August 2025, cases referred was 26,040, and through mediation the number of settled dispute was 9,652. And the special drive, total identified matter was 52,406. Referred number of cases was 11,382. Successful 3,814. Unsettled 2,987. And still pending 4,288. So the figure of the successful mediation was 33.51%, unsettled 26.26%, and the pending litigation is 37.6%. So I will not take much time. That can be a challenge for us, that the mediation council is not there, infrastructure is not there, but you have to work, and we have to introspect that how on the available system and the situation how to work. So with these words, I am extremely thankful to the organizer in giving me opportunity to address on the issue, and I understand that it is a very sensitive issue for the purpose of softening the litigation and settling the issue at the stage of pre-litigation itself. Thank you very much.
Thank you, Justice Prasad, for showing us a real-world application of institutional mediation. We now move on to Honorable Justice M.I. Arun, Judge, High Court of Karnataka, for sharing his thoughts on institutional mediation.
Honorable Chair, dignitaries on the dais, off the dais, ladies and gentlemen. Why institutional mediation? Why does it matter? Now, we have the concept of mediation with us, but to make it an effective tool for dispute resolution, we need to have institutions. If we do not have institutions, we cannot implement the concept of mediation properly. Now, these institutions, they ensure credibility. I mean, properly if it is structured, definitely they can ensure credibility, neutrality, and fairness in the mediation proceedings. and then it can provide for infrastructure and train mediators, and it can see to it that settlement agreements that are reached in mediation are legally enforceable. Even that's a very important concept which has been discussed from morning today. Now, coming to the institutions, I mean, there are other legislations apart from the Mediation Act where we have, where they do envisage mediations and institutions to deal with mediations. But I should say the Mediation Act 2023 is a fantastic piece of legislation. Kudos to the Parliament which has passed this and enacted it. It really puts India on the global stage. Now, if we look at this Mediation Act, though of course not all provisions are notified, it does envisage firstly creation of Mediation Council of India. It's a central statutory body created under the Act. Now, what are its key duties? Firstly, regulating and oversight of mediation ecosystem. That's very important. Next, it registers mediators. It seeks to register mediators, recognize mediation service providers and mediation institutions. Then it envisages to lay down standards for mediator training, certification, continuous education, which is very essential. Just like advocates and even for judges, we say continuous legal education is essential. It is essential for mediators also. MCA can do it. Then to determine manner of mediation, proceedings, registration of mediated settlement agreements, then promote domestic and international mediation and awareness building. Then after this Mediation Council of India, the Act also envisages to establish mediation service providers. Now, these may include bodies or organizations. It can be private or public, which are recognized by Mediation Council of India, authorities constituted under the Legal Services Authorities Act, then court-annexed mediation centers also, and any other bodies which can be notified by the central government, which is very key for implementing the concept of mediation in India. Now, this particular MSP, that mediation service providers, they can accredit mediators, maintain and manage a panel of mediators, which is very essential. Everything is not possible to be done by MCI. It has to do its, that ecosystem that is created has to be implemented through these MSPs. Then it can provide facilities, infrastructure, secretarial assistance, etc. for conducting mediation. Then it can promote ethical and professional conduct among mediators. It is very essential. Then it can facilitate registration of mediated settlement agreements. Now, all these things are possible only if MSPs function properly, and establishment of this particular institution as envisaged under the Mediation Act is very important. Then we have mediation institutes that are envisaged under the Act, and these are bodies recognized by the Council to perform functions like training, continuous education, and certification of mediators. And it will provide those things, and it will only supplement the purpose for which MSPs are established. Then last but not the least, we have this court-annexed mediation centers, that is legal services authorities and other authorities, which are already functioning, and they have been instrumental in seeing to it that mediation is promoted in India. Now, mediation, dear friends, is something that can resolve the dispute finally, without any problem. There won't be any animosity between the parties as opposed to adversarial system. Now, much has been said about mediation being very ancient. Yes, it is very ancient. From Ramayana, Mahabharata, it has been quoted. Now, I thought being in Odisha, in the land of Kharvela, I need to bring out certain other fact also. You have this Udaygiri and Kandagiri caves just outside Bhubaneswar. He was an ardent devotee of Bhagavan Mahavir, and there was a concept called Anekantavad. Now, The absolute truth can be realized by an enlightened soul. That is what is said over there. For an ordinary human beings, we realize the real truth. We can resolve a dispute only when we hear all points of view. Now, this may not be completely possible in an adversarial system, but this is possible in mediation. Many a times a litigation is filed with a particular prayer, but that will not be the real objective. The real objective will be something else. That can be realized and understood in mediation, where the parties can open up and all views to the dispute can be brought forth, so that there is a permanent settlement. Well, it's already late in the day. I don't want to take much time. Thank you, one and all.
Thank you, Honorable Justice M.I. Arun, for showing us the core action areas, I believe, for the future. We now move on to the team of government lawyers on the panel. I start with Mr. Arun Kumar, Advocate General, State of Meghalaya, to share his thoughts on the theme.
Thank you, Chairman. Dignitaries on the dais, dignitaries of the dais. I am at the fag end of this session and my iPad battery is also going down, so I will be as brief as possible. The idea of community mediation, which Justice Ashutosh Kumar highlighted, Justice Kosi highlighted, and certain examples have been cited of the countries in San Francisco and other parts. Since I come from the Northeast and I come from Meghalaya, we have this community mediation in practice as on today, and it has been since time immemorial also. For example, in Khasis settle their disputes in most of their family, land and other petty disputes at the level of Darbar Sunaw. Similarly, we have the institution like Nokma for Garo tribe in the state of Meghalaya, so we do not see too many disputes coming to the courts or formal structure, because they settle their dispute through mediation at those levels. Learned Attorney General before the session reminded me that they are the real stakeholders and they should also be heard and seen in August gathering, that those practices which are being followed in Northeast, especially in Meghalaya and Mizoram, where elderly councils decide the matters. There are some aberrations which they do in practice, but by and large, the practices followed in mediation by these communities have been helpful to the state. And in this context, what we have to notice is that now Section 2H of the Act talks about the community mediation. Now, when we go for community mediation and formal structure, under Chapter 10, if I am not wrong, Chapter 10, the issue is whether mediations which are carried out by these institutions will get recognized under the new Act or not. So we need to ponder, we need to see and at least recognize the best practices which we have in northeastern parts of India. That is one aspect of the matter. Second aspect is the question of how do we strengthen our institutions, how do we strengthen them. Because what the Act is doing is making, as previous speaker has pointed out, that it is formalizing the institutional mediation by recognizing mediation service providers and mediation institute. And therefore, the purpose of institutionalization is to create trained mediators, inculcate better ethics, predictable panels and infrastructure and ease. These are the measures which we are required to adopt and do it, and we have some example in arbitration. I can cite one example of Delhi International Council, which is very DCI, if I'm not wrong, that we have, and they have set the standards. So once we have this Mediation Council of India and the best practices are followed, including the practices which are being followed by Singapore International Arbitration, we may see the day where most of the disputes are getting resolved through the mediation process. At the same time, the purpose of this mediation is, one is saying that to ease the burden of the court, but it is quick, fair and enforceable. That is the beauty of the new Act. And in my opinion, in very short submission, the path to success is we have to establish the institutional credibility, integration with culture and Indian perspective, trust building, and access and outreach. If we follow all these measures, I am hopeful that the mediation will be successful, and it is the idea of the day, and as Victor Hugo said, nothing is more powerful than the idea whose time has come. And in my opinion, idea is idea of mediation to way forward in our journey to access truth and justice. With these few words, with the permission of Chair, I conclude.
Thank you, Mr. Amit Kumar, for sharing your experience from the Northeast. We now move on to Mr. Anil Singh, Additional Solicitor General, High Court of Maharashtra.
Co-chair, dignitaries on the dais, off the dais, ladies and gentlemen. Since yesterday we have been discussing on a main issue that the lawyers will play a very important role in success of mediation. Unless the lawyers, the Bar Association, the Bar Council of the State Bar Council and the Bar Council of India, they support mediation program, the program or the movement of mediation won't be successful. This reminds me, way back in 2010, when I was a chairman of the Bar Council of Maharashtra and Goa, we had a conference on mediation. Justice Ravindran, the then Supreme Court judge who was in charge of all mediation program then, he had visited Maharashtra. And then he was narrating a story. He told us that he was watching a TV program and the channel had a very interesting topic. The topic was, are we afraid of courts and lawyers? Surprisingly, each and every participant present in the program answered, yes, we are afraid of courts and lawyers. In our democratic setup, if such type of impression is gathered by the ordinary people, by the common man, it's really a dangerous setup, dangerous trend. Then we were told at that time, I'm talking about 2010-11, when the mediation movement was at its initial stages, that 40 to 50% of potential litigants, they are not approaching court. The reasons given are all usual reasons which we know: delay, cumbersome procedure, heavy cost of litigation, and all those infrastructure, then cumbersome procedure, all those reasons were given. And then on the discussion, it came to us, to our notice, that the best solution would be the alternate dispute resolution mechanism, and that is by mediation. Slowly and gradually we have made a lot of progress in mediation. Now the government has, since last 10-12 years, has taken a lot of initiative in mediation, and mediation program has been becoming successful day by day. But still, I must tell you that when somebody told in the morning and yesterday also, that this has to be inculcated since beginning when you are either joining the profession or when you are studying as a law student. Otherwise, as a law student, you are not aware of what is this mediation program, how mediation takes place, and if a client comes to you, you can also suggest a via media of mediation, especially junior lawyers, and it is our experience in Maharashtra that when we were conducting mediation programs in Maharashtra, some junior lawyers, they used to come in the program, they used to say that you are all senior lawyers practicing since last so many years, you have learned a lot. हमारा तो भी कमाने का दिन, अगर हम मैटर छोड़ देंगे तो कैसे चलेगा mediation? So this is what the impression was gathered, and therefore we require to educate those lawyers, the junior lawyers, and tell them that, see, you are benefited ultimately. If your client gets a result immediately, if the matter gets settled, you can charge more fees, you can get more matters, people will have more confidence in the system. So this is what needs to be told to the junior lawyers, to the young lawyers, and even to the law student. And therefore, I fully agree that this has to be inculcated right from the beginning. So whether you go for institutional mediation or ad hoc mediation, success of mediation will certainly depend upon the legal fraternity, the lawyers, because 95% of the litigants or a common man who goes to a lawyer, he will rely or he will trust what the lawyer says, and accordingly he will act upon. Now, coming to the point of institutional mediation. Now, we all know, and it has been already spoken by my previous speakers, so I will not repeat it. The theme has been, the theme of the session, that is development of institutional mediation, is a subject that is fast becoming final, fast becoming central, and and will be the future to dispute resolution mechanism. Several institutions are developed providing structured mediation and recognized as credible and effective alternate to litigation. Private mediation centers have been developed and has been increasing day by day. There are a lot of mediation centers private in Maharashtra, in Mumbai, in Pune, in Nagpur, and we are all taking advantage of all those institutions. Though we had some provisions earlier of mediation in Industrial Dispute Act, we had Lok Adalat, mediation under the Arbitration and Conciliation Act, Family Court Act 1984, Commercial Court Act 2015. The Supreme Court emphasized the need of dedicated legal framework for mediation in India, recommending enactment of Mediation Act as a stand-alone act and establishment of Mediation Council to regulate training and ethical standard. This was in the case of M.R. Krishnamurthy, and thereafter the act has come into force now. We all know that the preamble of the act states that it is an act to promote and facilitate mediation, especially institutional mediation. Therefore, the emphasis is on institutional mediation, which will include pre-litigation mediation, online mediation, and community mediation also. Several advantages of mediation has been already spoken. We have seen the credibility, because the parties trust the process when it is backed by a recognized institution. Neutral and trained mediators we have in the institution, confidentiality and enforceability of settlement agreement. The proceedings are more streamlined, which avoids unnecessary delay. It's more accessible, and it is available to the ordinary citizen. It preserves relationship and fosters cooperation, provides all facilities, assistance, infrastructure, logistic, and other administrative support. So this is how we have a lot of advantage of mediation, and one of the most important benefit of mediation institution is because if you go to a mediation institution, it avoids a lot of wastage of time by having agreement ready in hand. When institution is mentioned, parties are bound by the mediation rules like venue, language, fees, time frame, etc. And therefore the process is more effective, less burdensome, and also cost effective, and the parties are bound by that. We have been told about the importance of mediation council. Once it comes in force, certainly it will be helpful in the entire progress of mediation. Justice Arun has already stated, I will not repeat it. And therefore we are all aware that how mediation has been successfully progressing day by day, and certainly this program and this seminar which we have held today and conferences like this will help in future also for the progress of mediation. And one of the most important things is that when you go to a mediation center or institution, you get a specialized team who are working. They are expert in their field, as it was already mentioned in the morning, that when you are practicing in a family court or you know the family dispute, you can't resolve, or if you don't know commercial dispute, it is very difficult to handle such situation and settle the matter, or to draw or to draft a document of settlement. And therefore, it is always preferable that you have an expert team, and this is always available when you have an institution. So that is a benefit of institutional mediation. I will just give one illustration, one illustration, and then I'll close. One of my junior who is practicing with me, he said that when he was studying in US and when he was doing his masters, he had visited the small causes court in a city of America. When when the matter was going on in court, the matter was being argued. Suppose the court had called the first matter, and 10 or 15 litigants are waiting for their matter. The court had trained mediators, and that court had tie-up with some institutional mediation center. And that mediator, he was sitting in the court or in the next room attached to the court. The litigants were requested that if you want to settle your matter till your matter is called out, because otherwise also you are waiting for a matter, why don't you try and get your matter settled through a mediator if it is possible? Otherwise, we will not adjourn the matter, we will go on with our matter. I am told that there has been successful result of such suggestion which was working well in the court. I can suggest here also that even in courts also, if we have a tie-up with some mediation centers who are recognized and are well reputed, then we can have trained mediators even in the court. And because we know that in our court, we have on board large number of matters in the court, there are many matters listed. It is not possible that every matter reaches on the same day. We have sufficient time. At that time, we can suggest the litigants who are in the court, especially in the district courts, that why don't you try and go for settlement, because the mediator is available here. And if it is not settled, the matter can be taken up without adjourning the matter and without wasting time. So this is one suggestion which I am giving as far as the mediation institution and working of mediation is concerned. Thank you very much.
Thank you, Mr. Anil Singh, for sharing your lucid thoughts on the subject. I now move on to Mr. S.D. Sanjay, Additional Solicitor General, Supreme Court of India.
I presume that I am the last panelist in this whole session. Everyone must be very tired, so I will be very brief. Honorable the Chairman, distinguished judges on the dais and off the dais, I only want to add few words, although everything has been said in the whole day deliberation. One thing I want to point out, right from the morning we have been discussing two important events in the past. One was of Ramayana, another was of Mahabharata, where attempt for mediation was made, but it failed. But then I want to remind that one of the most important historical event of modern India was our independence. We achieved this independence by mediation. And the starting point was calling of Mahatma Gandhi in round table conference in England. And thereafter, continuous effort was made. Finally, it led to our independence. So this is one of the successful example of mediation in the history. Now, therefore, we are deliberating here for future, and we have to look back what were the problems which has been faced by this robust system, how we have to make it a robust system. I have few suggestions to make. This act has come in 2023, but even before this act, there has been effort of mediation. Now the first thing is to identify the areas in which it can be successful. Nowadays, I find that courts are being flooded with the matrimonial disputes. Even the Supreme Court, every day we see before every court, the cases of family disputes, matrimonial discord are coming either by way of
transfer petitions or otherwise, and people are bringing it to expedite solution of this dispute, because when the matter goes to the family court, it takes 5 years or more than 5 years in the settlement of dispute. But when the matter comes to Supreme Court in this way or that way, in exercise of power under Article 142, it is granted, but before that, the Honorable Supreme Court grant opportunity to go in mediation. In similar fashion, the matter goes to the High Court, but then power under Article 142 is not available to the High Court. So therefore, the cases are coming. So first things to make this institutional mediation system to be more effective and robust, we have to identify the areas. Now once the areas like family disputes are there, then lot of civil matters like partition in the family are going in the court. They can be resolved through mediation. So from the ground level, it has to be improved. Now first thing we have to do is, now the government has taken initiative and 2023 Act has come into force. Now this mediation has to be put in the curriculum of these students, in the schools, in the law colleges, that this has to be encouraged. Now I say not only the role of lawyers, the role of honorable judges also become very important, because people have lot of faith in the system. So if it comes from them, they have to believe it, and they believe that, and then their trust enhances that yes, when it is coming from the judges, like in the High Court or Supreme Court, when the matter is referred to mediation, then they say all right. And then thereafter the negotiation starts for this system. So we have to put it in the curriculum of students, so that like any other system, like Contract Act, constitutional laws, one subject should be introduced as mediation, in which the training should be started from that level only in the colleges, in the law colleges, and thereafter during the training of the lawyers. And then like there are law assistants in the High Courts and Supreme Court, in similar manner, in order to make it effective and robust, that there should be training for them as a law assistants. Now it has to be made remunerative. Now like when in the law college the student goes, now he starts thinking in 3 ways. One is to become a litigation lawyer. Second is to become a judicial officer. Third is nowadays to go in corporate law, to join a company to do transactional business. Now similarly, now they have to think, they have to make it as a career. Now if it becomes remunerative, then they think to opt it as a career. And once it becomes that, now in our sessions, before this session, there were trained mediators. So they think of making their career in that field. Now so far as the law is concerned, it will take some time to develop, because every law when it comes, like even Arbitration Act, when it came initially, it was not developed that much. Now it is only past 20 years there has been development in arbitration, and nowadays after 2015 amendment, it has taken the pace. Similarly, this mediation will also take time, and such type of deliberation really help in this making it further robust, and virtually this makes the people aware, apart from everybody, to go for this system. And I am quite positive and optimist that even the government is going to take decisions soon. Our Attorney General is sitting here, our Minister will also be there. So I think whatever deliberation has been done today in the morning session till now, they have taken note of it, and we as a law officer of the Government of India, we are also going to push it up to take it as a robust mechanism, not only to reduce the pendency of the cases in the courts, but also to give fullest satisfaction to the litigants, because this is the only mode through which they don't feel, it's a win-win situation and don't feel at a loss. I will not take much time, and I thank
all of the organizers here, particularly Sri Acharya, Learned Advocate General, Odisha, for giving me this opportunity and organizing such a wonderful symposium on this subject. Thank you, sir.
Thank you, Mr. Sanjay, for your incisive and clear views on the subject. With this, we move on to the last speaker for this theme, Honorable Justice Sanjeev Sachdeva.
Thank you very much. Honorable Chair, Justice Mishra, dignitaries on the dais, off the dais, and all of you sitting there, coming in as the 43rd speaker for the day. With all of you still so attentive, shows the success of this conference. And the credit really goes to the Learned Advocate General, Mr. Pitambar Acharya. Now, talking about success stories, I'd like to share two success stories, one about Delhi and another about Madhya Pradesh. I was a trained mediator, I was a lawyer, then I became a trained mediator in Delhi, then I became a judge. So I have worn all the three hats, as it was discussed in the earlier session, that you have to change hats when you're a mediator. The Delhi High Court Mediation Conciliation Center, which we call as Samadhan, started on 24th September 2005. It was one of the first centers which were court annex centers which were set up in mediation. There was a lot of protest from the bar at that time. There were strikes which went on for several days. The judges who set up the center were adamant, no, it is going to be successful, because they had got experience from abroad where it was very successful. So lawyers protested, bar went on strike, but then they were convinced to come on board, they were forced to come on board, and they did. This center became successful for the sole reason that it is lawyer-run center. It was not run by judges. Judges convinced them, look, you come on board, and slowly the lawyers realized that it has it is very, very successful. I'd like to share some numbers. 42,536 cases have been referred to this center by the Delhi High Court, Supreme Court, and other high courts. 13,179 cases have been settled, with about 9,983 connected cases. These are not current figures, these are figures of last month. Now, these figures are only of the High Court Mediation Center. District Court figures run in lakhs in Delhi. The settlement rate in commercial cases in the Delhi High Court Samadhan is about 60 to 65%, with overall success rate of about 54%. And success rate of cases under Section 12 of the Commercial Courts Act is about 22%. That also is a very tremendous number. Parties are approaching the Center for Pre-Litigation Mediation, where the success rate is about 35%. And similar success rate is also of the Supreme Court Mediation Center, which is also run by lawyers. So this goes on to show that if institutional mediation is set up and run by lawyers, it can really be successful. You see, when you have judges running institutions, it's very difficult. Because when you're a trained judge, you become very judgmental. Every case you look at is from the point of view of deciding who's right, who's wrong. And that is exactly contrary to the concept of mediation. So my suggestion to the government and the stakeholders, that when you're setting up the council, when you're setting up centers or court annexed mediation centers or these institutions, please ensure that they are predominantly run by lawyers. Madhya Pradesh has another success story. It has a success story of community mediation. Community mediation was attempted in Indore, and today it is conducted by retired academicians, bureaucrats, senior citizens, respectable members of the community. There are about 100 community trained mediators who are there. They have settled scores of cases. Every day they hold sessions, to an extent that the police commissioner in Indore gave up part of his office to set up a community mediation center there. So every day trained mediators, non-lawyers, community mediators go there, they settle disputes which are pre-FIR registered cases. Parties come together, of course, serious cases don't go there. Some disputes between parking issue, neighbor disputes, fight between brothers, they go there and they are settled. Success rate is pretty high. Now, the Chair, Justice Mishra, talked about capacity building, taking it to the villages. Now, how are these centers successful? How was it achieved? How did the Supreme Court and the High Court Mediation Center achieve it? First of all, like I said, lawyer-driven. The first thing that you have to do is identify advocates who can become mediators. Everybody is not cut out to become a judge. Everybody is not cut out to become a mediator. So you have to identify them. Give them extensive training. Inculcate the feeling of dedication to serve. Because we know, as lawyers, we would earn a substantial amount in the time that we spend. But mediators pro bono would work for hours and hours, days and days, session after session, and then even face a failure. But their dedication to the cause is immense, and that is something which we have to inculcate. Now, what are the skills that are needed to be inculcated in a mediator? Once you set up these centers, once you set up these institutes, one of the roles in the Act is train them. But what do you need to train them? You don't need to train them in law. You have to train them in negotiating skills. They have to know about different approaches to negotiation. How can they be used in parties in mediation to an effect that they have become a problem solver? Then they have to be trained in trust building. A mediator has to gain the trust of the parties. He is not deciding, he is making the parties come together. So another skill that is to be trained in is trust building. Neutrality maintaining. The mediator has to be neutral. Parties should not even have a single feeling that, look, this mediator is taking sides. So he has to be trained, he or she has to be trained into give an impression that I am completely neutral. The mediator has to be trained in facilitating the process, controlling the mediation process. We've seen cases where parties come into mediation, tempers rise, and the entire mediation process fails. So mediator has to know how to control the parties, because sometimes after years of litigation, when parties come there, they have been pushed to a corner, pushed to a stage where they are not in a position to even share the space with the opposite party. That is where the mediator's role comes in. That is where he has to gain the trust, ensure that he is controlling the parties. And the biggest skill that a mediator must have is listening and communicating. As lawyers, as judges, we only focus on the legal aspects. We are not ready to listen. But a mediator has to listen. And why listening skill is very important is sometimes you will realize that there are undercurrents, which parties themselves don't even know what is the undercurrent. It has to be a collaborative problem-solving skill. Now, when I learned my mediation, some of my trainers are here who taught me mediation. There was a problem that they were talking about, a dispute with two companies fighting over oranges. That's an example which is always used in mediation training. They were fighting over oranges, and the mediators were given that problem that try and solve this issue. The simplest solution was divide the oranges half and half. That's the easiest way. We say, all right, split it into two. But the mediator would go deeper and found out that one wanted to make orange juice, the other wanted the marmalade. So one needed the pulp, one needed the skin of the orange. And both had a 100% success rate. Similar, I like to share disputes, some instances where I've had my training in mediation helped me. There was a partition dispute in Madhya Pradesh of brothers which came up before me. Now, there was no dispute on the share of the parties, it was a partition suit. So I told the parties, I said, all right, one of the brothers had a 22% share, the other side was 78%. There were three brothers on one side and one on the other. So I told the brother who had 22% share, I said, why don't you propose the value of the property? The others will choose. If they feel the value you are proposing is high, they'll sell you the property. If they feel it's low, they'll buy share of. So he said, I think the property is worth about 4 to 5 crores. The other brother said, no, 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 it is worth about 10 crores. So I told the other side, I said, are you willing to put money where your mouth is? They said, yes, we stand by our offer of 10 crores. So I told the one who had 22%, I said, you were getting about 1.1 crore. Now they're offering you 2.2. Are you willing to buy or sell? He says, I'll sell my share. That dispute which was on for 25 years got settled in minutes. So there are several stories. Now the mediator also has to learn on reading the undercurrents. Now sometimes there are undercurrents in a dispute. I remember a dispute in Delhi High Court which I was handling. There were two Sikh brothers who came before me. They had longed on, they were aged, senior citizens, aged in court, and I looked at them and I asked both of them. I said, where do you come from? They said they come from a place called Karol Bagh. Karol Bagh is a place where I was born in Delhi. So, and knowing them, they looked very pious. So I said, where was your father taking you when you were kids? Which Gurdwara was he taking you? They said, so-and-so Gurdwara in Karol Bagh. So this was at about 11 in the morning, that dispute had come up before me. So I said, do one thing. Both of you just go to that Gurdwara, sit there, listen to Kirtan, come back after lunch. So they both went. But I said, please don't discuss about the case. Just go there and sit there and listen to Kirtan for an hour or so and come back. They came back at 2:30 and the dispute was resolved. They really had no dispute. It was just ego. Similar instance I came across was a custody dispute again in Delhi High Court, where the wife had custody of the child who was 5 years old and father had visitation rights. So wife was a teacher in a school and she had an opportunity to go to Germany for higher education. And she said the moment I go for higher education, she was going for about 3 years, and the husband was opposing it. He says, for 3 years I will not have visitation on my child. So I am opposing it. They were fighting tooth and nail. So the wife said, look, I get this opportunity to go there to study. I don't want to deprive him. And once I come back, I'll get a jump, I'll get a boost, I'll become a principal in a school. But if he's so adamant, I will give it up. So I had asked the husband, what did he do? He says he works for an MNC and he was working from home. So I said, where did you both meet? So they both said, we studied in Germany together. So I asked the husband, is it possible for you to go to Germany to meet the child? He says, I can even shift to Germany for the 3-year period. So today they are living together as a family in Germany. So these are success stories which happen. You see, I always say mediation is not a vocation or a training, it's a lifestyle. Training in mediation helps one change as a person. I have changed as an individual once I underwent this training, and that training has helped me as a judge as well. So in conclusion, I would say that lawyers have to be on the forefront of mediation movement. I always say this and I would reiterate this. They bring an added dimension to the mediation of litigated cases in terms of their experience with the trial process, their knowledge of law, because without lawyers, we would not be able to draw up a mediation settlement. They practice at working things out with the opposing counsel, with the parties through negotiation. Whether a lawyer is acting as a mediator or lawyer is appearing in a mediation process, their role is very important. So we can't separate lawyers from the mediation movement at all. They have to be part of it, they have to be in the forefront. An enhanced understanding of mediation process with legal training and experience will help us achieve the goal, will help us achieve the purpose of the Mediation Act, and also transform the lawyers from gladiators to mediators. Thank you very much.
Thank you, Justice Sachdeva, for very interesting perspectives on the topic. I now circle back to Honorable Justice Prashant Kumar Mishra to close the session.
Now I will not take another 5 minutes to wrap up the session. The only message which, the one-liner which I could gather from Justice Sachdeva is, mediation has to be made a lifestyle. Lifestyle of justice delivery system, lifestyle of pre-justice delivery system and pre-litigation system. And in the beginning, I could not mention Honorable the Law Minister of Odisha, who is here, and Justice Karol was also there, and Mr. Pitambar Acharya, he is restless, going in and out when this valedictory function will begin, and he is not listening to us as also. Anyway, we wrap up this session, and it was a wonderful 2-day conference on this mediation. The next conference will be in Meghalaya, as promised by the Advocate General of Meghalaya, and hoping to see you all in Meghalaya. And thank you, the organizers, Honorable Law Minister, Mr. Prithviraj, and the Advocate General, and all other sitting over here. Thank you so much.
Now, may I please request Sri Manoj Ahuja, Chief Secretary of Odisha, to felicitate the esteemed dignitaries on the dais. Shri Dharmender Pradhan, Shri Dharmender Pradhan, Honorable Minister of Education, Government of India. Honorable Sri Justice M.M. Sundres, Judge, Supreme Court of India. Honorable Sri Justice Sanjay Karol, Judge, Supreme Court of India. Honorable Sri Justice Ahsanuddin Amanullah, Judge, Supreme Court of India. Shri Arjun Ram Meghwal, Honorable Minister of State, Ministry of Law and Justice, Government of India. Honorable Sri Justice Harish Tandon, Chief Justice, Odisha High Court. Honorable Sri Justice Sangam Kumar Sahu, Judge, Odisha High Court. Honorable Justice Shri Krishna Ram Mahapatra, Judge, Odisha High Court. Honorable Dr. Justice Sanjeev Kumar Panigrahi, Judge, Odisha High Court. Now, thank you so much, sir.
I request Chief Secretary to take the chair.
Now, I request Shri Manoj Ahuja, Chief Secretary of Odisha, to please take over the chair. Thank you so much, sir. Now I request Shri Pitambar Acharya, Learned Advocate General of Odisha, to preside over the valedictory section.
इन जो सरकार जो बुलाएंगे ना सर जो सर एक एजेंडा
Good evening. I now welcome Honorable Sri Justice K.R. Mahapatra, Judge, Orissa High Court, to give the welcome address.
Namaskar and a very good evening. Honorable Sri Dharmendra Pradhan ji, the Minister of Education, Government of India. Honorable Sri M.M. Sundaresh, Judge Supreme Court of India. Honorable Mr. Justice Sanjay Karol, Judge Supreme Court of India. Honorable Justice Asauddin Amanullah, Judge Supreme Court of India. Honorable Judges of the Supreme Court of India gracing the occasion. Honorable Sri Arjun Ram Meghwal, Minister of State, Ministry of Law and Justice, Government of India. Honorable Sri Harish Tandon, my Chief Justice, High Court of Odisha. Honorable Chief Justices and Honorable Judges of High Court who are present in this occasion. My esteemed sister and brother judges of the Odisha High Court and other different high courts of the country. Sri Tushar Mehta, Learned Solicitor General of India, Learned Additional Solicitor Generals, Sri Pitambar Acharya, Learned Advocate General, Odisha, Learned Advocate Generals of different states, Learned President and Office Bearers of the Odisha High Court Bar Association, respected senior advocates, mediators and academicians, officers of the Registry of the High Court of Odisha, learned judicial officers present, distinguished members of the bar, members of print and electronic media, ladies and gentlemen. It is my solemn privilege to welcome the honorable dignitaries, distinguished guests, and esteemed participants of the valedictory session of the second National Mediation Conference 2025 that marks the conclusion of what has been a phenomenally enriching experience in the technical sessions. It was indeed a historic occasion in the chronicle of High Court of Odisha and legal landscape of the state of Odisha. Distinguished dignitaries from far and near gathered to contribute to this conference to make it such a grand success. Time flew through the indulging discussions and debates over so many sessions. Each session was enlightening and thought-provoking. As we reach the conclusion of the conference, I am honored to welcome you all to the valedictory session. The conference has been a vital step in deepening our collective understanding and role of mediation in justice delivery system. We feel particularly honored and gratified by the presence of Honorable Chief Justice of India, Honorable Judges of the Supreme Court of India, the Honorable Union Minister of Education, Honorable Minister of State, Minister of Law and Justice, Honorable Government of India. I extend my heartfelt welcome to all the dignitaries for their kind presence in this occasion. It is my proud privilege to welcome the Honorable Chief Justices and Honorable Judges of the High Courts whose contribution has made the technical sessions of the conference so meaningful. We are grateful for your participation, sirs. The contribution of senior mediators and mediators are also immensely enriched the discussions. I also extend a cordial, affectionate welcome to the learned Solicitor General of India, learned Advocate General of Odisha, and Mr. Venkat Ramani, the Attorney General of India. Distinguished members of the bar who are present with us on this occasion. The technical sessions on challenges, way forward, enhancement of mediation ecosystem, mediation in state litigation, commercial mediation, and institutional mediation witnessed some truly engaging discussions and discourses widening the horizon of mediation's landscape in our country. Thanks to the erudite inputs shared by the participating judges and legal professionals, I am sure this conference has given all of us to make a take back with us and reflect upon the covered those reflections into positive action. Once again, I extend my hearty welcome to all the dignitaries and esteemed participants and respected members of the audience to this valedictory session. Wish you a wonderful evening, ladies and gentlemen. Thank you. Namaskar.
Thank you, sir, for your insightful words. Now I request Shri Pitambar Acharya, Learned Advocate General, sir, to felicitate Shri Tushar Mehta, Solicitor General of India. Now I request Advocate General Sir of Odisha to kindly preside over the session.
Thank you and good evening to all of you. It's one of the most distinguished audiences I have ever seen in my life. On behalf of State of Odisha, the Department of Law, and on behalf of my Chief Minister and my office, I once again welcome you all to the holy soil of Lord Jagannath. Now may I request the Learned Solicitor General of India, Sri Tushar Mehta, to deliver his address.
Good evening to all of you, the honorable dignitaries on the dais and dignitaries of the dais. We have already crossed our time limit and you have been attending and hearing everyone with captive attention. Anything further by me at least will only mean that I am treating you as a captive audience also. We have yet to hear good words, wise words and words of wisdom from honorable judges, Dharmendra ji, the honorable law minister, etc. So I will not take much time. The government has taken mediation very seriously, which is reflected from the fact that in 2024, now there is a proposed Commercial Court Amendment Act, which permits even an interim order to be passed. Because the major difficulty which was found in operationalizing the mediation as a concept of dispute resolution mechanism was that in case of emergency there was no provision. Now, subject to the bill being passed with modification, without modification, but there would be a kind of mid-RB regime also, that is a fusion of mediation and arbitration. The government and the government law officers are committed, and we will do our best at our level to ensure that before we come and trouble the honorable judges, there is a mediation, and mediation is not only just an empty formality, but it is successfully implemented and effectively becomes an answer to a very major problem of courts clogging dockets. I am thankful to my dear friend Acharya Saab. He has done an excellently well thing. He has set a benchmark, and every other conference henceforth will have to meet this benchmark, which itself would be a very difficult task. I am thankful to the organizers, thankful to the government, and thankful to my learned friend, Mr. Acharya, for giving me this opportunity to be before you, such an august and learned audience. Thank you so much.
Now may I request Honorable Sri Justice Shangam Kumar Sahu, Judge, Orissa High Court, to deliver his address.
Jai Jagannath. Good evening to all. Honorable Justice M.M. Sandresh, Honorable Justice Sanjay Karol, Honorable Justice Ahsanuddin Amanullah, Honorable Judges of the Supreme Court, Sri Dharmendra Pradhan ji, Honorable Union Minister of Education, proud son of Odisha, Sri Arjun Ram Meghwal ji, Honorable Minister of State, Minister of Law and Justice, Government of India, my Chief Justice Harish Tandon ji, my esteemed brother Justice Krishnaram Mahapatra, Justice Sanjeev Kumar Panigrahi on the dais, Mr. Tushar Mehta ji, Learned Solicitor General of India, Mr. Pitambar Acharya, Learned Advocate General Odisha, Honorable Chief Justices and Honorable Judges of different states, Mr. R. Venkatramani, Learned Attorney General, sir, my sister and brother judges of High Court of Orissa, Mr. Prithviraj Harichandan ji, Honorable Minister, Law, Works and Excise, members of Registry, Orissa High Court, government officials of the state of Orissa, dignitaries from different parts of India, members of print and electronic media, ladies and gentlemen. आपण माने समस्ते आम मानकर निमंत्रण स्वीकार करी एही द्वितीय राष्ट्रीय मध्यस्थता समावेश रे एते संख्या रे जोग देइथिबारु मो तरफरु एवं ओडिशा हाईकोर्ट तरफरु आपण समस्तंकु धन्यवाद अर्पण करूछि. I thank all of you on my behalf and on behalf of Orissa High Court for accepting our invitation and coming here to join the second National Mediation Conference 2025 and participating in the conference. I know how much efforts have been put by our learned Advocate General under the able guidance of the Honorable Supreme Court judges and active cooperation of the Government of India and state government to arrange this program to make it successful. There were obstacles, but the learned Advocate General was of the firm view, and he was of that belief that the greater the obstacles, the more glory in overcoming you. Thank you, learned Advocate General. Whenever learned Advocate General used to meet me and discuss about this conference, and becoming a little apprehensive, I was telling him, you do your part, leave the rest to Lord Jagannath, and his blessings will be always there, and all the obstacles will go away. And you see the result. All of you know that the Mediation for the Nation campaign, which is a 90 days initiative launched by the NALSA and Supreme Court Mediation and Conciliation Project Committee to settle pending cases through mediation in different courts from 1st July to 30th September 2025, aiming to reduce the judicial burden and provide a people-friendly alternative dispute resolution method. The campaign involved identifying cases, referring them to mediators, and taking all necessary actions to facilitate amicable settlement. During such period, as per guidance and instruction of the Honorable Supreme Court in my High Court and 30 districts of my state, 14,206 cases were referred to mediation by 22/9/2025, and 2,744 cases were disposed of. These cases relates to matrimonial disputes, accident claims, check bounce cases, commercial dispute, service matter cases, consumer disputes, debt recovery cases, partition cases, and criminal compoundable offenses. Odisha State Legal Services Authority organized 5 numbers of 40 hours, which we called 5 days mediation training program in Odisha Judicial Academy, Regional Judicial Academy Ongul, and ADR Center Baleshwar. Chairpersons of permanent Lok Adalats, members of permanent Lok Adalats, advocate mediators of different districts participated in it. A referral judges training program on mediation was organized by the Odisha State Legal Services Authority through virtual mode for all the judicial officers and referral judges, including the secretaries of District Legal Services Authority of the state of Odisha. The master trainers of MCPC of the Honorable Supreme Court acted as the resource persons. In all the 30 districts, the referral judges training on mediation have been completed. People are now looking for early solution that can put an end to their difference so that they can move forward to seize new opportunity and not be held back due to pending disputes, non-clarity about their claims. It is here that this mediation, by offering simple, quick, and easy solution, becomes relevant. Mediation is built around a culture of give and take, and it creates an opportunity to arrive at a win-win formula. When a dispute is resolved through the mediation process, there is no winner or loser as the parties agree to a solution, whereas in litigation, there is always a loser. This is the positive outcome. Mediation avoids hostility and offers an opportunity to restore trust between the parties. Most importantly, as compared to court procedures, considerable time and money is saved in the mediation procedures. There is no dispute that the government is the biggest litigant, and there could be a system by which mediation could be effectively used for settling the dispute where government and its agencies are party. Some innovative thinking on this aspect is necessary. Father of Nation believed in mediation as a powerful tool for resolving dispute, seeing it as application of his core principle of ahimsa, satya, and sarvodaya. Honorable Chief Minister Odisha yesterday laid emphasis on mediation connecting to the broader goal of social justice, especially for the poor and needy who seek to redress grievances through the court. I just give you something that during my justice 12 matrimonial appeal cases in which decrees of divorce were passed by the family courts were settled with much efforts by we the two judges. You can't believe the happiness, the tears of joy which we saw in the eyes of those parties. The family reunion gave immense satisfaction. Today, right from 10 a.m. on different themes, interactive sessions were held and important discussions on various aspects of mediation were made. I'm sure the purpose of organizing this National Mediation Conference has been fulfilled. The conference will be highly beneficial not only to the participant but also for our state and to the entire nation, and we must utilize whatever we have learnt so that access to justice for all, in particularly to the poorer sections, be achieved in its fullest extent. Thank you. Jai Hind, Bande Utkal Janani.
May I now request my Chief Justice, the person who is the principal motivator, philosopher, guide, and has never grumbled for anything which I have suggested during the last 2-month-long preparation for this conclave. I request His Lordship, the Honorable Chief Justice of Orissa High Court, Sri Justice Harish Tandon, to deliver his address.
The distinguished guests on the dais and off the dais, the friends and ladies and gentlemen, though it was a commitment by the Advocate General that because of the paucity of the time, and then we have already crossed the this time slot which was allotted, so I will not be speaking for the occasion. But I do not know. I have been ordained to do this exercise, so I have come before you. We have been going through the different technical sessions throughout the day on a diverse topics, on a diverse the subject or the lapse, the gaps, the challenges which the mediation would face or have faced which we experience while going through the mediation process, whether it is the court annexed mediation or it is the pre-litigation mediations. And the erudite speakers have already highlighted those aspects of the mediations, which is definitely food for thought, and we take home a lot of stuff to introspect, to ponder upon, and how to give an impetus to this particular process of mediations. I have one suggestions, because we all talk about the pre-litigation mediations when the dispute cropped up, and a court annexed mediations when the dispute has already arrived to the court. Why not we can also think of a mediation when the dispute is yet to be cropped up at a nebulous stage, and the parties should be encouraged to go for a mediations. When the dispute has not really has a reason, but likely to arise in future. We also talk about the MEDAR, which is also a concept. The Singapore concept is the ARB-MED. We can make another hybrid of MED, ARB, and MED, that the arbitrators should also be, sensitized to send the parties, even if they have undergone the pre-mediation, litigation mediations, or pre-arbitration mediations. So this is how the capacity buildings, how to improve the mediation, the drive, these are all have been talked about. And I hope that all of you have enjoyed the whole day, the sessions. And hope that this session would continue in a third phase. I believe the third national conference, mediation conference, going to be held in the state of Meghalaya. And I wish and congratulate the organizers there that they will definitely keep the same momentum which we have set a tone in this particular program. Thank you. Jai Hind.
Thank you, Your Lordship. Now I request Sri Arjun Ram Meghwal, the Honorable Union Minister of Law and Justice, Government of India, to deliver his address.
सेकेंड नेशनल मीडिएशन कॉन्फ्रेंस 2025 के वैलिडिक्टरी सेशन में आप सब उपस्थित को सबको नमस्कार करते हुए जय जगन्नाथ। वो तो बोल ही सकते हो आप, जय जगन्नाथ। वेरी गुड, थैंक यू। इस अवसर पर उपस्थित हमारे मध्य ऑनरेबल श्री धर्मेंद्र प्रधान जी, यूनियन मिनिस्टर ऑफ एजुकेशन, हमारे ऑनरेबल जस्टिस MM सुंदरेश जी, जज सुप्रीम कोर्ट ऑफ इंडिया, ऑनरेबल जस्टिस संजय करोल जी, जज सुप्रीम कोर्ट ऑफ इंडिया, ऑनरेबल जस्टिस असुद्दीन अमानुल जी, जज सुप्रीम कोर्ट ऑफ इंडिया। अभी आपके समक्ष बोल के गए जस्टिस हरीश टंडन जी, ऑनरेबल चीफ जस्टिस ऑफ उड़ीसा हाई कोर्ट, हमारे तुषार मेहता साहब, सॉलिसिटर जनरल ऑफ इंडिया, हमारे जस्टिस संगम कुमार साहू जी, और हमारे जस्टिस संजीव कुमार पाणीग्रह जी, और एडवोकेट जनरल उड़ीसा श्री पीताम्बर आचार्य जी, हमारे चीफ सेक्रेटरी मनोज आहूजा जी, और हमारे बीच में उपस्थित एडवोकेट अटॉर्नी जनरल ऑफ इंडिया वेंकट रमणी जी, पिंकी आनंद जी, हमारी लॉ सेक्रेटरी भी बैठी है। अभी मुझे ज़्यादा इसमें नहीं बोलना, ये एज है ADR की। ADR का मतलब अल्टरनेट डिस्प्यूट रिजोल्यूशन मैकेनिज्म। इस पे हमारे प्रधानमंत्री जी नरेंद्र मोदी जी ने बहुत जोर दिया है और ये कहा है कि कोर्ट में जो केसेस पेंडिंग है उनका अगर भार कम करना है तो हमें एडीआर को अपनाना ही पड़ेगा। और एडीआर में 3 चीज़ें आती हैं, आर्बिट्रेशन, मीडिएशन और कंसिलिएशन, और तीनों पे ही जोर है। इसलिए जब वेंकट रमन जी ने फर्स्ट नेशनल मीडिएशन कॉन्फ्रेंस दिल्ली में की थी, तब भी ये तय हो गया था कि इसको सेकंड भी करना है, और अभी मुझे यहाँ प्रसन्नता हुई कि थर्ड भी तय हो गया। कहाँ करना है? शिलोंग में। ताली बजाना तो जोर से बजा दीजिए थोड़ा शिलोंग के लिए। लेकिन उड़ीसा की जो ये सेकंड मीडिएशन कॉन्फ्रेंस 2025 हुई है, मैं और धर्मेंद्र प्रधान साहब, बाकी और भी ऑनरेबल जजेज यहाँ 4 बजे के आसपास आ गए थे वैलिडिक्टरी सेशन के लिए। लेकिन 4 बजे से जो सुन रहे हैं वो सुन रहे हैं कि इतने चीफ जस्टिस ऑफ डिफरेंट हाई कोर्ट के लोग आए, जजेज आए, सुप्रीम कोर्ट के जजेज आए, इतने तो किसी कॉन्फ्रेंस में आए ही नहीं। इसलिए जो आयोजक है उनके लिए बहुत बहुत बधाई और शुभकामनाएं। और चिंतन मनन मंथन भी बहुत जोरदार हुआ है। अभी हमें करना क्या है कि जो हमारे अटॉर्नी जनरल ऑफ इंडिया बैठे हैं, ये जो तय करेंगे कि चिंतन मनन मंथन में यहाँ क्या क्या चीज़ें हैं जिन पे हमें काम करना है। तो एक तो चीज़ आप बताएंगे, फिर हमारी लॉ सेक्रेटरी भी बैठी है अंजू राठी राणा, हम आपस में जल्दी मीटिंग कर लेंगे। मैं ज़्यादा समय लूँ आपका, उसकी बजाय मैं चाहता हूँ कि अपन एक डेट तय करें कि इन 2 दिनों में यहाँ जो भुवनेश्वर में आपने चिंतन मनन मंथन किया और हमें क्या करना है, वो अगर आप तय करेंगे तो मेरा काम आसान हो जाएगा और जल्दी हम निर्णय कर पाएंगे। बाकी चीज़ें टेक्निकल सेशन में सारी आ गई है, इसलिए मुझे लगता है कि मैं समय ज़्यादा नहीं लूँ आपको। बाकी आपके समझ में आया हुआ है ना सारा? आ गया कि नहीं आया? अभी कुछ समझाना है क्या? नहीं समझाना है ना? तो क्या करना है? लेकिन आ गया, ये पीछे से कोई बोला आ गया, लेकिन फिर भी आने के बाद भी दुष्यंत कुमार ये कहता है कि कब तक अपन ये कॉन्फ्रेंस और इसमें उलझते रहेंगे, कुछ ना कुछ तो ठोस करना ही पड़ेगा ना। हो गई है पीर बरबसी, पिघलनी चाहिए, और इस हिमालय से कोई गंगा निकलनी चाहिए। आग मेरे सीने में नहीं, तेरे सीने में सही, जहां कहीं हो आग, लेकिन आग लगनी चाहिए। सिर्फ हंगामा खड़ा करना मेरा मकसद नहीं है। मेरी कोशिश है कि मीडिएशन की सूरत बदलनी चाहिए, मीडिएशन की सूरत बदलनी चाहिए। बहुत बहुत आभार, धन्यवाद।
Odisha has a special connection with Bihar, the Patna High Court. Before Odisha High Court was established in 1948 by a latest patent, our lawyers were going to practice in Patna. So most of my earlier seniors, they had their place of practice in Patna. Fortunately, the next speaker amongst us, Honorable Sri Justice Asauddin Amanullah, hails from Patna, which was our parent High Court. May I request His Lordship, Justice Amanullah, to deliver His Lordship's address.
Very good evening. Thank you, Mr. Pitambar. I could see the confusion with Mr. Meghwal trying to abridge the speech, how to put it together. He was just shuffling his pages. So I think, yes, rightly, there has been some serious deliberation and everything must have gone. But to give a solemn end, I think little bit of formality too is required. I've got just few points to share. It's a takeaway. I know everything has been deliberated, but yes. And sorry, I'm not taking the risk of individually referring to all the dignitaries on the dais and off the dais, because all of you are known to me and I'm not very good at names. So I don't want to have the risk of missing somebody out. So everybody, hearty welcome. I'm really privileged to be amongst the valedictory session
of the second national mediation organized at Bhubaneswar, Odisha. On a lighter note, I am happy to be the penultimate speaker, and I can gladly say that I concur with all that my preceding speeches have said, alluded to. I am also looking forward to the valedictory addressed by Justice Sundaresh, and as such my endeavor will be to the point. Help and not fight, assimilation and no destruction, harmony and peace and not dissension. These were prescient words of Swami Vivekananda. Looked at deeper, one can see pointer towards mediated resolution of conflicts. The Indian civilizational ethos has encouraged and embraced dialogue, reconciliation, community-based resolution, and consensus building. From the old panchayat system to informal village council and sabha, the idea of resolving disputes consensually rather than by way of coercion has been rooted in the Indian society and psyche. With the advent of the Mediation Act 2023, Parliament has aimed to further reinforce the rooting and principles in the statute. Dialogue and deliberation from the heart and the mediative process, litigation mostly leaves a winning party and a losing party. But mediation possesses the capacity to let all the people to a list walk away with a greater degree of satisfaction. It can also restore ties and bonds, especially when the parties involved are related to each other. It would not be improper to refer to mediation also in the context of the growing case docket. If alternate dispute resolution ADR mechanisms including arbitration, mediation and conciliation succeed, a direct impact would be witnessed on case pendency figures. I may also put it on record that when the judiciary encourages mediated settlement, it is not shying away from performing its core duty, that of adjudicating disputes. The focus of the judges when referring parties to mediation is to bring about a lasting resolution, however, without a building up of acrimony or hostility. Increased adoption of ADR mechanisms would enable the courts to focus on adjudicating disputes which actually require consideration. Indicating illustratively, intra-family disputes, especially those concerning partition or division of assets, etc., are in my view inherently capable of being resolved through mediation. Further, the choice of mediators should be in the first instance left to the parties alone. If and when a court is called upon to make the choice, due regard must be had to the nature of the dispute and the attendant circumstances, and the mediator should be someone well conversant with the subject matter involved. Yeoman service has been rendered in training mediators by the Supreme Court's Mediation and Conciliation Project Committee, and these trained mediators have gone on to train others in the respective high courts. Mediation offers benefits to the litigants. It cuts down delays, reduces expenses, frees them from adherence to rigorous evidentiary procedures, and directly offers them a voice in the resolution process with the assistance of lawyers if so needed. Mediation is voluntary, non-adversarial, flexible, and fully respectful of the party autonomy. The mediator is not an adjudicator, but a facilitator, an intermediary, if you will, in bringing about a meeting of mind and offering a closure such that not only the referred dispute is nipped in the bud, but the door gets shut to future litigations that may have arisen if the dispute was allowed to be festered. Chris Voss has opined, negotiation is not an act of battle, it is a process of discovery. The goal is to uncover as much information as possible. As I can conceive of it, the road ahead lies primarily on 4 C's: culture, credibility, capacity, and courts. When I speak of culture, it means we judges, lawyers must foster a mindset where parties see mediation not as a sign of weakness, but as a symbol of wisdom. Lawyers must see it not as a threat to advocacy, but as an extension of it. Judges must not see it as an abdication of duty, but as an aid to resolution. When I mention capacity, I refer to the pressing need for still more trained mediators, not legal professionals, but also professionals from diverse fields who understand the nature of negotiation, psychology, business, and of course, human behavior. When I talk about credibility, I emphasize the need for the mediative process to exhibit transparency, accountability, accessibility, and affordability. Without these, no good initiative can come to fruition. When I refer to courts, I urge judges to adopt a balanced approach in referring cases, genuine matters, where judges feel or parties urge unanimously that a resolution of settlement is possible, only must then be referred to mediation. If the dispute in the eye of the referring judge is not one capable of mutual resolution, he or she would be well within his rights or her rights to refuse such reference. Further, if the judge is of the opinion that the plea seeking reference to mediation has only been made a dilatory tactic, mediation should not be permitted. That apart, the court should also refer, after reference, play only a supporting role and monitor only the outcome and not the process thereof. The court must first call upon the parties, and then initially they should convince them to go for mediation, as experience has shown that it gives greater chances of the success. Sensitization programs are needed for both judges and lawyers. This training can also extend to law schools and law universities, perhaps at a one-term subject. I hope the Bar Council of India takes the lead in formulating this, which would go a huge way in equipping fresh law graduates with basic mediation and negotiation skills. This would also help them in litigation and dealing with clients. Most of the court-annexed mediation centers are doing very well and have successful settlement rates upward of 50 to 60%. Thus, government and court administrations need to provide relevant budgetary support, and the necessary infrastructure has also trained staff and allied personnel. Mediation is no longer just an adjunct, but a vital cog of the justice dispensation system. It has been tailored to recognize and act for the human element, which sometimes can get lost in the dust and sweat of litigation. Let us also remind ourselves in the legal profession that we too exist to serve the public trust and uphold the public faith. While our indigenous systems has served well, it would do no harm to study and adopt best practices from across the world, including but not limited to from the Singapore International Mediation Center, the United Kingdom Civil Mediation Council, as also Canada's P3 Dispute Resolution Framework. The Union government has brought in reform with an eye to bettering the ease of doing business in India. I think every public sector unit take the lead in adopting a pre-mediation stance, especially for lower value disputes. To begin with, depending on the results, a call can be taken to widen the net in the issue in the times to come. The sessions over the course of the day have been fruitful, and I am left with no doubt that there is food for thought to ponder over the mediation as a concept, is what it entails, and further what steps need to be taken now and in the near future to ensure the system works. While litigation restores rights, mediation can restore and rekindle relationships. On a parting note, one should always remember that even the father of the nation, Mahatma Gandhi, was a strong votary of the mediation process, albeit in a somewhat different manner than what we see currently in operation. I also recall the Mahatma's talisman, in times of need or dilemma, recall the face of the poorest and weakest man whom you have seen, and ask yourself if the step you contemplate is going to be of any use to him. I am sanguine that by the time we meet again for the 3rd National Mediation Conference, we will have an occasion to turn back and see where the journey started, from the distance we have covered and the journey that lies ahead. To sum up, Max Lucado had commented, conflict is inevitable, but combat is optional. I convey my thanks to the organizers, especially the Learned Advocate General and the Department of Law, Government of Odisha. Thank you, Jai Hind.
Thank you, my lord. Now, there is a story. My Lord Justice Sanjay Karol, though his lordship was initially given consent, but due to some family preoccupations, his lordship expressed his inability. But I must admire his lordship's magnanimity to give me a call day before, that even though my name has not been printed in the invitation card, but I would like to attend such a distinguished gathering. We are humbled and bow down before his lordship. Now I call Honorable Mr. Justice Sri Sanjay Karol to give his lordship's address.
On the dais, my esteemed colleague, Justice Sundaresh, Justice Amanullah, Minister for Education, Shri Dharmendra Pradhanji, Minister for Law and Justice, Shri Arjun Ram Meghwalji, Chief Justice, Orissa High Court, and judges, the High Court of Orissa, Learned Solicitor General, Shri Tushar Mehtaji, Chief Secretary. In the audience, we have the Attorney General, we have the Advocate Generals, we have the Chief Justices, ladies and gentlemen. A very good evening to all of you. I shall be as brief as the Learned Solicitor General was. To begin with, a big round of applause to the Learned Advocate General who has made this conference a great success, and to his office. Advocate General, you take me back to the year 1999. Same sitting, but different place.
Right.
I was sitting there in 1999 in my capacity as the Advocate General of the state of Himachal Pradesh. Same conference we had in Simla. And today in 2025, we are here sitting in this great town, Bhubaneswar. What has changed since then is this which I wish to speak on. We had 25 states, then today we have 28 states. We had a population of 103 crores. Today we have 146 crores. The urban population was 27%, rural population was 73%. Today it is 35% is urban or more, and rural is 65%. Litigation at that point in time, overall pendency was 2 crores. Today it is more than 5 crores. Our times were such at that time when the assertion of rights were measured. and the understanding of legal entitlements were circumscribed. People did not know much about their rights. In the last one decade, the legal services movement has grown immensely. We have, as judges, stepped out of our courtrooms and reached out to the people. I'm sure 26 years down the line, the litigation is going to increase. There's no doubt about it. Because the marginalized ones, the have-not ones, have now been made aware of their rights, their duties. The avenues are more, and they are becoming all the more vigilant with each passing day. Therefore, how do we deal with this problem of popularly known as docket explosion, or docket inclusion, I would say that. And the only way is, pardon me if I exceed in saying so, is that we have to, from my personal experience I'm saying, step down from the dais, reach out to the people, understand them, understand their language, understand their problem, and find solutions at the grassroots level. And that can be done, in my considered view, is only if, as has been said by the Honorable Minister, that we have to find solutions in a concerted and a meaningful way. The only way we can wipe out the tears of the teeming millions of this country, citizens of this country, is just to see how best, rather than penning our judgments, we reach out to them and solve their problems and bring peace, happiness in the society. I must also say this. Brother Amanullah mentioned about Vivekananda. I must share this with the audience that our guest here, the Central Minister, also has read and likes Vivekananda. He and I both have tangible relationship with Himachal Pradesh, where I come from. Only thing is that Vivekananda, in Uttarakhand, when he went to Kasar Devi, he was told to come and serve the people. Now, when Mr. Pradhan went to Himachal Pradesh, he was also asked to serve the people of this great nation. And he has been, I must say proudly, serving the people of this great nation. Thank you very much, Minister. I would also say this, that we have 15 Chief Justices here. We have about 44 judges who have come from different states, and we have 12 Advocate Generals. Each one of us have to find solutions at the local level rather than waiting for the result of these conferences. I'm sure with the passage of time, you shall go home, ponder, contemplate, and find a way for having the disputes resolution mechanism enforced with greater success, vigor, and emphasis. Thank you very much, all of you, please.
Now may I request one of the senior most cabinet ministers of Modi government, a friend, philosopher and guide to me all through, and more than a family, Sri Dharmendra Pradhan ji, to deliver his address.
Honorable Justice, Supreme Court of India, Mr. M.M. Sundaresh ji, Honorable Justice Sasuddin Amanullah ji, Honorable Justice Sanjay Karol ji, my colleague Sri Arjun Ram Meghwal, Union Minister of Law and Justice, Honorable Chief Justice of Odisha High Court, Justice Harish Tandon ji, Justice Sangam Kumar Sahu ji, Justice Krishna Ram Mahapatra ji, Justice Sanjeev Kumar Panigrahi ji, Solicitor General of India, Mr. Tushar Mehta ji, Attorney General of India, Honorable Venkat Ramani ji, Law Minister of Odisha State, Sri Prithviraj Harichandan ji, Advocate General of Odisha, my elder brother Sri Pitambar Acharya ji, Chief Secretary of Odisha, Mr. Manoj Ahuja ji, esteemed dignitaries, respected members of judiciary and legal fraternity, distinguished guests and ladies and gentlemen. Judiciary is more patient than our political ecosystem. If you will address a meeting at this time of the 2 days conference, when I entered the room after waiting 3 hours, again I go back and I again come back, I asked my dear friend Mr. Acharya, anybody is there? He said, you come and see. I am thankful to all of you. You all are here to listen, honorable justices and honorable guests. Friends, I welcome all of you, my state Odisha. For which reason you have chosen Odisha as a place of this mediation second conference, but I am fortunate to tell you few things. This land is itself a land of mediation. You all might have visited Lord Jagannath Puri Mandir. In Puri Mandir there is a concept Patita Pavan. There is a Patita Pavan Vigraha not in the sanctum of the temple, in the just outside of the temple, gate of the temple. There is a story behind that. That is to my learning as a child, as a practice of Odisha civilization, practice in Odisha civilization, as a devotee of Lord Jagannath. Friends, there is a dispute between system and devotee. One devotee who is a non-Hindu, is a Muslim, his father was a Muslim Sipahi of the Mughal period, of the Puri king, and mother was a Hindu. The boy Salabeg was very devoted to Lord Jagannath. Every day he come to the Singhadwar in front of the gate in the Baradan, and he write many beautiful and devotional songs in the dedication of Lord Jagannath. Looking into that, the king did one of the first mediation, I think, to my understanding. The king facilitate a vigraha just outside the sanctum and put it in the gate and facilitate and create a mediation between Lord, the Supreme Lord, and devotees. You all are here in this holy land. I congratulate all of you. This 2 days deliberation will certainly create new pathway. There are 4 crores pending cases and the different level of courts. I hope this new initiative by judiciary and by government will certainly create new ease for the society. And you all are here in the Lord's place, the mediation's place. And in Odisha, another believe, Bhadraloki. Those who are from the eastern part of country, they know what is the concept of Bhadralok. In our society, Bhadralok's job is to do mediation. Mediation for local dispute, mediation for marriage, mediation for education, mediation for many things, for many disputes. And I welcome you in the land of Bhadralok. Friends, fortunately, coincidentally, I am in charge of education minister of country. Everybody has their own interest. I have my own interest to come here. I am thankful to my dear friend Pitambar Acharya ji. He invited me to this conference. I thought I should go to the Bhubaneswar conference to welcome all the legal illuminaries and dignitaries of the country in my native state. So I am here. But I have another motive behind to come here. NEP recommends multidisciplinary. NEP, National Education Policy 2020, recommends education through mother tongue. I am thankful to Indian judiciary. You all have consciously decided to adopt Indian language as court language in many states. I congratulate all of you. I pay respect for the great decision. I think, but according to my own understanding, how do we create a zero pendency of this 4 crore case? Corona created a new ecosystem, that online argument. I think using technology. Today is a Sunday, last Sunday of month of September. Prime Minister Narendra Modi, as usual, put his word through Mann Ki Baat to the countrymen. Friends, since last 2-3 Mann Ki Baat, there is a new things coming up. Using technology, using AI, the Prime Minister is communicating to countrymen in all the regional languages. All these things are recommended in the NEP. Mother tongue, technology amendment, these are the recommendations of NEP. Time is not far away where judiciary is already adopted technology in their arguments, in their deliberations. AI kind of tools can be embedded, can be used to deliver fair justice, for the to liquidate to the decline, to decrease the pendency of the cases. I urge to the Indian judiciary through this mediation conference, mother tongue based argument, mother tongue based judicial procedure and using technology, can we give more justice? And this is the real reason, this is the real cause of inspiration of justice. And you all are here to deliver, to discuss and deliberate all this important thing of mediation. And lastly, I can say, I seek your cooperation to suggest, because for me, mediation is part of the thought process. If you are a democrat person, if you are a cultured person, you don't go for dispute. Mediation is part of your day-to-day life. Mediation is the pathway for thriving things, for the bigger achievements. So can we create some modules for new sanskar, how people will not be becoming litigant? People will be democrat, people will be accommodative, people will be, and this mediation is not alternative dispute resolution mechanism. I think for me this is a real dispute resolution mechanism. So this two-day deliberation of Bhubaneswar is a grand success, and I expect from education sector more advice, more cooperation. How can we create a culture of mediation in society through education? Thank you, friends.
Before it concludes, Honorable Minister of Education, Government of India, Sri Dharmendra Pradhan ji, my Lord Honorable Justice Sri M. Sundaresh ji, my Lord Justice Sanjay Karol ji, my Lord Chief Justice Harish Tandon ji, the Union Law Minister Sri Arjun Ram Meghwal ji, Justice S.K. Sahu, Honorable Justice K.R. Mahapatra, Honorable Justice Dr. Sanjeev Panigrahi, the Learned Solicitor General of India Sri Tushar Mehta ji, the Chief Secretary of Odisha Sri Manoj Jahuja ji, and in my front, seated on the audience,
the main architect and the motivation behind all these conferences, my most respected learned Attorney General, Sri R. Venkat Ramaniji, who in fact started this initiative on 3rd of May 2025 in New Delhi and handed over the baton to me in the said conclave. I do not know how much I have been able to carry out the wishes of the central government, but this much I can candidly confess today, that the entire credit goes to the distinguished participants, those who have come from all corners of the country, and it is their generosity, not my endeavor, to make this conference a grand success. I will not take much time. We are already running behind the schedule. I cannot take individual names, but let me give a special thank to the Honorable Chief Minister of Odisha, Honorable Law Minister of Odisha, the Chief Secretary and his team, the DG of Police and the entire police force of the state, the Chief Administrator of Sri Jagannath Temple Administration, who has taken all the pain to remain personally present in Puri Jagannath Temple for safe darshan of Lord Sri Jagannath, to the Commerce and Transport Department, of course, his spouse, Usha Padhi, who has taken care of the entire transport of the dignitaries, and to all the government officers, those who have given their tireless effort to make this conclave a grand success. I will not take much time. I once again thank the Honorable Chief Justice of my High Court, my Honorable other judges, the Registry of the High Court, the law officers of Advocate General's Office, and the entire success story behind this conclave are 30 young girls, those who have been working with me as research associates in Cuttack office and Delhi office. Till 3 a.m. night, all of you would be surprised, they walk with a smile. When I was confused whom to take and whom not to take in the panel of discussion, I took the help of Honorable Justice Suryakant, and you will be surprised. From 10 p.m. till 1 a.m. morning in the night, 3 hours, we sat together. Mr. Nataraj was there, the Additional Solicitor General of India. We finalized those speaker lists. Many must have been left. My apologies to all of you. And once again, I cannot but offer my gratitude, a sense of gratitude to all of you, those who came here taking all the pain. Thanking you all. Once again, we wish to meet in Meghalaya. The Advocate General of Meghalaya has already given his consent to hold one such conference in Shillong. So see you in Shillong sometime in February or March. Thanking you all. Jai Jagannath. Now, I humbly invite the most humble, I repeat, thy name we should call is sobriety, humility, and greatness. My Lord Justice M.M. Sundaresh, who has all through been a great support and has guided me at every stage to make this conclave a success. My Lord Justice M.M. Sundaresh to deliver his keynote address.
I think I need a clap. I must tell you there are two reasons. As the Advocate General said, mine is a valedictory address, and therefore the day's hard work and agony is going to come to an end. Secondly, I'm going to make my speech very short. So this would make the audience happy. Honorable Sri Dharmendra Pradhan, Honorable Minister of Education, Government of India, my respectful brother, Sri Sanjay Karol, Sri Asuddin Amanullah, Honorable Sri Arjun Ram Mehwal, Minister for State, Honorable the Chief Justice of this great High Court, Sri Justice Sri Justice Harish Tandon, Honorable Justice Sangam Kumar Sahu, Honorable Justice Kursharam Mohapatra, Dr. Justice Sanjeev Kumar Panigrahi, learned Attorney General, learned Solicitor General, Chief Justice of various High Court, judges from the High Courts, distinguished invitees, and the last but not the least, my dear students. I can't say it's a good evening or good night. Where do we start the mediation? How did it emanate? I was just pondering in the morning. I believe mediation came into existence before human being. Why is it so? We can look at the world in two different ways. A world full of conflict, a world full of cooperation. A living being for his existence requires the help of others. Let us imagine few chicks in a nest craving for food from their mother. There may be a dominant chick among them, there may be a weak. But the mother makes sure that everyone has his own share. Mediation starts at an earlier date than what could possibly perceive. It's a way of life. It's a natural way of living. We see mediation at home. Fight happens between sister and brother, husband and wife. This great country believed in mediation. Now, it was said by the Honorable Minister about the huge pendency. When this country believed in mediation, it led to an orderly society. When an alien power took over and brought a system which is adversarial and procedural, it completely obliterated and killed mediation.
And that's the reason why we have 5 crores of cases today. With a sense of responsibility, I am telling you, the huge pendency of the cases involving various enactments along with the complicated procedure law has made the great institutions suffer. Therefore, we have to go back to our roots to bring back the old concept of mediation, which is part of our life. Yesterday, in the inaugural session, Honorable Minister for Law and Honorable Chief Minister were talking about mediation during ancient times. A reference was made to Mahabharata and Ramayana. I asked myself, what happened and why did it fail? Lord Krishna was an acclaimed speaker, a respectable speaker. Why did his mediation fail? In my view, mediation never fails. At times, the process might fail. It failed because of the lack of trust. While he was respected, but unfortunately he was not accepted. Duryodhan felt that he was a mere emissary from the other side. Now the failure was also due to the fact that good people surrounding him miserably failed to take part in the mediation. Be it his own brothers, aging father, his uncle, guru, grandfather and friend. Did all of them not fail in their duty to advise him? Was he not told about the effect of the failure? A mass destruction. I apply this to Ramayana also. Lord Hanumanji, some of you might know, is an extremely powerful speaker. He could speak according to the situation and according to the persons. His words would exhibit pearls of wisdom. And that is how he successfully completed an agreement between Lord Rama and Sugriva. However, when he was sent to Ravan, he changed himself. He was seething with anger that Ravan had clandestinely taken Goddess Sita with him. Perhaps the diplomacy we exhibited in clinching the deal earlier was missing. Secondly, as in the case of Duryodhana, all the wise men surrounding Ravan also did not adequately advise him. I only quote these examples to show that trust is the key. Unless the parties believe in the mediator, success would not be forthcoming. We are dealing with individuals. Convincing an individual is the most difficult task. We are dealing with individuals with utmost ego and desire. I am reminded of one little story. Tolstoy, one of the finest writers ever produced, went for a stroll in a park. While he was sitting in the park, a small girl of 5 years came running. So she asked him, "I'm alone, would you like to play with me?" Tolstoy looked at the young girl and said, "All right, I'll play with you." So they are playing with each other for nearly half an hour. Sun was setting. So the girl told him, "I would like to leave. My parents will be searching for me." So at that point of time, the gate man told the girl, "Tell your parents that you were playing with Tolstoy." He wanted to give a subtle message that the parents would tell the child that he was indeed lucky to have met and spent some time with a great thinker. Pat came the reply. The young kid told him, "When you go back, tell your people you played with Mary. That's me." To break this ego is a role which is required to be played by the mediator. Before I end, I would like to share my views on the new enactment. As the learned Solicitor General has said, it's a work in progress. All that I can tell the learned Advocate Attorney General and the Honorable Minister and the learned Solicitor General is that before you embark upon new amendments, kindly consult all the stakeholders, including the High Court, because they have a distinct role to play. So with these few words, I thank all the organizers, including the Advocate General, for giving this opportunity. Thank you very much.
We are deeply honored, my Lord. Actually, Honorable Minister, Justice Karol and the Learned Solicitor General, they have a flight. They have already shifted twice, thrice rescheduled. They have some important work. It is at 10:30, hardly 45 minutes left. So they have to immediately rush. So therefore, I would request Dr. Justice Panigrahi to give a brief and as precise as he can a vote of thanks.
Good evening.
Sri Dharmendra Pradhan ji, Honorable Union Minister for Education, Justice M.M. Sundaresh ji, Judge Supreme Court of India, Justice Sanjay Karol, Judge Supreme Court of India, Justice Asanuddin Amanullah, Judge Supreme Court of India, Justice Sri Arun Ram Meghwal ji, Honorable Minister for Law and Justice, Sri Venkatramani ji, Attorney General for India, Justice Harish Tandon, our Chief Justice, all the Justice, brother and sister justices present here, Sri Prithviraj Harichandan ji, Minister for Law, Government of Odisha, Sri Tushar Mehta ji, Learned Solicitor General of India, Sri Pitambar Acharya, Learned Advocate General of India, and all the Advocate Generals who are present here, who are from, they hail from different states, and the Chief Secretary of Government of Odisha and his team, Srimati Anju Rathi ji, Union Law Secretary, learned panelists and all the delegates, all the official protocol and print and electronic media. I am standing between you and your hunger, so I am trying to be as brief as possible. Therefore, thank you all for being here, and we sincerely apologize if there is any shortcomings on our part in hosting, and hope you will show a great heart. Bande Utkala Janani. Thank you.
Jai Jagannath. Thank you very much, Dr. Panigrahi, Justice Panigrahi, for understanding. And everything is well. If it goes well, the conclave conference stands concluded. Thank you very much.
Next, क्या?